end of the road there, or the top of the screen, what unit is involved in Exhibit 55, please?
Yes.
Please tell us.
Objection leading.
Overruled.
It is the dancing grannies that are approaching from the right.
Okay. And
Dancing grannies, lol.
one of the dancers, we have her testimony that was involved with the grannies was a woman by the name of Lola Hospital. Is that correct?
Objection leading.
Overruled. It's foundational. The witness may answer.
Yes, she was.
Is there video showing Miss Hospital being struck by the SUV?
Objection leading.
Sustained as to the form of the question. Please rephrase.
Sure. Is exhibit, you've seen Exhibit 55 before?
Yes, I have.
Are you able to identify Miss Hospital, I'm sorry, yes, Lola Hospital in Exhibit 55, sir?
Objection leading.
Overruled.
Yes, I am.
All right. We're going to play the clip, Your Honor, from from 4 seconds to 8 seconds at 50% speed, and it is zoomed in on the middle of the road where the dancing grannies are located.
All right, go ahead. Thank you.
Please describe for the jury what you just saw in the video, sir.
Objection leading.
Overruled.
I saw the red SUV driving westbound on Main Street, approaching the dancing grannies and hitting Lola Hospital and then striking 2 other dancing grannies.
When you say hitting,
I turn up the volume of the
Lola Hospital, what
video.
did you see?
Yes, I can.
Objection leading.
Overruled. You may answer.
I saw the left side of the car come in contact with her, and then her body moved to her left after.
Did Miss Hospital report any injuries to the Waukesha Police Department?
Objection leading.
Overruled. The witness may answer.
Yes, she did.
All right, sir. I'd like to now ask that Exhibit 118 be published for the jury. This has previously been admitted.
Permission granted.
Objection to the relevancy of 118.
It's previously been received. Go ahead.
Sir, do you recognize the item shown in Exhibit 118?
Yes, I do.
And in addition to the photograph, have you had an opportunity to examine that item or items
Objection leading.
personally?
Overruled. The witness may answer.
Yes, I have.
And Mr. Johnson from the crime lab testified about these items yesterday, but I'd like you to tell the jury what you remember of these items, please.
Objection leading.
That's not leading.
First
It's pretty open. What do you
Overruled. The
remember
witness
about
may
the
answer.
items? It's pretty open.
So this is the red SUV that was used in the parade attack. This is a picture of it taken after. I remember a hood from a white jacket and a hat, a black hat with snowflakes on it, being pressed in between the hood and the windshield wiper of the vehicle.
Objection to it being called an attack. I think that's a disparaging remark for the record.
Hey, that's lucid.
Your objection is noted, and the answer will stand. I will instruct the witness to simply describe what he is seeing without further characterizing it, as it will be up to the jury to determine the facts in this case. Go ahead.
Thank you.
That was a lucid objection.
When you saw these items on the hood of the red SUV,
Objection, characterization.
did you later come to
Hey,
recognize where they may have come from?
I have a sound for that somewhere.
The witness may answer.
Yes, I did.
What did you determine?
determined that they were the jacket, hood, and hat that Virginia Sorensen was wearing while she was walking in the parade.
Like to display to the witness only, please, Exhibit 177. This has not yet been received, Your Honor.
All right, go ahead, please.
He's learning.
Is 177 on your screen, sir?
Yes, it is.
And what do you see in Exhibit 177?
Objection leading.
Overruled.
I see two dancing grannies.
Maybe turn up the volume
wearing
even
a
more.
Walkie dancing granny sign.
I'll just turn down my own
And the woman
volume a
on the
little
left
bit.
is Virginia Sorensen, and she's wearing a black hat with
And
snowflakes, wearing a white jacket with a hood on it.
Move to admit 177 and permission to publish, Your Honor.
No, I'll turn up the volume. It's fine. I'll figure it out. I fucking
The
hate
objection is
StreamYards.
overruled.
Fucking
Exhibit
hate StreamYards.
177 is
Fucking
received.
bullshit.
Permission to publish is granted.
Said 177.
177, yes. Go ahead.
I can't see the volume levels in
Yours
StreamYard.
would only know when it's in
I
the
can't even
chat box as well.
hear it in StreamYard. What I hear is not what you hear. It's such a pain in the ass.
And again, just so we're clear on the record, please circle Virginia Sorensen in the hat in this picture.
Objection leading.
Overruled.
That is Virginia, and then this would be the hat and hood that I believe was found on the SUV.
That's pretty good evidence. I have to say, hey, here's a picture of a hat and shawl or whatever inside the
There
SUV.
were
Here's a
many
picture
videos
of someone
that have been
wearing
shown
those
to this
exact
jury,
items.
correct?
Objection.
That's pretty good evidence, I have to say, man. Pretty good evidence that, at some point the
Salvation
SUV
Army?
hit that person.
Overruled. The witness may answer.
Or is it at least in the vicinity of that person?
To
Yeah.
your knowledge, are there any videos that display the license plate of the red SUV as it goes along the parade route?
Objection leading.
Overruled.
No.
Yes, there are.
Is it possible to capture a screenshot from those videos to see the license plate of the red SUV along the parade route?
Yes, there are.
I'd like to display for the witness only, Exhibit 150.
Go ahead.
How am I, fe-
Is 150 on your
how am I
screen?
feeling today? I'm doing okay today. Thank you for asking, Brittany.
It is now.
All right. Do you see Exhibit 150?
Yes, I do.
Please describe what you see in Exhibit 150.
Objection leading.
Overruled.
I see the red SUV that was driven through the parade route, and it's at the time when it was contacting the Waukesha South band members. In that photo, you can read the license plate number.
Do you believe this photo is a true and accurate representation of the events of the day?
Yes, I do.
Move to admit 150 and permission to publish.
Objection. How does this go to investigation? Exhibits
Overruled.
on investigation.
Exhibit 150 is received. Permission to publish is granted.
Brooks is just hard to hear. It's not me. Brooks is not speaking into the microphone. He is just mumbling his words. So me upping the volume so that he'd be clear would just blow
Image
out
is a
the
little blurry,
video.
correct?
So we'll just have to deal with him mumbling his
Okay.
objections. For those of you saying, "Oh,
Can
you can't hear
please,
Brooks,"
point out
that's just how it is in the court
license
audio. For me to
plate
fix
in the
that problem,
photo and
I'd have to
read
blow
it.
out the rest of the audio, which I'm not going to do.
Is it okay if I circle it?
Yes.
Overruled. You may do so.
That is the license plate number, and I read ADP 9256.
All right. Now I'd like to show to the witness only, number 151, please.
Go ahead.
I do have to say, I do like this
Please describe
detective
151.
styling. I like his
Screen, Madam Clerk.
combination he's got here with this checkered shirt with the tie and the jacket. I
This
like
photo is
that
of
look.
The red SUV on the parade
I
route.
think it's snazzy.
It's just photo taken just prior to the Barris Logistics float. And the band director is in the lower left-hand side of the video. It shows the red SUV with the license plate number displayed.
Do you believe this photo represents a true and accurate depiction of the events of the day?
Yes, I do.
Move to admit 151 and permission to publish, Your Honor.
Objection to relevancy.
Exhibit 151 is received, permission to publish granted. The objections noted and overruled.
I recall this station we had 140 exhibits. How did we get this many?
Keep going, Attorney Younger.
Detective, please describe what you see in 151. I think you did describe it. Strike that. Please circle the license plate and read it for the jury.
Will I be here after lunch? Nick wants a place to send folks.
Overruled.
Sure.
9256.
Why not?
It's still not up. Okay, I'm sorry. Gotta wait.
I'll tell you what. How about this? If Nick sends people over here, I will commit to streaming the rest of the day. Let's do it that way. If Nick sends people over here, I will commit to streaming the rest of the day.
During your investigation, did you uncover any other videos linking Mr. Brooks to this same vehicle with this same license plate?
Objection, I don't consent to being called their name and misleading the witness.
Overruled.
If he doesn't send people over here, I'm
Yes,
running
he does.
away
Could
and
you
pretending
describe
that this
video
entire
for
stream
us,
never happened.
please?
Objection, leading.
Overruled.
There's a video that we obtained from social media that shows Mr. Brooks.
Yeah. No, this is
standing
exactly
next
why
to
I'm streaming today,
the
Brittany.
SUV
This is the only this is the reason I'm
license
streaming
plate
today.
Number on the vehicle.
It's like why I'm streaming today
Video was taken
is
sometime
exactly
prior to
because of
November
this. I'm
21st.
expecting some real fireworks today because Brooks is going to
Like
start his case.
display for the
And I
witness
expect there's gonna
only,
be some
Exhibit
interesting-
175, please.
Interesting experiences with his opening and him
Mhm.
trying to call witnesses. And I imagine today is just going to be the most shit show of the shit show days. There is a reason I'm streaming today. Because maybe it will just, it's going to elevate everything to a whole new
75.
level.
This is
Objection, relevancy.
Overruled. You may answer.
This is a photo. There's two individuals in the photo. The individual on the left, I know to be the person referred to as Darrell Brooks. It displays a vehicle, a red Ford, and it has the license plate number, which is displayed in the photo.
What is the source of this photo?
Objection, leading.
Overruled. The witness may answer.
We obtained it through social media.
Okay. I mean, this is a photo versus a video.
This is the photo taken from
Hold
a
on.
video.
I understand the objection. It's sustained. It's foundational. This particular question, the witness may answer. Go ahead.
This is
Overruled or sustain?
Overruled.
He said sustain.
What did I say?
Yes, you did.
Sorry. I meant it's overruled. The witness may answer. Sorry, I'm taking notes. I was writing the word source, and I think that's why I did that. In any event, go ahead and answer. Sorry about that for any confusion I may have caused.
This is a screenshot taken from a video.
He's correcting the judge.
Move to admit
The judge made a
175
mistake
and
and he's
permission to
correcting the
publish, Your Honor.
judge.
Objection.
Like, did you mean this when you said this? It's like, yes, I actually did.
The relevancy.
Wow.
I don't see the alleged defendant in here.
He's competent,
Your
guys.
objection is noted. It is overruled.
He's
and
competent.
Exhibit 175 is received. Permission to publish is granted.
He's infuriating, but he's competent.
Where's, oh, sorry.
The jury would also let me know when it's in the jury box. Or on the-
Lol. We saw this video. Not his best work, though. His best work remains what the business. In this rap evaluator's
Go ahead.
critique.
Detective Casey, is person you know as Darrell Brooks in this photograph?
Objection, I don't consent to being called their name and leading the witness.
Overruled. The witness may answer.
Yes, he is.
Please circle or X or mark in some fashion.
They couldn't find a shot with him like, oh,
How
they
do you know that's Darrell Brooks there? His back is to us.
Objection, leading.
Overruled.
I've watched the video in its entirety and I've seen his face in the video.
Yeah, they couldn't find a shot with him looking at the camera without him like holding a
have
gun
you
or
go down,
something like
please.
that would be unduly prejudicial. Is that what's going on?
Detective Casey, in total, how many videos do you think were collected by the Waukesha Police Department during this investigation?
Objection, speculative.
It's not
Overruled.
speculative.
You may answer.
You would know the answer.
We have at least 65 to 75 files. Some of those files contain multiple videos, photos, could be 10 each. So I would say probably 300 to 400 videos we've collected.
What were the source of those videos?
Some of the videos came from different people that were at the parade. Some of them are from city-owned cameras, and some of them are from fixed surveillance systems from businesses that were in downtown Waukesha.
Were
If
all of the
Darrell
videos that were
Brooks-
available shown to
If
this jury?
Darrell Brooks
No, they were-
enters the rap
Overruled.
videos
You may
into
answer.
no,
evidence,
they were not.
Have you personally observed
yeah,
and reviewed each of the video files available in this case, sir?
Objection.
if the jury
Overruled.
gets to experience what
Yes,
the
I have.
business, what the business, what the business.
To your knowledge, sir, did any video ever show a different
Wow.
person behind the driver's wheel of that red SUV?
Objection, leading.
Overruled. The witness may answer.
I have never seen anyone
I want
driving a
the-
vehicle.
I want
besides
everyone to hear my rap
the-
stylings and go
any
check
of
out
the
my
videos
album.
that I looked at.
I'm releasing a new album just
Any
dropping
of the
this
videos, Were
morning.
you ever able to see
It's called the
multiple
Waukesha
people
Parade.
inside the vehicle?
I'd like to release that single right now in court, Your Honor. Can we play exhibit?
The witness
Can we
may
play
answer.
exhibit 305?
None of the videos
My
that
new
we had
single.
looked at showed anyone else in the vehicle.
Yo, I own a red SUV.
Do any
Yo,
of the videos
I
at
drove
any
through the
point
crowd, yo.
show the red SUV coming to a stop, a complete stop along the parade route?
Objection, leading is
Oh.
speculative.
Overruled. The witness may answer.
I've never seen a video that shows the vehicle slowing or stopping while it was on the parade route.
Do any of the videos show the driver of the vehicle exit the vehicle to check on a person who had just been struck by the vehicle?
Objection, leading.
Overruled. The witness may answer.
I never observed in the videos the driver of the vehicle to stop and check or exit the vehicle on anyone.
There was testimony earlier in this case about witnesses observing multiple people running from the car. Do you remember that?
Objection, leading.
Overruled. The witness may answer.
I've got to wonder.
Yes,
I
I
respect the prosecutor. I really do, but
Were
I've
there
got to
multiple
wonder if
reports
she's
like that,
wondering,
sir?
along with the judge. I wonder if they're both wondering, what have I done
Initially,
wrong
there
in
were
my
some
life
reports
or in a
like that.
prior life that has led me to this place?
When the vehicle was found on
What
Maple
mistakes
Street,
and
you weren't
sins
there.
have I made that has
Right.
led me here? What did I do
Overruled.
wrong
His
in my
Answer
life
may stand.
to earn this?
Do you know what police activity occurred?
Is
When
the judge or
Maple-
prosecutor
when the
questioning
vehicle
every
was
life
found on
decision
Maple?
they've ever made?
Objection, speculative.
'Cause I'd be right about now.
Overruled. The witness may answer. He was asked, what does
They're
he know?
wondering what the business. They might be wondering what the business.
I
That's
do.
a fair point, Lou.
Please tell the jury what happened when the SUV was found on Maple.
Objection, leading.
Overruled. The witness may answer.
Initially, Officer Moss went, he secured the vehicle, did not find anybody in the vehicle. There was an initial report that saw.
Maybe
some
the
other
jury will
people
tell us what the
running from
business.
the area of the
They are the
vehicle.
finder of fact,
After that information was.
We could
given
ask
back
for a
to us,
special
we sent
verdict form,
detectives down to the area
along with
to investigate
along
further
with
to see if we could
deciding,
corroborate
the
and
guilt or
find
innocent
out
and the
if
whatever
that was
80
true or
counts
not.
there are. We could also ask the jury to decide, as a matter
After
of
that
fact, what the
investigation,
business, and then we would know.
Did you have other suspects
Yeah.
or just one person?
Objection, leading.
Overruled. The witness may answer.
Based on the information of what everybody saw on the parade route, and then the detectives that went back down to Maple Avenue where it interviewed the people that reported the people running. Our investigation determined that there was only one person in the vehicle and there was no other suspects that we were looking for.
At some point in your investigation, Detective Casey, were you given a Ford key?
Objection, leading.
Overruled. The witness may answer.
Yes, I was.
What was your understanding as to the source of that key?
I like this suggestion very much from Dan M. Let's play along in chat,
My
guys.
understanding that
Why don't
that
you
key
give
was
suggestions
taken
for
from
some
Mr.
titles
Brooks when he was
for this
taken
new
into
rap
custody
album
and
that he'll be
turned over
releasing as a result of this
to
trial? I like Dan M's initial suggestions. Maybe you can come up with better ones.
Noted.
What should be
Overruled.
the titles
How did you get
of
it?
these new songs in this album? Let's at least have some fun in
Overruled. The
chat.
witness may answer.
What are your suggestions?
Overruled.
Help Dan
You
M
may
out
answer.
finish out the list.
Detective Stern brought me the key the morning after the incident.
Did you do anything with the key?
Yes, I did.
Tell the jury what you did, please.
Objection, leading.
Overruled.
At that point, the vehicle was at the Waukesha County Sheriff's Department Secure Storage Facility. Mr. Johnson was over there processing the vehicle. I went there and I took the key with me and I checked the vehicle to see if the key would work in the car.
What did you find?
Objection, leading.
Overruled.
I found that the key worked the door locks to unlock the car. I also put the key in the ignition and it turned the ignition lock.
Thank you.
I'm not a person, I'm a human being.
Detective Casey, you've heard testimony about the manner in which the defendant was identified by the name of Darrell Brooks. Do you recall that testimony, sir?
Objection, I don't consent to being called that name, misleading the witness.
Overruled.
Yeah, we haven't heard a
Foundational.
lot of grounds today. That's true. I
Witness
mean,
may answer.
maybe he's given up the
Yes, I
grounds
do.
issue.
Did you endeavor to verify the identification of the subject you had arrested for this incident?
Objection, leading.
Overruled.
Yes, I have.
Did you verify his identity by the name of Darrell Brooks?
Objection, I don't consent to being called that name, leading.
Overruled. The witness may answer.
Yes, I have.
How did you do that?
Objection, leading.
Overruled.
How did you
There
do
were
that?
A couple different
It's
ways.
pretty freaking open.
One
Who,
way
what,
is
when,
when
where,
a
why,
person's
how?
taken into custody.
Are pretty
we take the
open
fingerprints.
questions.
We check that against other records that are kept by the state. Those fingerprints matched Darrell Brooks. I've also spoken to 3 women that he has children with. They verify that is his name that he has always gone by. I have also spoken to his mother, which states that that's the name that he has gone by always.
He spoke to his mother. Lol.
I'd like to put on the screen for the witness only Exhibit 88.
Go ahead.
Do you see Exhibit 88, sir?
Yes, I do.
Objection to this, what was the relevancy?
Overruled. Go
Can you-
ahead.
Grounds for the overrule?
Relevant.
In what way is it relevant?
To the counts alleged in this case. Go ahead.
His
Can
mom
you
is
please identify
apparently
Exhibit 88,
not calling him
sir?
math boy. No, Lou. Apparently his mom is not
This
calling
is
him math
a
boy.
bail
I
bond
know. We're all
through
shocked.
Milwaukee County Circuit Court for Darrell Edward Brooks, the date of birth of 2/21/82.
To your knowledge, was Mr. Brooks on bail through a Milwaukee County case on the date of November 21, 2021?
Objection,
Math
leading.
boy is his rap name. Math boy fly.
Overruled. The witness may answer.
Yes, he
I know.
was.
We watched his
What
music
is the
videos the
date
other
of
day. We
this
can watch
bail
him
form,
again.
Please.
But that's his
near
rap
the bottom.
name. His rap name is Math Boy Fly. So
The date on the bottom
Yeah.
Objection,
is
leading.
Overruled, the witness may answer.
2/21 of 2021.
Was Mr., we'll strike that. By classification, can you tell us the level of charges that Mr. Brooks was pending on
I
for
feel
this
you.
bail?
Objection. You've already made a ruling on it.
Overruled, the witness may answer.
All the charges that I see in here are felonies.
To your knowledge, was this bail in full force and effect on November 21 of 2021, sir?
Objection.
Overruled. You may answer.
Yes, it was.
And in the middle of the form, do you see the conditions of bail that were set upon Mr. Brooks?
3.141592653589734486646872568725.
Yes, I do.
3.1415926535. Okay, that's
Overruled,
enough
the
of that.
witness may answer.
The state defendant shall not commit any crime.
Thank you. Move to admit number 88, Your Honor.
Objection.
Exhibit 88 is received.
Like to display for
We've
the,
already speculated to, how's that coming into evidence?
Overruled and permission.
You guys
to
haven't seen that video?
I'm sorry, I did not seek to publish this.
We'll watch
Oh,
it together
alright.
during a break.
Request a legal finding of fact for that.
The objection is noted. It's overruled. Continue, Attorney Opper.
Thank you. I'd like to display for the witness only exhibit 89.
Got to help your math
Go ahead.
Sir, can you
education.
please identify 89?
Objection.
Overruled.
Relevancy.
Overruled.
This is a,
This has been stipulated to as well. How's it evidence? How's it being admitted?
The objection's noted. It's overruled. The witness may answer.
I request a legal finding of fact for that too, Your Honor.
Noted. Overruled. Go ahead.
this is a bail bond through Milwaukee County Circuit Court for Darrell Edward Brooks with the date of birth of 2/21 of 1982.
Is this a different case than what was displayed in exhibit 88?
Objection, leading.
Overruled.
Yes, it is.
Are you able to make any observations about the level
We're
of
here on
charges,
Uncivil Law. We're
related
here to
this
help.
case,
We're here
sir?
to help Math Boy fly
Leading.
Overruled.
by exposing him to songs for him to cover, and we're also going to help educate the entire chat
4 charges. 2 of
about
which
the
are
magic of
felonies.
3.141592653589734626433. Yeah, all that good stuff.
States 11/11 of 2021.
The directing your attention again to that same location in the middle of the page under paragraph B, the third bullet. Could you please read the conditions of release that were set by the court in that case?
Objection, leading.
Overruled. The witness may answer.
Defendant shall not commit any crime.
To your knowledge, sir, was this bail in full force and effect on November 21 of 21?
Objection, speculative and leading.
Overruled as to both. The witness may answer.
Yes, it was.
Oh,
Finally,
he's already
sir,
out on
I'd
bail
like
on some
to,
other crime at the time.
Put
Okay.
up one last item for you, or 2 items. 1 second, please. I'd like to display for the witness only exhibit 13.
Objection, what's the relevancy of this? How does it say any foundation to testimony?
I'll give the state some leeway to establish that. Go ahead.
Thank you. Sir, do you recognize can you tell if exhibit 13 is a video, sir?
And that's what the fight with his girlfriend is about, that she wouldn't post bail.
Yes, it is.
Okay. Have you seen this
Why
video
wouldn't
before?
he have the money from all of his
Overruled.
Still relevant.
revenue from his math
Um,
boy fly rap
The state
career?
is asking the foundational questions, the objection's a bit premature. I'll take it under advisement. Go ahead, Attorney Opper.
Yes, I have.
What does this video depict?
Objection leading.
Overruled, the witness may answer.
Objection speculative.
Overruled, go ahead.
This video depicts the backyard at 4014 North 19th Street in the city of Milwaukee. It also, that's the address of Dawn Woods, the mother of Darrell Brooks. And on the lower left-hand corner, you can see a Ford Escape.
In the lower
Objection.
right,
I move to strike that. How does he know? What,
The objection's noted, overruled. You can ask him on cross-examination. You can question him about that. Go ahead.
in the bottom right-hand corner of the exhibit, do you see a date and time stamp for this video, sir?
objection leading.
Overruled.
Yes, I do.
What does it say?
It says 11/21-2021, and then it says 13:26:18.
What do those numbers represent, sir?
Objection leading.
Overruled.
To me, it'd mean that the video was taken on November 21st, 2021 at 1:26 p.m.
And do you believe this video is a true and accurate representation of the events of that afternoon at that location, sir?
Objection speculative.
Sustained, if you could lay a little more foundation.
Sure.
please.
How did you come into possession of this video, sir?
The defendant's mother provided it to us.
Do you know approximately when it was obtained?
Objection speculative.
Overruled.
The evening of November 21st, 2021.
Do you know if the defendant's mother was cooperative with police in providing the video?
Objection relevancy.
Overruled. The witness may answer.
Yes, she was.
Do you know if the video was provided to police when asked?
Objection leading.
Overruled.
Yes, it was.
Do you have any reason to believe that the video was altered or modified in any way before it was provided to police?
I do not.
He's waiting for the
Move to
objection.
admit
He's just like
13, Your
waiting.
Honor, and permission to publish.
That's kind of hilarious. He's just like, I'm just going to sit here for a second and see if they object because he is objecting to everything. before I
Noted.
answer the
Overruled.
question.
Exhibit 13 is received. Permission to publish is granted.
For the record, this is a video. It's 49 seconds in duration. We're going to play it in full. There is no audio, and it will be played at normal speed.
Lol. That looks like a red SUV to
Oh,
me.
hang on, don't play yet.
Yes, if the jurors would let me know when the monitors are displaying the video. All right, go ahead.
It's why are we playing a video? Oh, okay. There he is. That's why. Oh, he's going to get in the car and drive it away. Oh, he's caught by his own Ring doorbell on his own house, driving the vehicle away at some point. Oh, that's good. That's just great. Come on, move the car. Drive it away for us. Show us. Yep. Wow. That's funny. He's caught by his own Ring doorbell driving the car away.
Detective
That's a
Casey,
nice
were you
little-
able to
that's a
see
little
any
nice little
emblem
note.
on the front grille of that
See,
vehicle
guys, this
as
is
it
what we
drove
call
away?
pretty good evidence. This is pretty good evidence.
I would have to look at it again.
Okay, I'm sorry. Let me ask you this. Did you see any damage to the front end of that vehicle as it drove away?
Objection leading.
Overruled.
I did not.
Okay. I'm going to put up State's Exhibit 14 now, please.
Go ahead. Just to the,
Yeah, just to the witness only, please.
thank you.
Do you recognize Exhibit 14, sir?
Yes, I do.
What is the source of Exhibit 14?
This is a still shot taken from the video.
The same video we just saw, number 13.
Yes.
Move to admit 14 and permission to publish, Your Honor.
Objection, relevancy.
The objection's overruled. Exhibit 14 is received. Permission to publish is granted.
Sir, do you see
That's
Darrell
pretty
Brooks
good
in this
evidence.
photograph?
That's pretty.
I don't consent to being.
It's pretty good evidence right there.
Noted, overruled.
Can't help noticing him. Can't help
Yes, I
notice. Yeah, that's pretty good. That's pretty
Can you
good.
identify or, excuse me, describe the clothing items that you see him wearing in this photograph? Oh, it's not in the jury box yet. I'm sorry.
You can state your objection, though.
Lead it.
Overruled. The witness may answer.
Mr. Brooks is wearing a red t-shirt, blue jeans, and he has blue colored flip-flops on with white socks.
And
Yeah.
what's the date and time stamp for this photograph, please?
It's 11/21/2021 at 13:26:08 hours.
And
1:30 in the
that's what
afternoon.
time?
Objection, lead
In, on the 12-hour clock.
it. Objection, lead it.
Overruled.
That would be 1:26 p.m.
All right, thank you. Have any other questions, sir?
Lee Cross.
In the two exhibits we just watched, 13 and 14, do you see anyone driving a vehicle?
No, I do not.
Do you know if anyone's in the vehicle at the time that you see it pull away?
I would assume based on my training experience that when the vehicle pulled away, that there was someone inside the vehicle, because in order to move a vehicle, you have to manipulate the controls, the shifter, the brake, the accelerator. So my assumption is that someone is inside the vehicle doing that.
That wasn't the question. Do you see anyone in the vehicle?
I object, Your Honor, that was the question, and he's already asked and answered. The question is, anyone can be seen.
The objections. Not sure what the objection was, but the answer may stand. You can ask your next question.
Let's go back to exhibit 175. You pull that up for the witness.
Would the state please pull that up? Witness only or published?
Publish.
Okay, thank you. Go ahead. Jurors, let me know when it's in the jury box as well.
Publish, by the way, in case we just in the effort to learn something, publish means show it to the jury, right? So when you offer an exhibit to the witness, if you want the jury to also see the exhibit, you have to ask for permission to publish. So that's what the judge was asking. Is this witness only, or do you want the jury to see it?
All right,
Just-
go ahead. It's in the jury
You
box.
just testified.
As general trial
That this
practice,
was
you
the
do
alleged
want
defendant.
the
How do
jury
you
to
know
see
that?
things.
Can you see a
So
face?
as a general rule, if
Which
you're a
question
lawyer,
are you asking?
you
Those are
publish.
two.
Can you see the face on the circle
There are exceptions, of
individual
course, to
in
everything.
that exhibit?
In this clip, I cannot see the face of the person that is circled.
So how do you know who it is?
Because I saw the entire video.
I can tell
How
who
do
it
you
is
know
because I
who it
watched
is?
this
Is an
video in its
open-ended
entirety,
question.
And I can tell
He's
that
on cross.
it is
He doesn't
you
have to
based on all my
ask
contacts
open-ended
with
questions.
you.
That's a
So why
mistake.
were there not any other exhibits that can give credibility to you positively identifying the individual in this video.
Objection, argumentative, or
Grounds.
compound.
Sustained
Happy
is the form of
birthday.
the question.
Lol. No.
Is it fair to say that this is the only exhibit photo from the video?
He can say I don't know.
Go
Can
ahead.
you clarify the only one that is shown today, or the only one that has ever been taken?
The only one that's
ever
the only
exists?
one that's
Could you clarify,
being
please?
shown right here today. Is this the only one that is an exhibit being shown here today?
Yes, this is the only one that we've shown today.
And you can tell just from this exhibit exactly who that individual is.
I don't believe that was my testimony.
Good answer.
I'm asking the question.
From just looking at this, no, but I know from looking at the entire video that it showed.
Objection, move to strike, non-responsive.
We're talking about
Oh well.
this exhibit that's being shown right now during your testimony right now at this moment. Strictly that.
Could you ask your question, please?
I'm going to object, asked and answered.
Sustained is to the form of the question as well.
Would it be fair to say that from this exhibit 175 that they're looking at right now that you cannot tell who the circle individual is? Would that be fair to say?
Yes.
That would be fair to say.
Can you
Very
clear the circle?
Thank you, Madam Clerk.
And do you recall what date you viewed this video, as you call it?
I can recall what date I
I
viewed
have
the
viewed
video
this
because it was a
video
day that I
multiple
regret.
times. I don't recall the specific dates that I've seen it.
Was it relatively early on in the investigation?
There have been multiple times that I've watched this video. Some of them early, some of them as late as yesterday.
Did you watch it yesterday? So did we.
Do you recall seeing this video
Or maybe it was the
The
day
same
before. I
night of
don't
the
know.
incident,
Time
or-
gets weird.
in the days following?
I did not see it the night of, but it would be the days following that I have seen it.
And at that time, did you have knowledge of who that vehicle belonged to?
Yes, I did.
And did you have knowledge of the usage of that video? I mean, the usage of that vehicle?
I'm not sure that I understand the question.
Did you have knowledge of who may have been using the vehicle?
Objection vague as to time.
Sustained is to the form of the question. If you could limit or perhaps direct him to a specific time frame regarding the use of the vehicle.
At the time of the incident?
Yes.
And can you clear that? And what information was that?
The information that I had is at the night of the incident that you, Darrell Brooks, were the person that were operating the vehicle.
And who did you learn that from? And for the record, I don't consent to that name.
Noted,
For the record.
overruled. Go ahead and answer.
Can you repeat your question, please?
I'm gonna go another route.
Aren't they showing the full
You don't
video
think
because it would be
it's-
unduly
No,
prejudicial?
no.
There's a lot of controversy right
You're
now on this
withdrawing
exact
your
issue about
No,
showing
I'm
rap
going
videos in
another route.
particular,
Thank you.
You
and
just
because it's unduly
testified to seeing,
prejudicial, and so they
the
don't want to
entire
show the
video
entire
that this
video to
steel
avoid that
frame,
issue.
exhibit
California just
came
passed a
from,
law
correct?
specifically dealing with this issue. There's some controversy right now in the
I testified that this came from the entire
law
video.
about the
Correct.
use
You-
of rap videos in
Said that you
particular,
viewed the video in its entirety,
and so they are
correct?
playing it safe by not offering the full video. That's
The
why.
entirety what we recovered from your social media account. I'm not sure if there is a longer version someplace, but
Did you see the
And good for
video in
them.
its entirety? The video that this exhibit came from?
yes.
But of course, There's nothing stopping Mr.
And are
Brooks
these
from
the only two
offering the entire
individuals that
video
you
into
observed in
evidence,
that
right?
video?
There's nothing
They are the
stopping
only
him
two
from
that I
saying,
recall
okay,
seeing in the
let's
video.
show the entire video. Carby, like,
Did you
okay.
ever inquire about the identity of this individual?
No, I have not.
Can you clear that circle?
Thank you, Madam Clerk.
Would it be fair to say that from looking strictly at the exhibit that we're viewing right now, that
I'm gonna put on a
both
little wrist brace.
individuals
My
have
wrist
the
is a little
same
sore.
hairstyle?
It would be fair to say.
Can we clear the X's and clear the exhibit?
Go ahead. Thank you.
We go back to exhibit 13. Published.
Go ahead. The state would assist, please.
13. Can you play it?
Yes,
Well,
the
just-
rap video is bad.
Just play it. I'll tell you when.
So
to pause
small
it.
town
That's
girl
okay.
goes 9999. Say thank you for live streaming this. I know it's painful. It's pretty bad.
It's not up yet.
Thank you for giving some super chats. It's always
We're gonna wait for
appreciated.
the jury box.
Okay.
Okay, go ahead. Thank you. Just a reminder, it's 49 seconds long.
I don't think I'm gonna need the. Well, I don't know. I might. Pause. Right there, the individual that you observe. Right here. Do you see them wearing a hoodie?
The person in that photo is not wearing a hoodie.
Do you see a hoodie anywhere present in this video?
Hey,
I
that's
don't see
actually a
video
somewhat lucid
or a hoodie
question.
anywhere in the video.
Can you take the X down? From this angle, it'd be fair to say that you can see the very front end of a vehicle, correct?
That is correct.
Can you see any windows or see inside the vehicle at that time? Or at the time that we're looking at right now?
You cannot see inside the vehicle at this time.
So it would be fair to say that just by looking at what we're looking at now, you wouldn't know if anyone's already inside the vehicle.
Hey, that's a lucid
Can I
question.
answer, Your Honor?
I'll allow it. The witness may answer.
This is a whole different.
She agreed with you.
Go ahead.
That is correct. From this video, you cannot tell if anyone else is inside the vehicle.
So it'd be fair to say that you're not sure.
It's fair to say that I am not sure.
Can we pull this down?
Hey, that's a lucid question. You're not sure who the driver is. Good job, Darrell.
Whoa, wait. I'm sorry. Can you pull that back up for 1 second?
Same exhibit.
Same
Go
exhibit, 13.
All right. The state would put that back
Right.
on display,
It does-
and there you go.
Good.
Do you want any
Right.
more of a plate or just the still?
We waiting for the jury, or do they?
It's up.
No, we don't need it played.
Do you need it to go to a certain point?
Yes,
All right. Do you know what point?
I'm about to arrest.
Andrew asked, I've only caught bits and pieces of trial. Has Brooks managed to ask the question, what the business, what the business,
Looking
what
at
the
this
business?
House right here.
Unfortunately, no.
Do you see
He
an
has not yet
address
asked the
posted
question.
anywhere on
Maybe
this
he'll
house?
ask the witnesses he calls what the business
In
is.
the
I mean, it
photo
is a
that you
question that
circled,
consumes
no.
him. And this is his
So it'd be fair to
opportunity.
say that you don't
Maybe
know the address
maybe one of the
this-
witnesses
this
knows
house.
what the business is. Who
That is
knows?
incorrect.
What the
You
business
just
is
said
an
that you
open-ended
don't
question.
see an address posted anywhere in this house. So from the vehicle, strike that, not the vehicle. I'm still looking in the corner right here. From the video that we're viewing right now, do you see an address posted anywhere on this house?
I do not see an address posted in this photo.
So judging by this, well, actually it's a video, but judging by this video, how can you know the address of this house?
Because I went
Because
there
I've
and I
been
found
at
the
this house
house and I
before,
looked at it
talking
and
to
I
the
saw the
mother.
yard and I
I've
know
seen the
it
address
because
on
I've
the
been
front of
there.
the house.
Judging by
I'm like,
his,
yep, that's
Hold
the
on,
one.
you have to let him finish because that was not the question you asked. You asked him how he knew. He can answer. Go ahead.
Yeah, you did. You asked an open-ended
I've
question,
been at this
Darrell.
address before.
You said,
I've
how do
spoken
you
to your
know?
mother. I've been in the
Because I've
backyard of
been
the
there.
residence.
I've seen
the
it.
address on the front of the
I've
house.
been in the
I
backyard.
know this
I
to be
know
your
it from
mother's house.
being there.
I recognize from this photo to be your mother's address at 4014 North 19th Street.
you recognize the house or the address? Because we don't see an address in this video.
I recognize this house to be that address from being there.
And had you already been there, as you say, and talked to people, as you say, before you viewed this video?
Review the video? I'm not sure.
I believe that I saw the video first, and then I was at the address.
Doesn't really matter either way.
So at the time that you saw this video, you didn't know whose house that was.
That'd be correct.
That would be an incorrect statement.
You just said that you saw the video first before going to the house. Did you, or did you not say that? Would that be fair to say?
I guess I'm a little confused in your question. We received the video. We know from getting it from my mother that she said that that is where she lives. So I knew that this was where she lives when I watched the video. That was clarified for
I
you.
follow you, but that clarification wasn't stated before. So
Yeah,
that's
fine.
fair from the clarification of how you just clarified it. Can you clear the
You're
circle,
done with
please?
this exhibit?
Yeah.
All right, we'll take it down. Thank you.
Thank you, Z360, for your $2 super chat. It is appreciated. Thank you. If you give me super chats, it fuels me. Lol.
You made reference to a key being found. Did you yourself find that key?
No, I did not.
Were you at the scene where the key was found at the time it was found?
No, I was not.
So it'd be fair to say that you were told that a key was found.
Yes, I was told that a key was found.
I'm gonna turn off my cam for just a second here. We can just have a little voice time with Uncivil Law. How y'all doing today?
So it'd be fair to say that you went off of what you were told. You actually didn't observe this with your own eyes.
What are you speaking of?
The key being found.
That's correct. I was told by two officers who I've worked with for a long time, and I trust what they tell me to be accurate.
Yes, absolutely. Super chats absolutely give me a tingle at my leg
You
every
made
single
reference
time.
to there
Please
being
give
a
super
couple-
chats so I
what's
can
the
have
word you
further
used?
tingles.
A couple ways to identify.
The tingles are
individual.
appreciated.
And you stated that you had spoken with the mothers of
$1.99
the
from
alleged
Mambo
victims' children.
Fuego. Man Bear Pig was
Very
driving. Chewbacca defense might work. I
Like I said, I
understand.
spoke with the mother of three of your children.
At that time, was the alleged defendant already in custody?
Yes, he was.
Wouldn't it have been easier to just use the fingerprints that were already obtained?
Like I said before, the fingerprints was one way. We also verified it talking to his family members that his identity.
We verified it on fingerprints. We
Any reason
verified it on
why-
DNA. We
well,
verified it by
let me
talking to
back
his
up.
family. We verified it multiple different
Is
ways.
it fair to say that there was more confirmation needed to identify the
No.
alleged defendant at that point? Seeing as how the fingerprints.
10 Canadian
Were already
dollars from
obtained.
CC Vatter. This is painful to watch. I've been doing it
Oh, we
alone.
were
Glad I
just
found
being
Uncivil to
Darrell.
watch
We were
with.
certain that it was Darrell
Does anyone
Brooks
else
that
think
we
the
had in
prosecution
custody
must be getting a
because
little
his
tired
fingerprints
of
and
Mr.
other
Darrell's
information that
behavior?
we had, it was just a matter of being thorough and verifying
Mr. Brooks,
the person
yeah,
that we had and the name that he goes by.
I think they're getting a little bit tired of Mr. Brooks' behavior. Yes.
It'd be fair to say fingerprints are pretty accurate, though. Correct? Would that be fair to say?
I think that would be fair to say.
So it would also be fair to say that there wouldn't be any reason why the alleged defendant that was in custody would be someone else. Wouldn't that be fair to say?
Objection, that's compound and difficult to follow.
It's not compound.
$2 from Z360. Here's another super chat. Hope it helps. It does help a little bit.
Sustained as to the form of the question.
Thank you.
And where did the interviewing of the mothers of these children take place, if you recall?
In the support group.
I spoke to Jessica Macklin in Iowa at her residence. I spoke to Angel Fitzpatrick at her residence in Menominee Falls.
Whoa. Can we strike that? Why do the names have to be stated?
Overruled, he was answering the question. His answer may stand, your request to strike is denied, and the witness may continue answering.
I spoke to Angel Fitzpatrick in Menominee Falls at her residence, and I spoke to Erica Patterson a number of times at various locations about you.
We've named the baby mamas on the record
You
now.
said one of the mothers of these children.
These are three
spoke
women
to
who have
Iowa.
made some bad decisions
Correct.
in their lives.
Why would you
Maybe
go
they
all
can
the way to
they
Iowa?
can form a support group or something.
Because initially you listed her as a witness on your witness list for court. So we went there and we wanted to verify what information she might have.
He
that
put.
she would
That's
testify
why
to.
we talked to her. You
Just for the
You put her
record.
as a potential witness.
I don't recall listing anyone as a witness.
So
Just for the record.
For the record, Mr. Brooks, you can't testify. At this
Lulu
moment.
says
You'll have an opportunity should
49489.
you
Thanks for
choose.
streaming. You're welcome,
I just
Lulu.
wanted that clear for the record since what was
Can't be,
said.
it's struck from the record at this
I-
point because you're attempting to testify. The
not
jury will
attempting to
disregard
testify.
that.
I just wanted the record to show
The
that I
jury
had no
will
knowledge of doing that. And if
The jury will disregard those statements made by the defendant
If
as
something's-
that he is not testifying, and it would be improper at this time for the court to receive them.
I don't think a
Go,
record should be
next
made of
question, sir.
something that I didn't do.
Next question,
question.
sir.
It's ridiculous.
Your attorneys did it, which is the same thing as you
So
doing it,
you said you went to
right?
Iowa
And I do
to-
this all the time too. By the
to
way,
try
I
to
did it all
find
the
out
time when
who
I
he
was in patent
testified to.
practice.
Why?
Like I would say, like the
Objection,
inventor says
argumentative,
when it's their attorney,
irrelevant, and calls for
because I
hearsay.
treat them as the same. So
Sustained
like,
as
yeah,
on all basis.
your attorney
Next
did it,
question.
you did it. It's a common
Was that an attempt
colloquialism
to
for
prepare
attorneys
for
at
what
least.
might have been said?
I'll allow that.
Okay.
Go ahead.
Yes.
Why would there be preparation involved in someone who might testify on an alleged defendant's behalf?
Objection, argumentative.
Grounds.
Why would you
Overruled,
prepare?
I'll allow it.
Is that the question?
We went there to speak with her, so if she came and testified, there wouldn't be any surprises. We also wanted to find out if there's any background information that she had about Mr. Brooks that would be helpful in our investigation.
So you made reference to not being any surprises. Would it be fair to say that there was a little worry there?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
What surprises were you referring to? What do you mean by surprises? No surprises.
Your Honor, I object to this entire line of questioning. This witness is not expected to testify. It's wholly irrelevant.
Well, he opened the door by putting the name on the record and saying where he went.
I will allow one more question on this. Go ahead, you may answer.
Could you re-ask the question, please?
What do you mean by making sure that there were no surprises?
We wanted to make sure that there wasn't any information that we weren't aware of that may come up later for that would be helpful in the trial.
Do you recall making an attempt to interview the child
Objection, relevance.
who was 7 at the time?
Sustained. Next question, please.
Reason for the sustain, Your Honor?
Not relevant.
Well, the question was asked, does he recall?
Sustained. Next question, please.
Grounds for the sustain again?
Relevant.
Relevance.
How's it not relevant?
Keep going, sir.
Did you interview the child?
Same objection.
Grounds.
Sustained.
Grounds for the sustain?
Relevant.
Why would you ask to interview the child?
Your Honor, objection. This
Sustained.
entire line of questioning is inappropriate.
Sustained. Move on.
I would
Mr. Brooks.
object that trying to interview a 7-year-old child is
Sir, move on, please. 90611. It's also not relevant. Since that's not an evidence.
was a tricky move. You made reference to, in regards to Exhibit 88 and 89, which were documents from an entirely different county. Do you work for Milwaukee County?
No, I do not.
So how did Milwaukee County, which is a different county, come into your investigation in Waukesha County?
You may answer. With the understanding there are some limited pretrial rulings that still are in play. Go ahead.
During the normal,
I'm sorry for interrupting. I started off by saying in regards to Exhibit 88 and 89. That's how I started the question, just for the record.
I know. I'm reminding the witness of the pretrial rulings.
Okay.
during the normal course of an investigation, we do background on a person to see if they have any open cases or any information that would be helpful. There is a computer system that displays what cases or charges are open for a person, and it is relevant because if you are charged in one county and you violate conditions of bail, you can also be charged in another county for those violations.
And in reference to having charges in one county and potentially being charged in another county, in reference to that, wouldn't you essentially have to violate the conditions in one county and strictly be charged in that county?
That is an inaccurate statement.
You being in law enforcement for a very long time, it would be fair to say that you're familiar with the term double jeopardy, right?
I've heard the term
No,
before.
God! No,
what is your
God, please,
understanding
no, no,
What that term means?
no!
Objection, irrelevant,
No!
beyond the scope of the witness's knowledge, legal conclusion.
Sustained for all those reasons.
So when did you become the lead investigator in this matter?
That was about 8:30 p.m. on November 21st, 2021.
So same night.
Correct.
And whom were you made lead investigator by?
The command staff or Lieutenant Jerry Habanik.
Do you
I feel
recall
you,
why
Richard.
were
I
tapped
feel
to
you
be
in
the lead
levels, man.
investigator?
Because I was the most qualified person and had the most experience to take care of it. That's what I've been told.
Cute.
Any other reasons besides that?
Also, because I was at the parade route a little bit earlier and I had the most information out of anyone. It took a little while for the other staff to come in. So I already had a little bit of a head start with the information that I already had learned as being there at the beginning.
And that would be the information that you said you had more knowledge of than anyone else at that time. Would that be in reference to having an interaction with the vehicle at some point?
I would say as the totality of the situation, I was there when the car first went through. I know what the radio traffic was for taking Mr. Brooks into custody. There's also some decisions that were made early on how to proceed with the case. I was also on scene downtown and took control of the crime scene initially. So a lot of those decisions were made even before our command staff started coming in to take over lead on the case.
You referenced you were there at the beginning when the vehicle first entered in the parade. What do you recall about when the vehicle first entered the parade?
I remember a horn beeping, red Ford Escape driving around, and then you driving into me and not stopping when I pounded on your hood and window.
Driving into you, what do you mean?
I meant that I was in front of your vehicle contacted
Thank
me,
you, CC
pushed me
Vader,
off to
just
the
here for
side,
the uncivil single
and
tingle.
continued driving without stopping.
Appreciate that.
Were you injured in this incident?
I was not injured, thankfully.
And you made reference to a horn beeping. What do you mean a horn beeping?
I mean,
You
a
mean
horn.
the vehicle was beeping its horn?
Yes, the vehicle was beeping its horn.
What would be the only time a vehicle would beep their horn?
Objection, speculation.
Grounds.
Sustained. Calls for
Reason.
speculation.
He's an expert. That's be the response back.
Do you know why the vehicle was beeping their horn?
Same objection, Your Honor.
Do you know why you would beep
He
your
asked,
horn?
do you know why? So he can answer that question.
$5 from Lily Smith.
Could you repeat
It's
the
just
question,
Mark Kirk with
please?
his Charles Horrendous. Yes,
Do
it
you
is.
know why the vehicle was beeping its horn?
I imagine that the driver was angry and wanted to get through the crowd.
And how did you come to that determination?
For my training and experience.
I've been driving a long time, and a lot of times people get angry, they're late, they beat their horn at you in a way that is because they're upset and they're trying to get past you.
Do you know that for sure?
You asked me my opinion.
Yes, I did ask your opinion. Now I'm asking you, do you know for sure if the driver of the vehicle you observed was in fact angry?
I assume that he was.
So it'd be fair to say you don't know for sure.
I do not know for sure, but that is my opinion, is that he was angry.
And at that time, you had no knowledge who the driver was. Would that be fair to say?
Well, I had knowledge because I saw your face. I did not know your name
Did
at
you
that
know
time.
who the driver was? No, meaning had you had any prior interactions with them before this incident? That's what I mean by no. Have you had any conversations with him, talked to him?
Hold on.
saw-
Compound question, ask one.
I was just giving clarification of no,
You
what I
need to-
meant by
It's a
no.
compound question. Please rephrase.
Before you observed this vehicle, as you say, and this driver that, as you say, did you know them?
I have no memory of meeting Mr. Brooks before that afternoon.
Sagittarius A.
So it'd be
Gives
fair to
$5 to say I can't take this. I
that
thought I did, but I
you're
can't. I'm sorry. Here's a tip to ease your
assuming
suffering.
something that you
Unmute
don't
the stream
know.
now.
Would that be fair to
I
say?
respect that.
Objection,
Everyone's got to look
compound,
after their own mental
vague,
health.
and argumentative.
Sustained.
Grounds.
Sustained is to the form of the question.
How would you know how someone's feeling if you don't know who they are?
Your Honor, he opened the door to this. It's asked and answered. The witness has given his opinion.
Oh, shit.
It's clear.
Here we go
Grounds.
again.
I object. Improper question.
Grounds.
I will allow the witness to answer why he came to that conclusion. Go ahead.
Like I said before, I've been driving a long time, and a lot of times when people are beeping their horns, it's because they're late, they're angry at something happened, and that's why I concluded that the person was probably angry.
So would it be fair to say that another reason why a vehicle would beep its horn would be to alert people to the presence?
Objection.
Grounds.
Irrelevant speculation.
Grounds.
I'll allow it based upon his training and experience. He may answer.
It's a possibility.
And did you hear this beeping before the vehicle approached you?
Yes, I did.
You made reference to, and I'm referring to the ring video obtained in exhibits 88, or I'm sorry, the ring video obtained in exhibits 13 and 14. You made reference to obtaining that the same night of the incident. Do you recall saying that?
Yes, I recall.
I do need to butt in for grounds. At some point, I'm going to have to go clip out the audio for grounds and like sustained and
would
stuff.
be
I'm
fair
going to
to
have
say
to make
that
myself a Darrell Brooks
you yourself
soundboard at some point.
have been present for all testimony. Would that be fair to say?
Sometime in the future, I'll do that.
That is not correct.
How so?
I was sick one day and I was not here.
Well, I'm referring to, let me clarify. Maybe I wasn't clear enough. Pertaining to all testimony since trial began.
Hold on, I'll
You've
be
been
right
present
back.
for all testimony. Would that be fair to say?
I believe I've seen most of it.
Do you recall testimony of and I'm referring to, again, so clear for the record, exhibits 13 and 14, ring footage that was obtained by the owner of 4014 North 19th Street, that you testified to obtaining the ring footage the same night. Were you aware that, well, let me back up just a little bit. How were you able to obtain that ring footage?
There was officers that went to Freighter Hospital where Dawn Woods, Mr. Brooks's mother, was working. They spoke to her, and she's the one that alerted to them that she had ring video at the house and offered to remotely download that video for them.
And were you there yourself?
I was not there myself.
When did you yourself speak to the owner of that home?
The last time that I spoke to Dawn Woods was on August 8th of this year. I may have spoken to her a few times Before that, I don't recall the exact dates.
I'm referring to the first time that you spoke.
I don't
The
recall
very first time.
the first date when that was.
And you did just make reference to an August 8th date. And what was the extent of that conversation?
Objection calls for hearsay.
Grounds?
Sustained, hearsay.
The August 8th date that you referred to, was that in any way follow-up? Was that follow-up investigation?
Follow up to what?
Well, you stated that you had spoken previously before the August 8th date. So the question is, was the August 8th date follow-up to the investigation that you were already actively lead of?
I mean, everything is related to this.
$20 from
investigation.
Jeremiah Maddox. Super chat for holding Stephen and his
The
little language of
investigation
fire on
continues.
Rakita Law.
It will not end until
Okay.
this trial is over.
I'm not sure exactly what that's in reference to, but thank you for the super chat.
So what follow-up was needed at the time of the August 8th?
I was looking for my other mouse pad.
Yes,
When I
which
bought
you
the mouse pad,
I
it
don't
came in
know,
a
I'm not
packet
sure.
too, and I'm like,
Objection
because the
still calls for
Stream Deck
hearsay,
keeps
Your
moving
Honor.
around on my desk. It's like, oh, I could get a mouse
Sustained.
pad and put it on the mouse pad, and I can't find what I did with it. So
Why did you need
somewhere
to
in my
talk to
apartment, there's another mouse pad,
Ms.
and I'm not
Wood
sure where it
multiple
is.
times?
Because every time we spoke
with
to her, we
regards
got
to loaded
different
language?
information.
Oh, okay,
And at
fair
that time,
enough.
we were following up with your niece and nephew of what their testimony would be in this case.
What testimony are you referring to? Because I don't recall any nieces or nephews testifying.
I don't think I'm allowed to say it.
I think this line of questioning is irrelevant, Your Honor.
I'll sustain the objection, and at an appropriate break, I can address it further if need be. Please move on to a new topic, sir.
You made reference to people who were injured
Avery
at
asked,
parades
why
in
isn't he
Berkeley.
allowed? Because there's some sort of motion in limine.
Yes, I do.
His attorneys at some point moved to exclude certain things, and the court has already ruled that certain things are not admissible,
To your knowledge, were
and he's
any
aware
those
of that.
charged?
So the defendant is asking a question that is in
My
conflict
testimony
with the
before is that
pretrial
those
ruling. So
people,
it's like, I'm not sure I
cases
can
were
answer
not
that because
charged.
you're in conflict with a ruling that's currently in place by the court. His lawyers,
Were
in
they
other
seen
words,
as
did a good
victims?
job in excluding certain things, and Mr. Brooks over here
Going
is
to
currently
object
trying
to
to
the
undermine
form of
that by
question. I
asking
think it calls for
questions
a
that are
legal
going to
conclusion,
even
Your Honor.
prejudice him even
It
more.
was not. I asked to his knowledge.
Karina Edlin says, you know you've screwed up
I'll
when your own
sustain
mother provides
the
evidence
objection
against
as to
you.
the form of the question, if you could please refrain.
Yep. So he can't answer that question as long as the ruling is in place.
I'm gonna go a different route.
So all yeah, if he opens the door, it can't be used as grounds for appeal. That's true. So the prosecutor could respond by saying, you know, he opened the door, so let the question in. So you could view it as waiver, but the
Recall-
prosecution objected to it for whatever reason. They don't want to go there either,
Do you
apparently,
recall serving?
which makes
warrant
sense in some ways. They don't want to
to Waukesha
undermine
County
his.
Jail on July 1st of 2022?
They want to undermine what his competent lawyers did.
Yes, I do.
Do you
you
recall
know,
what that was for?
If an attorney did that, they'd whack you around with it. But
Yes, I do.
they're gonna.
And what was that for?
They're playing
Can you
it
state
safe,
for the
which is
record
fine.
For the jury.
It's for Mr. Brooks's jail cell.
And why did you serve a warrant for a jail cell?
Your Honor, I object pursuant to legal rulings previously issued in this case. I don't think this is relevant.
I'll sustain the objection. It's not relevant. I'll certainly take it up at a later point if need be.
What was the warrant pursuant to?
I sustain the objection. Next topic, please.
He did answer.
I sustain the state's objection. I'm directing him not to answer. We'll take it up separately. I'll have you continue with your cross-examine. I'll take it up later.
You made reference to this vehicle driving into you, but stated you were not injured. Did you file a claim in this matter?
No, I did not.
Do you consider yourself an injured party in this matter?
No, I do not.
You
Do
to
you
become a member of this
yourself
channel,
know
you hit the
anyone
join
filed a
button,
claim
you
in
hit
this
the
matter?
link in the description, you hit the link that the bot tells you about to hit
Can you be
to
more
become a
specific?
member.
Do you
the
yourself
join
know
button.
if anyone filed a claim in this matter?
Just in general?
Whatever your interpretation of that will be.
I would say yes.
And do you know what that claim was?
I would imagine that there was a lot of injuries from the people. A lot of people had very extensive medical bills. I would imagine that they would file a claim with their insurance company to have those bills paid.
Good answer.
So you had knowledge of what was filed to their particular insurance companies?
I have no knowledge, but my assumption is that they would have filed those bills.
So it'd be fair to say you don't know for sure.
That was my testimony.
Is that the answer?
Yes.
Yes. Not interested says, I always want to think people are intelligent, but mom, we all think that now. I'm not sure the problem is that Darrell Brooks isn't intelligent, because I think he's intelligent, at least in the legal sense of the word. Intelligence is not his problem. The problem is that he's obstinate child. He's competent.
As lead investigator,
He
for
just
this matter,
chooses to be an obstinate, petulant child.
to your knowledge, aware of any
So, yeah.
GoFundMe type of things? in
Objection
relation to-
relevant? I'm sorry.
Do you mean as it relates
As it
to
relates to the incident?
overruled? The witness may answer.
I have no direct knowledge, but I assume that there are some GoFundMe.
He probably has an average IQ or slightly
Could've done
better, if
something
I'd
like
guess.
this.
And
I
what
don't
do you
find
mean
him
by
to be mentally
typical? You've seen
deficient.
this before? Is that what you mean by typical?
We have a very loving and caring community where a lot of times when bad things happen to people, people pull together and offer financial assistance to help people.
Is it fair to say that there's a lot of communities like that across Wisconsin?
Yes, I think there are.
And it would be fair to say that you've worked extremely close with the district attorney's office during the entirety of this matter. Would that be fair to say?
The district attorney's office has been involved in this investigation since the night of, so we have worked closely.
So would it be fair to say extremely close, seeing as how you've been present for the whole trial pretty much?
Can you define extremely for me?
I would like you to define it extremely.
I'll answer yes if that helps.
Yukiro Taco Bell, anybody?
To your knowledge, do you know if it's typical for a lead investigator to sit right behind the prosecution table at a trial?
Yes, it's very typical. It happens in most larger cases, especially a case of this magnitude. There would be a court officer. So yes, that's a very typical thing that happens.
Have you ever done this before?
I've done this multiple times before.
And are you the only detective in the investigation that has that honor?
Objection vague.
Grounds.
Sustained as to the form of the question.
Are you the only detective directly involved in an investigation that sits with the prosecution?
Talking about this case or any case?
This particular case.
I'm sorry, you interrupted me. Could you repeat that, please?
I believe he said this case.
I'm referring to this case, yes.
Could you re-ask the question, please?
Are you the only detective actively involved in this investigation that sits with the prosecution in reference to this case?
Yes, I'm the only person, the only detective that's sitting with the prosecution during this trial.
So would you explain who the other officer is in the blue suit over there?
Objection to the relevance, Your Honor.
Grounds.
Sustained.
I just want to know his role.
Sustained. Next
Reason
question,
for the
please.
sustain.
Not relevant.
He's been in the courtroom the whole trial. How is it not relevant?
Mr. Brooks, next question, please.
Nobody knows who he is. That should be known. Nobody should
It's
know
not
that
relevant to
I
the
don't even
issues
have
that the
that
jury needs to determine. Next
That's
question,
right. It's not
sir.
relevant. It's not even close to relevant.
Action or telling? I'm assuming that's asking. You know what the other one would entail.
Do you have a question, sir?
Yeah, I do. I would like to get to it. Thank you.
Please do so. Thank you.
I will.
Oh, shit. Here we go again.
So seeing as how you sat with the prosecution for the entirety of this matter, it would be fair to assume that you know who the plaintiff is in this matter.
Yes, I do.
And who would the plaintiff be in this matter?
The state of Wisconsin.
Is that an entity or a living human being?
Objection.
It's an entity.
How can an entity file a claim?
Objection,
Grounds.
legal conclusion.
Grounds.
Sustained.
Oh, shit.
You are
Here we go again.
aware that only a living, breathing human being
Oh,
can
shit.
actually file a claim.
Here we go again.
An entity cannot walk into anywhere and file a claim if it's not even a real person.
Objection.
You are
move to
aware of
strike-
that, right?
Go ahead, Attorney Upper.
No,
strike the
God!
statements
No,
by
God, please,
Mr.
no,
Brooks.
no,
Also object to the
no,
question that was
no.
asked at the end is irrelevant, argumentative, and calling for a legal conclusion.
Objection is not calling for a
The-
legal conclusion in any
The
way.
court sustains the objection. The request to strike the statements made by Mr. Brooks are granted, or the request is granted. The jury will disregard the statement and the question asked for all of the reasons indicated by the state. It also is a misstatement of the law.
No, I definitely object to that, Your Honor.
Your objection is noted. I'm going to have the jury stand for a second. They've been sitting for quite some time, and then you can formulate your next question.
I'll take exception to that ruling. Like the legal finding of fact.
Your objection is noted. It's overruled.
Go suck a dick, suck a dick, suck a motherfucking dick, suck a dick, suck a huge or
That's
small.
judicial determination.
I think you be seated. Go ahead, Mr. Brooks. Please continue with your questioning.
Have you ever had any interactions with this entity, state of Wisconsin?
Mr. Brooks, under 906.11, I'm not going to allow the witness to answer. It's vague.
There was no objection.
Under
It's a sua sponte
906.11,
objection.
I shall exercise reasonable control over the mode and order of interrogating witnesses. Please, next topic.
The judge can
These
object.
questions we addressed during the initial cross.
She doesn't need the parties to object. She can just object herself.
They weren't relevant. So next topic, please.
She can ask questions. She can
Under
object herself.
906.11,
Judges
sir,
have
please move
judges
on
have
to
lots
a
of
new
power.
topic.
They're gonna keep coming
to
in.
be like,
For the
yeah, no, you can't do that.
cross-examination, I will end.
Do you
No one
see-
objected,
do you
I'm
see the state of
objecting.
Wisconsin president in the courtroom today?
Objection, argumentative,
Grounds.
irrelevant.
Sustained. Final warning, sir. Next topic or the cross-examination, I will.
You
Bring
don't
it to an
gotta
end.
keep doing that. You don't gotta.
Yes,
keep
she
doing
does. She does. She has to
My
warn you.
responsibility, sir, over this
it.
trial.
I'm informed.
Thank you.
And I
Next
respect
topic.
that. But it's relevant for the jury to know the truth. They deserve to know the truth.
Move to strike, Your Honor.
Granted, the jury will disregard
Regret.
those last statements. They're
Objection
not
to that.
relevant. Mr. Brooks is not testifying. They misstate the law.
I object to that. That's not lawful law. It's not
Noted.
truthful.
That's
All right,
not lawful law. That's a
906.11,
new one. I haven't heard. I didn't know that objection. I missed that one in
stopping
law
the
school.
cross-examination
That's a new one for me.
and
That's not
by the
lawful
state.
law. Okay.
Objection to that.
Thanks,
And I would
Mr.
like
Brooks,
to
teaching me,
find the fact.
providing some quality legal
Uh,
education
Attorney
over here
Albright,
today.
direct?
Yes, just very briefly, Your Honor, I would like to display for the witness only exhibit 178.
Objection.
I haven't seen the exhibit yet, so take
Well,
it under
I'm
advisement.
objecting still because
You may show it to the witness.
there needs to be an answer to why the jury's not being told information that they deserve to know.
They don't deserve to know.
Go ahead, Attorney Alford.
Your Honor, for the record, this is a video. I'm going to play about the first 5 or 10 seconds for the witness to identify it before moving on, please.
And this seems objection because this seems like a whole new exhibit. This was never mentioned before. It was never.
I haven't seen it. I can't rule on it, sir, so let me
I mean,
see it, and I'll
when
take
did
your
it become an
objection
exhibit?
under, I'll
It
take the
was never an
objection
exhibit
under
before.
advisement. Go ahead.
I haven't seen this in any of the exhibits that I have. So how could it just be created now and be made an exhibit?
No, God!
Go
No,
ahead,
God,
have all the
please,
exhibits.
no,
Go
no!
ahead, Attorney Alford. I haven't
No!
seen it yet. There's nothing on my
No!
screen that I can see. I see it's now playing.
So now we just creating exhibits now. I have all the exhibits, and this was never in it. Oh man.
Lisa Kaufman says this is requiring view from soft. I don't know what will help soft sits.
All right, you can stop.
I feel for you, Madam Prosecutor.
Sir,
I
do
really
you-
do.
Recognize what's contained in State's Exhibit 178.
I feel for you on
Objection.
levels.
Overruled.
Relevancy.
The prosecutor is having a rough go,
Leave it
man.
and
I feel
answer.
for you.
Yes, I do.
I feel for you.
What is it?
Stay strong.
Objection leading.
Overruled. The witness may answer.
I'm still gonna object. How's it? I
Mr.
have
Brooks, I
all-
ask that you
I
honor
have all
the ruling that
I
I've
have
been
all the
made.
exhibits though, Your Honor. I have them
Mr.
all.
Brooks.
They were provided to me and this was never in the exhibit, so how could it just be made an exhibit?
I'll take
just
this
out of
up
the blue?
outside the presence of the jury, but I'm gonna allow it.
Can that be stated for the record? Can that be explained?
No, the jury will disregard the statements made by Mr. Brooks. They're not evidence. And the statement
So this
continue.
exhibit shouldn't be evidence then, because it
Mr.
didn't
Brooks, the
exist before
objection's
today.
noted. It's overruled. Go ahead.
I'm gonna get myself some coffee liqueur, I think.
There was a still photo shown before of Mr. Brooks
This is
standing in front of the
mind-boggling.
Ford Escape. This is the video in which that still photo was taken from.
You could-
Objection, how does he know that?
Overruled. The witness may answer. I'll give you the opportunity to question him about it when the state's done asking the questions. Go ahead.
Where'd you get this video from, sir?
Objection leading.
Overruled. The witness may answer.
From Mr. Brooks' social media account.
There you go.
Your Honor, move to admit 178 and permission to publish.
Objection to the relevancy.
I'll
And
find that
still
it's
don't know how
relevant.
this
I'll
obtained.
receive Exhibit 168. Permission to publish is granted. For the record.
It's
Could you please-
178, Your Honor.
No, could you please tell me the length of the video?
The length is 2 minutes, 33 seconds. We're going to play it in its entirety, but without volume, Your Honor.
All right, thank you.
And
I object to that, and I would like to make an offer of proof for my appeal.
We'll do that outside the presence of the jury, but I will allow the state to play it in its entirety without
Your
audio.
Honor, I have.
He said
all the
offer of proof.
exhibits
That's actually a
that were
thing.
provided.
Mr. Brooks, I'll
Who
take
taught
that
him
up
words?
Along with the other
Who's-
two issues, I still.
Which
need
of you
to-
guys is
But how
teaching
can
him
you play
words?
something that's
Who
not-
taught
that
him
I
offer of
didn't
Mr.
proof?
Brooks, I'll take that up.
Which of you guys is
outside the
responsible for
presence of the
this?
jury.
This
Your
is
objections are
mind-boggling.
noted.
This is
It's
mind-boggling.
overruled.
Mind-boggling.
actually, Your Honor, I changed my mind. I would like to play the audio, please.
This is mind-boggling.
I want to have it played first.
Well,
without-
it's mind
and I'll make a
melting.
ruling And I'll take that up.
Okay, I understand.
Thank you.
So we will play the entire video, Your Honor, 2 minutes, 33 seconds.
Is this the video? Is this the rap video?
Why does the whole video?
Oh my God.
Is this setting the foundation?
It's relevant. You questioned the officer about it. You
I
questioned this
question him
detective
about,
about
I
his
question him
knowledge.
about the steel frame from the video. The video wasn't even in the exhibits that I received.
The jury, the sound is up.
Actually,
We
didn't
can't hear
receive
it.
They
Mr.
were
Brooks, please
obtained.
stop. The jury will disregard his statements. He's not testifying. The video's playing.
Oh my God. The jury is actually listening to this song? Wow. Why can't we hear it? That's disappointing. Yeah, there's shots of him. There's shots of him with him face to the camera without him holding a gun. I'm not sure why they used the shot they did. There are other shots they could have done that would have shown his face, I think.
We address why it is.
She said played it without sound at first, she did, and then she said I changed my mind and want to play it with sound. So I don't know what's going on exactly. Did he open the door? You know, actually, I'm not really sure that strictly speaking, he opened the door. I think this ruling might technically be wrong. Not that I care, because but it's a grounds of appeal. It is a grounds of appeal. I think I might disagree that that he opened the door by the way in the manner of his question. But as a court of appeals, I can't be bothered. As a trial judge, and I also can't blame her because she's worn down. Judges make mistakes too because they're human and they're worn down.
Go ahead.
So I'm
attorney,
not
after the
strictly
video's finished
speaking
playing.
sure that
Thank
was
you, sir.
legally
Did you
correct.
see during the playing of that video the image that was captured as a screenshot and presented to you in your direct testimony as states exhibit number 175?
Objection leading.
Overruled. Foundational. The witness may answer.
Yes, I
A
did.
lot of.
You were questioned on cross-examination as to your ability to identify Mr. Brooks in exhibit 175, correct?
Objection. That question was asked initially by Attorney Hopper.
Overruled. The
Yeah.
witness may answer. Sorry.
Yes, I was.
As you just watched the entire video.
But the judge
again
could
now
always, of
in
course,
court,
Change
as
their
states
mind.
Exhibit 178, did you
Right.
clearly see Mr. Brooks? in
Right.
that
So during the
video,
break,
sir?
the judge could say, I shouldn't have done that.
Overruled. The
And so
witness
I'm
may
going
answer.
to I'm going to strike
I
it
believe
and
there's no
instruct
doubt
the
that
jury to
that's Mr. Brooks
disregard.
in the video,
And then the
they
Court of Appeals
understand
really
this
won't
is
care.
for escape.
Thank you. I don't have any other questions, Your Honor.
As to this particular piece of evidence only, Mr. Brooks, you may ask questions of Detective Casey.
Objection. I don't consent to being called that name. And yeah,
Noted.
I
Do you
got
have
a
any
question.
questions for the witness?
This when did this video? When was this made a exhibit? Because I don't have it.
Just now.
Objection, that's not a question for the witness, Your Honor.
That
Sustained.
was a question. The question.
The
Sustained.
witness
Reached
says
as in the
no
form
one
of
has
the
made an exhibit.
question.
When was this video made an exhibit? That is a question.
It's not a question he knows the
Object
answer
the
to.
question directed at the witness, Your Honor. It's beyond the scope of his knowledge.
Sustained.
Well, he said he saw it.
That's not when it
the
made.
question.
That's not the
So
question.
You can rephrase your question if you want to.
When did you see this exhibit?
There
When
you
did you
go.
see it?
With the understanding that you're asking when did he see the video, I will
When
allow
did
the
you see
question
this
to be
exhibit?
asked. With that understanding, you may answer Detective Casey.
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table?
I'm
It would be the same thing. I'll take that as disrespect because they were allowed to say something and I said under my breath that was disrespect.
I
They
would
just
direct
did the
both
same
parties
thing.
to avoid commentary.
Okay, well, can
and
you do that,
gestures
please, and
faces.
admonish them?
Yes,
Because
I
I'm
will.
always the one getting
Absolutely.
admonished.
Everyone.
I take that as disrespect too.
Sir, I'm good. Can I do my job? State's directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
All these
the
cameras in
witness.
here, don't nobody
However,
see nothing.
I'm advising both parties to show
Come on, man,
decorum
this is not fair.
and restraint, to be
I'm with-
respectful of this jury's time and attention, and to let them do their job by focusing on the testimony and exhibits and
You go,
evidence that's
girl.
presented.
You're the best judge. You
ahead,
go, girl.
Detective
Get it.
Casey. You can
You get
answer
it.
the question about when you have seen this video prior to today.
I saw the video within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times before yesterday and today, why did you feel the need to view it yesterday and today?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
Why did you need to review it this morning?
Objection, argumentative.
Overruled, the witness may answer.
Because I wanted to be 100% sure of the content, and if there's any questions that were asked of it, I wanted to make sure that I would be able to answer them appropriately.
And why was this, to your knowledge, why was this video never brought up in your earlier testimony?
Objection,
Because it's
that's
unduly
Wow.
prejudicial.
Sustained
It was
as to the
not
form
brought
of
up
the
in
question
your
assumes
testimony.
facts not in evidence.
So do you
If
want
you
it
had
admitted
seen
or
it
not?
numerous
What
times
position
before
are you taking
today,
at this point?
Why did you need to see it again to make sure if any questions were asked or however you refer to it, what would be the need to view again this morning something that you have viewed
I need to order more
numerous
beer.
times before?
I'll see what I
Hold on. Objection, compound, asked and answered, misstatement of the facts, argumentative.
Sustained.
Did you
Going
view the
into my
video
app
this
and I'm
morning
ordering
because
more
you
beer.
knew that the video would be made an exhibit this morning?
Objection, assumes facts, not in evidence.
Sustained. As to the form of the question.
This is mine, Bible.
Is it mind-boggling?
Can you clarify again why you viewed the video this morning?
Objection, asked and answered.
Sustained.
So you're gonna sustain everything?
It was already answered, sir. Next question, please.
And I'm asking for clarification.
Next question, please.
I don't got no more questions, man.
Thank you.
This is mine, Bible.
Detective, you may step down. I'll excuse the jury.
What you people was trying to do is not fair. Hide things from the jury repeatedly. You don't tell them all the information
Mr.
they
Brooks,
need
I'm
to
going
know.
to take up all of your objections outside the presence of the jury. I ask that you honor my decision to do that and you show courtesy and decorum.
Because you asked.
Mr. Brooks, please.
Because you asked. That's the only reason, because you asked.
I'm getting some coffee liqueur.
I see
Cold
what
brew
you
coffee
people are
liqueur,
trying to do.
excellent.
It's not right.
I'm gonna start doing shots
It's
of
not fair
that.
and it's not right.
You can have a seat. Well, once the jury's outside of the courtroom, I'll take up the objections previously in the evidence.
All right. First of all, Attorney Hopper, if you can make a record as to this exhibit and whether it's been turned over previously.
It was previously included in the initial discovery that was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection, I don't consent to being called that.
The
name
reason he
because
won't
it's
accept his
not
name is because
in the
sovereign
video
citizen
footage
bullshit.
that I
It
have
doesn't. Don't worry about it.
obtained.
I'd explain it,
That
but you become
video
dumber,
was not
and I'm trying not
part
to
of
create
it.
harm.
Do you think
Over
I
here.
would sit here and be
Just note some
this
sovereign citizen
irritated?
bullshit.
Mr. Brooks, I need to
something
make
that I
a
saw.
record, so just please sit down.
Avery,
There's no
the
need
judge
to
said no
stand
volume
at
at
the
first, and then
moment.
add if
Feel like
need be.
saying
I missed that. I
Please
missed
sit
that.
down.
The judge
Feel
saying
like
that. So fair enough. I missed that part of the
All right,
judge
based
saying
upon the
that.
offer of proof provided by the state.
thank you.
And it was provided to prior counsel.
I'm also going to get this Jägermeister cold brew coffee. I don't know what this is,
Issue.
but we're going to give that a shot and see if that's the answer to my
I
drinking,
indicated I would-
my drinking drift, my
prior
drinking needs.
testify to that then? Because
Not at this time,
I
sir.
have not obtained that.
Um,
Right now, that was my first time seeing that as an exhibit.
Mr.
That's why I
Brooks, I
raised the
presume, and you can correct me if I'm wrong, but you're familiar with that video? Yes or no?
What does that have to do with what we're talking
Because
about?
I'm gonna make a finding based upon what I viewed in that video, that there is absolutely no surprise to you. It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video is relevant for a number of different reasons. The first of which, it goes to identification of you, identification of the vehicle. You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. And when I say
Tomorrow.
identification of you, specifically as it relates to Detective Casey's opinion that that's you in the video, of course, it's ultimately up to the jury to determine that. And what relevance, if any, that evidence have, but you opened up the door for the state to show that video because you directly attacked the credibility.
It's
of
something like that,
Detective Casey,
Glassbell. It's something like
through
that.
his knowledge of it and the identification by him of you in it, because the still image was of your back.
Okay.
So
if-
that opened up
$5
the
from
door,
Lisa Kaufman.
and
A
it's
reasonable jury might
proper.
find him guilty just for paying
There's
suffering there during this
absolutely no
trial.
surprise to you that that video
Yeah.
exists. And that is my finding as it
What do you
relates to
mean by
that.
it's no surprise to me that it exists? That was not the issue. The issue was how was it made an exhibit at the last moment? How does it be made an exhibit out of the blue? That was the issue. The issue
State can
didn't
make an
have
offer of
anything to
proof
do
on
with.
that because obviously they marked it as an exhibit.
But with all
So
respect,
go
Your
ahead,
Honor, you're
Attorney Opera.
mischaracterizing what I said, and that the record needs to be clear. The issue that I raised was how does this, at the last minute, out of the blue, become an exhibit?
Attorney
That
Opera,
was the
go ahead
issue.
and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well
Objection,
aware.
he said social
There's
media. He
nothing
didn't
that
say what it was.
Sir, stop interrupting. We have to make a record of it. You've
Then make the record clear.
interrupted multiple times. I've been abundantly
Make
patient
the record
with
clear.
you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at
asking me to be
me.
quiet?
Stop rolling your eyes at
Are
me.
you asking?
Stop
I'm looking
mumbling.
right at you. I'm not rolling my eyes.
No, you
I'm
have
looking.
throughout. I've seen it
I'm
and I've
looking.
made note
I'm
of
looking
it.
at you. Okay, so are you asking me to be quiet or are you telling me to be quiet?
Both.
Go ahead, Attorney Opera.
Thank you, Your
I'm
Honor.
gonna take that
And
as
just to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him to sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor, and we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video, which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did because he pushed it again, and his voice and his mannerism of speech, I thought would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant who continues
The prosecutor's
to
saying, thank you from saving me
suggest
from myself.
and impugn the integrity of
prosecutor
this
knows.
court and this prosecution.
Prosecutor knows, because
Without
prosecutor's a smart
basis.
prosecutor.
He doesn't like it
Judge, thank you
because
for saving me from
the evidence
myself.
is stacking up and stacking up. And whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So
She's
I
right.
apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks because, again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion.
Exhibit,
So-
exhibit, exhibit,
He
exhit.
can object all he
Exhibity,
wants, and he
exhibity,
has
exhibity,
made that
exhibity.
clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception. I apologize for my tone, Judge.
Thank you. I appreciate that additional record being made.
I object to that.
My
I'm sure you
previous
do.
ruling doesn't change in any way that the exhibit is relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court that it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands. I do want to take up two other issues. There was an objection to questions regarding cross-examination. So the objections were by the state. One had to do with there was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction? I believe it was with your mom and possible testimony of your niece and nephew.
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you withdrawing that, sir?
How am I supposed to know? I think I deserve a chance to rebut what was just said. I think I deserve that much if it's in their trial.
She's saying, I'll
What
recall him.
information do you want to provide to me about
I'll
that
recall him.
last
He can be
incident?
back on the
About
stand.
what
We can
last
do
incident?
that.
I'm talking about the audacity of the prosecution to just put that on the record when it's stating it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight. Now don't nobody know what I'm talking about.
I don't
There
know
was a reference made
specifically
to-
what you're
There's
talking
a
about,
reference
sir.
made to what I'm supposed to know about the evidence stacking up and this and that, as if that. has
Ooh, that was
any
almost a
bearing on
rap
what I
lyric.
still think
Stacking
and what
up
I'm
and if
still
this
gonna
and
present.
that.
It
Man, his
doesn't.
freestyle rap is
That's
on
not what we're
game.
talking about at the moment. I made a ruling
She's
on an
been
exhibit.
laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
I
for her to sit there-
haven't made any of those observations,
I didn't
sir.
say
What
you.
I've
I didn't say
observed.
you, Your Honor.
No,
But
what I've
for
observed
her,
is
for
as.
her, listen, please.
Go ahead.
For her to sit there and try to play it off as if she's not referencing to me, she must think I'm an idiot.
Nobody
That is
said
very
sir.
disrespectful to me. I haven't said anything about that until today. She's done it numerous times.
Emotional
I don't
damage.
know what you're
Laughing
saying.
under her breath. Her trying to cover up the microphone so they can laugh and hee and key. That they've been doing that the whole time.
Huh?
I didn't say anything. I didn't say
sir,
anything
because
about
I
it.
have not noticed that. What I notice are
Huh?
three attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary
Huh?
issues or about testimony.
So why is it always laughing and giggling?
I
involved
haven't
with that?
noticed that other than the one thing you pointed out.
Well, we
today,
have
which
we
then-
have cameras. That's what the
Mr.
cameras are
Brooks,
for.
let's refocus our attention on what we're here for, and that's
Okay,
this
then
trial.
I take
And
that
do
as
you have
I
anything you
take
want to
that
put on
as-
the record?
I'm putting it on the record
As
if I
it
get a
relates, no,
chance.
you need to let me finish. As it relates to the video and my decision to admit
She
it.
just admitted that she just now came with the exhibit. It was not that she just said she just made it an exhibit. It
That
was
doesn't
not
mean
an
it wasn't
exhibit
turned
before she
over to
made
you.
it one.
So do you have some legal basis, sir, for your position? Because I'm not
What do
aware
I
of any.
need legal basis for when she just admitted on the record that she just made this exhibit up
No,
right
she
now?
didn't. That is a complete mischaracterization, sir. She did not.
That's what. So she wasn't
Create
implying that by
the
saying that she can
She did
pull
not make
anything
it up.
out of her suitcase.
So that's a figure of
During,
speech.
okay, so what is
Right.
it implying to? What would that be implying to?
As
How would
attorney,
anyone-
all
how
right,
would
I'm
anyone in
moving
my
on
position-
because you're not
How
providing me
would-
with
How
any
would
legal
any-
basis
I didn't even
for
finish.
me
You
to.
told me that I can make the record. I'm attempting to make the record.
Sir, as it relates to the video and my decision to admit it. do you
I
have
just said that. You didn't even let me
You're
finish.
not letting me
You
finish.
didn't let me finish either, Your Honor.
Because you're not providing me.
But how do you know I
you're
wouldn't get to
providing
that if
commentary,
anybody
You're not providing me with anything from a legal basis for which I would consider changing my mind. So the state's withdrawn their request to play the audio.
Then why play the video at all then?
I've already made a ruling on that. You're questioning the ruling. You're not asking me to reconsider it based on any legal basis.
There should be a legal reconsideration of it.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yes,
That's ridiculous.
you're representing yourself. It's not ridiculous.
It is ridiculous. So I was supposed to already come in here this morning and say, oh, a video is going to be shown off the fly at the drop of a hat. Let me try to find some legal thing to combat. How am I supposed to do that?
The bottom line is you opened the door to
It
the
doesn't.
playing
It
of that
doesn't.
video.
We're not talking about
And the
opening
video
no
was
doors.
previously provided to you during
We're
discovery.
not talking
There's
about opening no doors. We're talking about being fair.
There's
Because
absolutely
if I
no
would have did
prejudice
that,
to
Your
you
Honor,
in
with all
terms
due
of
respect,
surprise.
with
by
all
that
due respect,
exhibit.
if I had
Right.
done that,
I am going to move on.
if
from
I
this
had done
topic.
that, it would have
Mr.
been a
Brooks,
big
I'm
thing.
advising you.
Are you
that
asking
you
me?
need. I'm advising you, sir.
Oh, okay.
I'm
I don't know what that
advising you
means.
to sit down
I
and
don't
be
know what that
quiet.
means.
And if you interrupt me again, you are on notice that you will forfeit your right to be present
So
in
you're
this
holding me in
trial.
contempt
Mr.
for the
Brooks,
entire trial? Did you say the entire trial?
I never said any such
You said
thing.
for the trial. So what do
Please?
you mean? I'm asking. What do you
Mr.
mean?
Brooks, you continue to
That is
come at
not.
me.
I don't consent to being called
You
that name.
continue to fight with me.
I'm
You
not
are
fighting
being
with you.
disrespectful.
I'm not fighting with you. I'm not.
I'm
But
going to give
you
you
said I
one
would have
last
the chance to make the
opportunity to
record.
sit down and be quiet so I can make a finding
Are you
as it
asking
relates
me
to
to
other
do
facts.
that? Are you asking me
I don't
to
need
do
to
that?
ask, I'm telling you. Thank you. There were two other issues that came up that I advised the parties I would take up outside the presence of the jury and give, if appropriate, Mr. Brooks the opportunity to ask further questions of Detective Casey. There was questioning by Mr. Brooks about possible testimony and why it had to do with it was in the context of him questioning Detective Casey about speaking with Dawn Woods, his mother, and about a time in August. And there was some reference to his niece and nephew. And I sustained the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Casey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Casey about either one of these two topics is my first question.
Okay, why was it an issue with me bringing this?
Mr. Brooks, I'm only going to ask you one more time, and if you
I'm
don't
saying
answer
if I don't
correctly,
understand,
then I
if I
will
don't understand what was the problem in the get-go with the question, how am I supposed to answer it now?
Mr. Brooks, listen to me, please. I'm going to ask this question one more time.
Man,
It calls for
I
a
don't like
yes or
I don't
no.
like your tone and the way you're talking to me. I don't.
Mr.
I don't
Brooks,
appreciate it.
sit down. I don't care if you
No,
don't like my
I'm
tone,
not
but
gonna-
you've
I'm
been
not gonna
pushing
sit
my
down.
buttons all day throughout this entire
Okay, you've been
trial, and
pushing
I
my
have
buttons
showed
too?
the utmost of respect
No,
for
you
you,
haven't.
and I don't
Absolutely
appreciate
not.
you impugning the integrity of this court.
If that's
I
what you want to
don't.
call it, that's fine, but it's
Stop
not accurate.
talking.
What you mean stop talking?
I need to make a ruling. Okay,
Well,
I'm purposely
let's
not
talk-
putting
let's
you in
talk
the
to-
other courtroom
Let's
right
talk to each
now.
other like adults then.
Mr.
Because
Brooks,
I've never told you to stop talking.
I'm going to ask this question one more time, and if he doesn't answer it, I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the search of your jail cell? Yes or no?
What was the problem with me asking the
All
question
right,
about the
he's
jail
not answered
cell?
my question. We'll move on.
I'm
not
trying
giving
to
that
understand. If I
opportunity. All
don't
right, we're gonna take a
understand,
break.
how do
We're
I
in
know?
recess, 15 minutes
How do
from
I
now.
know
Take
what
care,
I'm supposed to
everyone.
answer if I don't understand? And I don't agree to a stop.
She is a fantastic judge, Lisa. She is a fantastic judge. She is a great judge. I could not disagree more. She is a great judge. She's a fantastic judge. There are other judging styles that would be fine as well, but she is a fantastic judge. They're going to search a cell? No, they already did search a cell. There was a search and there was some question about whatever was, I don't know what's going on. Yeah, I don't know what's going on. Yeah, the judge is a little hot. The judge is fine. The judge is absolutely fine. The judge is a great judge and doing a great job in every way. Why was she going to allow the questioning? All right. So so there was a question. All right. Why was she going to allow the question? She was trying to get to whether or not he wants to. She wasn't necessarily going to allow it. She wasn't necessarily going to allow it. But the first question is, do you want to? Right? Okay. So let me tell you what happened and what happened in normal law land. Okay. Let me tell you what happened and what the judge is trying to do and what's going on, so we can provide some sort of legal education. Okay. So he said, I'd like to make an offer of proof. That's actually a legal thing. All right. So the judge makes a ruling, like, I don't want this in, you can't ask that question, or you can't call this witness or whatever, right? So the judge makes a hostile ruling to you as a lawyer. It's like, you can't call this witness, you can't ask that question, right? And also it's something you can do as a lawyer. Okay, so there's two ways that this can happen. Let's discuss what an offer of proof is. All right. An offer of proof is what a witness would say, right? So what you're doing as a lawyer when you're making an offer of proof is, what you're saying is, here's what a witness would say. And you know that because, of course, you've done your due diligence, you've talked to these people, you know what they know, right? So you're not making it up out of nothing, right? You're making an offer of proof. Like, here is what a witness would say. So there's two ways an offer of proof can come up, right? There's two ways an offer of proof can come up, right? You as a lawyer do it in the first instance, right? So you're questioning a witness about something that there is not evidence in the record for yet, but there could be, but it's not in the record yet. So basically, it's a way of bridging the gap. And the reason why it might not be in the record yet is because perhaps it's coming from a later witness. And the reason why that later witness wasn't called first is because, well, there's reasons to offer witnesses in particular orders. And also, this is not necessarily solvable, right? There might be a mutuality problem, right? So it might be the one witness in part depends on the other. So it's not necessarily solvable. So there's strategic reasons to call witnesses in particular orders, right? And it might not be possible to avoid the issue. So, like, I want to ask you a question about something that is not yet in evidence. This would come up for expert evidence, for example. So what would be an example I could create off the top of my head? Let's suppose, okay, here's a good one. All right, here's one. Let's suppose there's a video in which we hear people's voices, okay? And one of the voices in the trial has not yet been identified. And so, but I as a lawyer do have an expert witness. I do have an expert witness who I know will testify as to that witness's identification, right? They've done the audio work, they've done the work, they know that. Or I have a witness in the future who can testify to it because they know the person, right? So they know the person's voice, or they're an expert, right? I have some person who can testify that is the voice of so-and-so, right? But that testimony has not been offered. So let's suppose there's some video that involves multiple different people, and maybe there's a question as to whether or not there's a third person, right? So we see two people, we see a video of two people, and we hear another voice. And maybe the person's back is to the camera, right? So we can't see them speaking, right? So the question might be, who's speaking, right? But it's a different voice. And so one of the things might be, okay, that isn't the voice of that person. That's the voice of a person who's not on the camera, but their voice is being captured, right? So what I could do is I could say, all right, I want to make an offer of proof there's a third person in the room. right? I want to make an offer of proof. There's a third person in the room, and the sound technician will testify, or so and so would testify. That's the voice of so and so, right? So I'm making an evidentiary bridge by saying that, right? And you can say, well, I object because that's not available. It's like, well, it's available later, and then I can connect the dots, right? I can fill that in later. So it's a way of a lawyer bringing in future testimony now. So that's offer of proof number one, right? I'm making offer of proof as to what witnesses in the future will say, because I need that piece of evidence now, but it's not available now, and I couldn't get it earlier because of insert various reasons. Okay, so that's option number one as an offer of proof. Option number two as an offer of proof is the judge makes a ruling against me, and it's very, very similar, right? It's like, you can't ask that question, you can't call that witness, you can't do that thing, right? And so I'm like, okay, I want to make an offer of proof, right? Because the appellate court only knows what's on the record, right? And so you need to put on the record what the witness would say. So let's suppose that, I don't know, let's suppose that for some reason there's an alibi witness who has been excluded. I don't know. I'm making shit up because I'm having to come up with examples on the fly. So you'll forgive me, my examples are a little half-baked, right? But I'm trying to come up with examples on the fly. Let's suppose there's a witness who I say would be able to testify that I wasn't at the scene of the crime because I was wherever, right? And for whatever reason might be the case, this witness has not been permitted to testify, right? We could imagine examples why, but it doesn't really matter for our purposes why this has happened, right? So I was like, I want to call this witness. Judge says no. It's like, I want to make an offer of proof. Judge says, okay, we'll do that at the next break or at some other opportune time. And so what then you do is you say, okay, here's what the witness would testify to. And you can even, depending on the judge's tolerance, you can even go so far as to have that witness's testimony outside the presence of the jury. So you could even have, depending on the judges, depending on the need and depending on the ability to preserve the record, right? Like, I'm not going to allow this witness in testimony. I'm not going to allow this witness's evidence. I'm not going to allow it to be presented for the jury. But in order to preserve the record as to what the witness would have testified to, right, you can either just state it, which is more common, right? I'm just going to tell you what the witnesses would say, and we'll take it as a given. Or we can actually have the person testify outside the presence of the jury so that we can have all the same sort of thing. And then that testimony is preserved in the record. So then I can go to the Court of Appeals and say, okay, the judge made a mistake by excluding that witness. And more to the point, right? Not only is it a mistake, but here's why it matters. Because here's what they would have testified to, and it would have exonerated me. Right? So I'm showing not only did the judge make a mistake, I'm preserving what the witness would have testified to. So the Court of Appeals has that information because, again, they don't only have what's on the record. So if you don't make it on the record, the Court of Appeals might be like, well, that wouldn't have mattered anyway. Right? Because they all know. Right? So one of the things you want to do is preserve that for the record. So the Court of Appeals can determine, all right, the judge made a mistake and that mistake mattered. So that's another example of an offer of proof. All right. So here's how that came up. So what we're in now is option number two. We're in option number two. And there might be other examples, but these are the two that came to mind. So I'm not saying these are exclusive, but these are the two examples that came to my mind of where you do an offer of proof. So during the detective's testimony, the defendant asked about two things. He asked about the interview with his children, and he asked about a search with the shell. The judge excluded it. And then Brooks said, okay, I want to make an offer of proof. And the judge is like, okay, we'll do that during the break. Great. All right. So now we're getting into an offer of proof, right? And of course, the judge can reverse their own rulings. A judge can reverse their own rulings. So if you make an offer of proof and be like, here's what the witness would have testified about, the judge can be like, ooh, you're right. I shouldn't have excluded that. Recall the witness. Or I shouldn't have allowed that piece of evidence in, right? Because we were debating whether the volume was present to the jury, right? So the judge can reverse their own rulings. The judge could say, you know what, you're right. I shouldn't have allowed that piece of evidence in. That was a mistake. I'm going to strike it from the record and instruct the jury to disregard. Or it can do the exact opposite thing. It's like, you know what, I should have allowed that piece of evidence in. No problem. Let's recall the witness and have them testify about whatever, right? So we can fix this, right? So that's what an offer of proof is. So he's like, okay, I want to make an offer of proof. All right. So step one of the offer of proof is I'd like to ask the witness about those questions. Right? That's kind of step one. Right? I was not allowed to ask those questions. I would like to ask those questions as kind of step one. So the judge couldn't get past step one. So the judge wasn't necessarily saying it would be admissible. The judge wasn't necessarily saying I would allow it. The judge was just pointing out I can, which is correct. The judge is saying I could recall the witness. We could have them testify again. We can fix this problem. If it's a problem we can fix. The witness is right over there. We can call them back. It's something we can fix. If I've made a mistake, it's a mistake we can cure, right? It's curable. So, but step one is, do you want to ask the witness about these things? And the judge couldn't get past step one, right? The judge couldn't get past step one. So the judge was not saying that she would have allowed it or not allowed it. She just wants to know, do you want it? Okay, what do you think the evidence would be? Then here's what the judge's next questions would be. Like, do you want it? Yes. Okay. What do you think the witness would testify to? Insert descriptor of what you think the witness would just say. Based on whatever. Here's what I think the witness would say. Okay. Why is that information relevant? Or why is that whatever? And then you would answer that question and the judge would make a ruling, right? It's like, okay, I am affirming my prior ruling. That's not relevant. Or now that you've explained it to me in further detail, I'm reversing my ruling and we're going to allow it after all, or whatever. But we couldn't get past step one of, do you want the witness to testify to these things? So we failed very early in the process of the offer of proof. So now I have explained what an offer of proof is. I've explained how it's used. I've explained circumstances it's used. I've explained why you do it. I've explained its purposes both for appeal and for trial purposes. So we have once again managed to extract something of legal education out of this complete nightmare shit show. I feel like I've done my uncivil law duty for the day. I have explained a thing. We're all better legally educated about the thing. Yeah. 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 Oh, and by the way, another term for an offer of proof you might hear is proffer. Proffer is another term you might hear, offer of proof. They don't necessarily mean the same thing, but they are you might hear, well, I proffer this. So if you ever hear the term proffer instead of offer, proffer is often a synonym for offer of proof. So proffer is also used in other circumstances beyond an offer of proof, but it's often used as a synonym. So not quite synonymous, but they often are. So if you ever hear the word proffer, then you can think then it might be a synonym for offer of proof. So that's another term that's used for the same thing. Someone said, can you touch on introducing the exhibit mid-trial? Yeah. Nothing is an exhibit until it's... First of all, there are no exhibits before the trial starts. Like, can you create an exhibit mid-trial? Well, to some extent, all exhibits are created mid-trial. So on some level, the objection doesn't even make sense. You're creating this exhibit mid-trial. Yeah, as opposed to what? It's evidence before the trial, but it's not an exhibit until it's offered. So can you create an exhibit mid-trial? Yeah, to some degree, all exhibits are created mid-trial because there's like no alternative. It's like, I want to turn this evidence into exhibit, but like, yeah, can you create an exhibit mid-trial? Yeah, I mean, there's a difference. There's a difference between it being evidence and an exhibit, right? So if the objection was, I've never seen this evidence, right? If the objection is, I've never seen this evidence, that's a whole nother problem, right? I don't know where this evidence is coming from. I've never seen this before. This wasn't disclosed to me. Now we're thinking about potential Brady violations, right? The state has to turn over everything. And, you know, if it's being offered now just for the first time and the defendant's never seen it, well, maybe, but not necessarily, but maybe we have a Brady problem, but not necessarily, right? So just because you've never seen it before doesn't necessarily preclude it from being a problem, but we're thinking along those lines. So I've never seen this evidence before is a problem. I've never seen this exhibit before. On some level, I don't know what you're talking about. Because of course I'm making it for exhibit for the first time, and she's absolutely right. Like I can pull something out of my briefcase and make an exhibit right now. There's nothing law that stops me. Of course not. Right? Your only thing that would stop you is Brady. Basically, it would be the only thing that would stop you. And you know, yeah. So there's no problem there. So yeah. Will it be the distinction between an exhibit and evidence? Just because something is evidence doesn't make it an exhibit. The distinction between evidence and an exhibit is what's offered in court. Something can be evidence without being an exhibit, right? So the police collect all kinds of evidence. The defense has all kinds of evidence. This evidence may or may not be used in court, depending on the rules of evidence, for example, right? It might not be admissible for any number of reasons. It might be inadmissible evidence, right? So if it's inadmissible evidence, it's definitely not going to be an exhibit. What makes the distinction between evidence and exhibit is what is the evidence might be, if you want a way of thinking about evidence, is the pool of all possible information. Exhibits are the information that's being offered at court. There's a distinction, right? And the prosecution doesn't necessarily need to offer things into evidence if they don't want to, even if they could, right? So this is why they say, like, this is one of the reasons that they typically say in the Miranda warning, like, anything you say may be used against you. Because strictly speaking, it doesn't have to be. I mean, there might be a reason the state doesn't want to offer your confession against you. I mean, who knows, right? There's some circumstance somewhere, I'm sure, where, yeah, I mean, you know, because there's nothing of value there would be the obvious, right? You're just ranting and raving and there's nothing particularly interesting there and it's just a distraction or whatever, right? So yeah, just because we have a tape of you talking to the police doesn't necessarily mean we want to use that. So yeah, anything you say may be used against you at court. We don't have to. The tape of the confession, as it were, is evidence. Whether it's an exhibit is up to the parties, right? Well, we're not going to offer that for, you know, whatever reason. That's the distinction between evidence and exhibits. So, yeah. Yeah, there's nothing she can hold over his head. That's right. There's nothing she can hold over his head. Contempt doesn't really make any sense. He's already in custody. He's going to be in jail forever. She can't threaten him with jail time or give him a jail sentence, a sentence of criminal contempt. What would be the point? When's the sentencing? I don't know when that's going to happen. I assume that there still has to be some like post-conviction reports and stuff. So typically sentencing is usually like, it depends, but usually like a month, 2 months after conviction. Unless, you know, you can always waive those things as the defense and just be like, I want to be sentenced now, but he doesn't seem like the kind of guy who wants to do that. Do I know law about family law? Not in particular, nor do I want to. So yeah, it's a total shit show.
The record in State versus Brooks appearances are as they were before.
I think the audio
Yeah, let's do that. All right, let me do that again. We are back on the record. State versus Brooks appearances are as they were before.
I don't consent to being called that name.
I'm sure you don't.
Are there any issues related to exhibits or other things before I bring the jury back out for what I believe will be the state resting?
Thank God.
Your Honor, I do believe that I did check with your clerk. Everything that we have offered and admitted matches what the court has. So I believe we are good on that.
I had one question
sure.
about Exhibit 89, and I don't know if I missed in my notes.
Okay.
What do the parties' notes reflect on whether that was received?
I showed that it was offered and admitted before it's published, or it wasn't published to the jury. But if not, we would move Exhibit 89 into evidence.
And do you recall what Exhibit 89 is?
It's a
Otherwise-
certified bail form.
No, I'm asking.
Oh.
I'm asking Mr. Brooks.
Oh,
So,
sorry.
that was the second of the two bail bonds. Do you have a recollection of whether it was received?
I don't.
All right, and then
I
what was?
know I objected to it.
I'm sure
I
you
know
did.
you objected when it was, I think, displayed for the witness who then testified about it. I'll receive it and also advise the jury. Were there any other exhibits? I have one other issue on evidence and exhibits as well, but are there going to be any other exhibits that we need to tidy up the record in front of the jury with?
I don't believe so. I know at one point, someone caught that we moved, it was either exhibit 175 or 178 into evidence, and the court admitted either 165 or 168 on the record. So I don't know.
So maybe just
I
had a
think you
misspeak.
Yeah.
You have any recollection of that, sir?
She did make a mistake. I remember. She did make a mistake.
Related to what the state just put on the record. Do you know what witness that was?
It's the
That
witness
was,
we just had.
Judge-
Yeah, she made a mistake. I remember.
Look at that. $175 was the screenshot taken from the video. I know I have a note that it was received and published. And you believe I may have just referenced it by the wrong name?
I thought it was 178. I thought you referenced it by the wrong number. So it's either 175. 175 was referenced as 165, or 178 was referenced as 168.
What is 170?
So yeah, this is very, very typical, by the way, at the end of the state's case, right? Because you got to admit everything, right? Because once the state closes, I mean, strictly speaking, you can reopen, but it's a total pain in the ass. And judges hate doing it.
Correct.
What was
They hate doing it, allowing the state to reopen.
178 was the
So
video.
you do want
Oh, that
to,
was the most recent one. Okay.
you really want to avoid that. So it's like you want to make sure, and also, of
What's the
course, state
request
law
then
may
as
not
it
allow
relates
it.
When the jury comes back
So
in?
it's also possible to be a
Right, I
violation of the
just,
state constitution or something like that. So maybe the state can't do it. I don't know.
There's
But
two
either
different
way,
ways
you
to
want to
do
avoid
this.
it. So you want to
I
do all your
can,
cleanup work.
Put on the record.
You want to do all your cleanup work, make sure all your exhibits are there and correct any errors and blah, blah, blah. So we're doing cleanup.
Have all been offered and admitted into evidence.
Cleanup is very typical
And of
because, you know, no
course,
trial's perfect. So you got to
agreed,
do
we
something
just
clean up.
agreed That those are, your records are the same as my records, or we can clarify just if there was some confusion about exhibits 175 and 178 that were shown to the jury this morning. Those 175 and 178 were offered, and the court has admitted those into evidence. So however you want to.
Does the state not get
Sir,
rebuttal?
do you have
No,
any
we have,
Position
state
on
doesn't get
how
rebuttal.
I address this
Well,
in front of
yeah.
the jury?
to reopen their case.
Yeah.
Rebuttal is limited. So yes, the state does get
Those
rebuttal,
objections
but
were
that's
already
different.
addressed. I'm talking
Right.
about how
You
I
can't-
addressed to make sure the jury knows they were received.
You're
by
not
the
as
court.
free in rebuttal as you are in your case in chief.
However you gonna do it.
Right. You
is
can
how
only
gonna
in
do it.
rebuttal, you can only respond to
Okay,
what the
what I
defendant
gotta say
has. So
must
you
matter.
may not be able
Well,
in
what you say
rebuttal
matters, sir,
to
but
offer
the
a new
fact that I've
witness.
already ruled on the
Yeah,
unless it's
admissibility is not
responsive.
something I'm gonna revisit.
So that's why it's different. But yeah, rebuttal is different. But that's a fair
Hold
point.
on,
Thanks for
that
bringing it to my
door's-
attention. I should have
All right,
clarified.
sometimes that door upstairs malfunctions and, all right, I didn't hear the last part of what you said.
Yeah. Rebuttal's only based on
What I
anything he
have to
covered
say
in his
about it
case.
is
And there may not be a
definitely
case because there's a
I
decent
take-
possibility this is all going to go to hell.
Huge objection with that, sir.
It's true.
And that may be your perception, but that is absolutely not true. This court takes your positions on evidence, legal arguments, admissibility, things of that nature. I take all of that quite seriously.
But somehow it's always overruled or discarded.
Sir, can I
No, not always.
keep going because you've interrupted me once again? My perspective on all of this, sir, is when you disagree with a ruling, you interrupt. You try to debate the topic again and again. You make disparaging remarks either directly or under your breath that are audible. Sometimes you roll your eyes. I mean, just previous to the break, you and I were talking over each other. I couldn't really get a word in edgewise. You wanted to debate topics that I've already made decisions on. I wanted to get clarification on whether you wanted to pursue any questioning, for example, with Detective Casey. I gave you multiple opportunities to answer questions directly. You chose not to do that. You directly challenged me about my authority in this courtroom. You refused to sit down repeatedly. Did I raise my voice? I absolutely did. Was I frustrated? I absolutely was. I'm sitting down. My voice is calm. I think the break was good. I hope for all it was good for me. We had a very long morning. It was about 11:30 when we broke. It's now 11:54. I didn't remove you to the other courtroom despite my repeated warnings because frankly I knew I was going to take a break. I just wanted to get through some issues outside the presence of the jury, which is the proper procedure for how to address objections if the record can't be done in a way that when a more full record needs to be made is how I'll put it. And I indicated during the cross-examination of Detective Casey, I would take your objections under advisement. I would address them outside the presence of the jury. You chose not to answer my questions, and so I moved on. Now, with respect to, I want to also address exhibits and the normal course of exhibits coming in a trial. Because I think there's some misunderstanding and certainly confusion on your part, sir, about the exhibit list that I asked the state to file near the beginning. And that was frankly to assist the court and my clerk in keeping track. Most trials, the normal course of action is as long as an exhibit has been provided to a party previously, or in some circumstances, if not, it's rebuttal. We're not quite there yet. That as long as it's been turned over in discovery, oftentimes parties will simply have exhibits marked as they're presented in the course of a trial. There's not a legal requirement unless a judge orders it that would prohibit a party from marking a document that's been already exchanged and having it offered as an exhibit.
That's what I said.
There was nothing improper about what the state did with Exhibit 178. And I want to make that record very, very clear. As Attorney Opper stated, trials are fluid. Things happen. parties can open the door to what might be inadmissible evidence for a variety of reasons. For example, this court made a number of pretrial rulings related to other acts evidence. Even during your cross-examination today, you came awfully close. I had the witness turn to me and pause and say, I don't think I can answer that, in a clear recognition that that witness, Detective Casey, understood his obligation to honor the pretrial rulings. And we moved on from there. I bet that's happened a half a dozen times in this trial. And that's frankly to protect your rights, sir. The door could have been opened a long time ago to the other acts evidence with Erica Patterson. And I frankly kept it out, despite your questions.
Yep. Right. Yep. This is where
So,
judgment
with
judgment
that,
comes into
I
play,
want to
right?
bring the jury
Did he open the door?
back out.
In a technical sense, probably.
I will
The judge
ask
is
the
like,
state-
but I'm not going to say you did.
Um,
This is where judgment comes to play. God bless
I'll
you,
simply
Judge.
just ask the state,
You're
are
probably
there
a better
any,
person than me.
Anything additional the state's offering by way of testimony or exhibits, you can then address the exhibit issue. Then I'll ask the state if the state has any additional witnesses, and the state can officially rest. Given the time of day that it is.
Thank you,
it's,
American Legend, for gifting memberships. I don't
11:58.
get notification of that
I'm not
inside
going to
StreamYards, but I do
have,
appreciate
Mr. Brooks start with
I do
his
appreciate the
opening
donation
statement.
of
We'll do that when we come back after
memberships.
the lunch hour. I think frankly, the time over the lunch hour will be good for everyone to regroup, hopefully get a little bit to eat and come back fresh. And then we'll have his opening statement and the start of testimony. Before I
Mary
bring the
says, I'd
jury
like to
out,
thank you,
there's
Kurt, and
one
make
other
me
thing
feel
I
comfortable
want to
answering my
do,
question.
though.
This hasn't always been the
Just
case
need
for
a
me in other
moment
chats. So
to
much
pull,
respect for you in your regard.
something
You no
up
problem.
from
If there's a
my
good
computer.
question, a good opportunity for me to teach something, then I'm happy to. Like if people are asking genuine questions
No.
and not just trolling,
Would
which
that be
sometimes
cool for the
happens,
record?
and sometimes
Please
I
don't
misread
interrupt me.
things,
I
I
need
make
to focus
mistakes,
on what
but
I'm not interrupting
know,
you. I'm just asking a
if there's an
question.
opportunity for me to
Not gonna
provide
be addressing that.
education
So
about
what-
Don't
why
interrupt
something's
me
being
right now. I'm
done
trying
or
to do something on my
Would it be
computer. I
proven
need
what's
on record?
happening, I'm happy to try to do that.
I feel it's important at this time to at least give you the advisement pursuant to Special Material 28. It is regarding your decision on whether to testify. I'm not asking you to make that decision, but since we're on the verge of you starting your case and it may impact your opening statement, I wanted to go through the following. Sir, are you aware that you have a constitutional right to testify?
I've been informed.
Are you advised and informed that you also have a constitutional right not to testify?
I'm not advised, I'm informed.
Are you advised and informed that the decision whether to testify is for you to make?
I don't understand the question.
Are you advised and informed that the decision on whether you testify in this trial is for you and you alone to make?
I'm informed. Not advised.
Whatever.
Are you advised and informed, sir, that if you choose not to testify, the jury will be advised that they cannot use that against you? In other words, you have that right not to testify.
I wouldn't be asking questions. I'd just be
I'm
giving him
informed.
his statements. I'd just be saying, you are informed this, you were informed this. I wouldn't be asking, but you know.
When you make a determination about whether to testify in this trial, I will further be asking you about whether anyone has made any threats or promises to you to influence your decision. I may also briefly go over your educational background. Did you hear me say that?
No, I'll say it again.
At the appropriate time,
Lol.
when we go through this discussion more fully, I will also ask you whether anyone has made any promises to you to influence your decision on whether to testify. Did you hear me say that?
I'm informed.
And then I will also ask you if anyone's made any threats or coerced you in any way in your decision to testify or not,
What's the significance of that?
so that I can make appropriate findings about the voluntariness, intelligence, and
Thank you, Chris,
Your-
for your super chat. Brooks is putting on a masterclass on how to become the
whether
most
it's
hated man in
knowing,
Wisconsin.
voluntary, and
In
intelligent.
case the chief, it's going to be a shit
decision
show, even more than everything's
Whether I
already
get
been.
to
I think
see-
that's very, very likely. That's why we're streaming it
That's
today.
not the legal determination that I make.
I think today could be fire.
It is simply something that is your choice. I will honor your right not to testify. Obviously, that's a constitutional right. I will honor your right to testify. That's also a constitutional right. And the jury will be advised one way or the other. There's a jury instruction on that. Did you hear me advise you of all of this?
I'm informed.
All right.
I'm not sure what he thinks the difference
let's bring
between
the jury
informed
out
and
and we can
advised is,
I'm gonna tidy
but
up the record and then we'll break from it.
May I remove that exhibit, please?
I think they're
so
right
the
there.
state is going to formally rest before
Jury
lunch.
already coming out.
I'll just stick
Okay, so go
All
ahead and
rise
sit
for
it
the
back
jury.
down.
So the state's just going to formally rest before lunch.
Subject matter jurisdiction still hasn't been proven for the record, Your Honor.
Yes, it has.
Should be proven at some point.
Gotcha, bitch.
Remind me not to do that twice. Remind me not to do that twice. That hurt.
I like the triad colors personally.
Thank you,
Commenting on my
everyone.
own
Please
lighting
be
setup, I like the
seated.
triad colors. Look at more than an analogous color.
Right then, I'll turn to the state. Any additional evidence at this time?
State has no additional evidence, Your Honor. May we make a record as to the exhibits?
Go ahead, please.
Your Honor, we believe that the court has admitted all exhibits that have been offered, with the exception of one prior ruling on Exhibit 6. I don't know if you want me to list them all by number or it's 1 through 78, 1 through 178. But there are some numbers missing because we chose not to offer those exhibits.
Anything specific as it relates to the most recent testimony?
Most recent testimony, with Detective Casey, we moved 177 and 178 and 175, 150, 151, 88, and 89. I believe those were admitted by the court.
That's my recollection as well, but for the jury, exhibits 150, let me start over. Exhibits 88, 89, 150, 151, 177, and 178. If I didn't receive them during the testimony, I'm receiving them now.
And 175, which was the still photo,
Thank you. Sorry, I had to scribble on my pad. And 175.
and 13 and 14. Those are
Okay.
the outliers, I apologize.
I believe those were received as well, but if I didn't
Objection, I
state
think
it,
they was already received.
I appreciate that. I just want to be thorough.
What is
for the
subject matter
record.
jurisdiction? I'll
13,
explain that
14
during the
were
break.
received As well, do you have any additional witnesses to call at this time?
No, Your Honor, at this time, the state rests.
All right, thank you. All right, then at this time, we are going to break for the lunch hour. I am going to have everyone come back at 1:30. It's a little bit longer, at least that's what I want to do for the lunch hour today. So all rise for the jury.
He needs an extra break. He wants to steal herself. She knows. She knows. She's gonna go meditate for a while. It's like I need an extra half hour for meditation. Man. We're gonna get closing arguments today. We're nowhere close to closing arguments today. In fact, we're having opening arguments today because Mr. Brooks deferred his openings. So we're getting opening arguments today. Plus whatever. So
Thank you. Be
yeah.
seated. Mr. Brooks, anything from you at this time, given the state is now rested?
She's asking if he wants to
I'm asking you the question. Do you have any requests at this
she's
time? now that
asking
the
if
state
you
has
want to
rested?
move
Request
to dismiss.
and pertaining to what exactly?
I'll ask the question one more time. Do you have any requests?
He's not going to
make
tell
at
him that,
this
but that's
time
why
now
she's
that
asking the
state has
questions. Like,
rested?
do you want to move to dismiss?
I don't understand what you mean by that. That's why I'm trying to get clarification.
I'm not going to give you legal advice. I'm simply asking the question. Do you have any requests to make at this time now that the state has rested?
I don't know what I'm supposed to say to that.
Yeah, you don't, do
I
you?
don't understand.
You're supposed to move to dismiss for lack of sufficiency
Would
of the
that be
evidence.
pertaining to,
I can't give you
don't
legal
know.
advice, sir. I'm just asking the question to make a record. I'll ask you one more time. Do you have any requests to make now that the state is rested?
I don't understand.
I bet you don't.
All right, the other thing I want to do when the jury
Lol.
comes back out is, you know how I read
Get wrecked.
section 101 at the
Get
very
wrecked.
end of the preliminary.
Do you want to
jury
move to
instructions
dismiss?
That just has to do with
Do you want to
opening
move for?
statements.
Do you want to move
I
for a
will
finding?
Read
Do you want to
that
move
with a
judgment as a matter of
caveat. It
law
will
for
just say
insufficiency?
That the defendant will now make his opening statement. The purpose of an opening statement is to give
Lol.
the parties an opportunity to tell you what they expect the evidence will show you, so that you will better understand the evidence as it is introduced during the
The
trial.
poor judge, like,
must
I
caution
can't,
you,
I'm not going to
however,
give you
that the
legal
opening
advice, but I'm going to ask you
statement
4
is not-
times.
So I'll read
I'm going to
that.
ask you
You
4
can
times. Hey,
incorporate
do you want to make the
that
motion to
Mr.
dismiss? Do you want to make the
Brooks
motion
opening statement until
for
the start of
judgment as a
this
matter of law?
case.
Do you want to make that? Do you want to
With
make that motion
we
right
will
about
take our
now?
lunch break. It's 12:09. If you could be back here at
Great.
1:25 and be ready to go at 1:30 with your opening
I
statement.
got a question.
Go ahead.
Uh-huh.
Do I get to present exhibits and stuff like that too and admit them into evidence?
Yes, you do, sir. Yes.
At what point are we talking about? Do you want to use exhibits that have been received during your opening? Is that what you're asking me?
No, I'm saying if I got my own stuff that I want to offer into evidence, which is a question I asked previously.
Do you believe
Yeah.
the state has all of those documents that they might be able to assist with? Or are they new documents?
I don't know what you mean by new documents.
Are they documents from the discovery that you have?
They documents of my filings and stuff like that. I'm sure they have copies of everything that I filed.
I guess without knowing specifically what you're referring to, sir, I did give you the admonition previously that you are prohibited from discussing subject matter jurisdiction during your opening statement. It's not relevant.
I'm not referring to the opening statement. I'm referring to things that I want to offer
Give
for
me an
evidence.
example, please.
I just did. I said I have filings that I want to offer into evidence.
That's too general, sir. I need a specific example so I can answer the question. What are you referring to?
My filings.
Which
Everything
ones?
that I filed.
Filing, sir.
Every one of them.
Well,
Give
they
me a
have to be
specific-
relevant, number one, to the proceedings. Okay, number two, I don't know specifically what you're referring to. You can't offer testimony of yours through an exhibit. That would be hearsay. So you'll have to testify if it's your statement that you're referring to.
I'm not referring to I didn't say anything about testimony. I said
I'm being
filings.
general based on what I've seen thus far. So, are you talking about during your opening statement or during the course of the questioning of the witnesses that you're calling?
Your Honor, with all respect, I just clearly said filings that I filed.
Mr. Brooks, if I understood, I'd answer. I don't understand what you're asking me. You need to be specific.
I've filed a number of documents. I think that's on the
Well,
record
without
that I
knowing what you're
filed.
referring to, then my answer is no. But again, well, I guess I'll have to wait and see as to when you seek to admit them, whether there's any objection or not, and whether they comply with all of the rules of evidence and the rules of procedure. That's the best I can tell you at this point.
I don't understand what you mean by that. They will only be relevant to
Bruh.
obviously
Bruh.
the matter. They would
Sir,
be relevant to anything
I
else.
can't answer that anymore.
Bruh.
We're gonna take our lunch
Bruh.
break. It's 12:12. We'll see everyone back here at 1:25. We are in recess.
So I'm not allowed to offer anything in the evidence.
For the record, I never said that. We are in recess.
So I'm trying to understand.
Okay, I'm sorry. I know that was a little extended, but I had to get out some frustration. I'm sorry. That was a little extended. I apologize. I'm sorry. That was a little much, but I had to save my sanity a little bit. It was a mental health. It was a mental health thing. It was a mental health thing, and I apologize for the repetitive nature of it. But it was absolutely necessary in every way, and I'm sorry about that. Per my earlier comment about the 3.1415 thing, yeah, I think we need to give Math Boy Fly something to cover, and also we need to educate you, the chat. So I figured we could share this moment together. For those of you who have not seen this, this is a thing that's happening. So here we go, kids.
The following has been paid for by a grant from the Windsor Pneumatics Foundation.
I wonder what the circumference of this record is. I wonder what the area of it is.
You could solve any of those problems without pi.
Pi? What's pi? Pi is a mathematical constant that represents the ratio of a circle's circumference to its diameter.
Did somebody say pi?
No, Steve, not pi. Pi.
Oh.
My name's Javier.
I'm Jessica.
My name's Steve.
My name's Susan.
I'm Gator.
When ink and pen in hands of men inscribe your form by B to B, they draw an altar on which God has slaughtered all stability. No eyes could ever soak in all the places you anoint. And yet to see you all at once, we only need the point. Flirting with infinity or geometric progeny that fit inside you, oh so tight with triangles that feel so right. 3.141592653589793288419716939937469399344599. Forever constant homily says flaw is discipline. The patron saint of imperfection frees us from our sin. And if our transcendental life should find a final floor, then man will know the death of God where wonder was before.
Yeah, I know this pot shit backwards and forwards. Check it out. I did 3 chicks, then I pointed at the door. A girl entered in, so that made it 4. I snapped one time, in came another 5. Add them all up, and that makes 9. The average age 26.5. Now that's what I call getting some pie. 5 of the chicks wore 6-inch heels. 2 other 9 squealed like seals. 514 was the area code. Quebec, Canada, my winter abode in my $1.3 million chalet. Pie backwards, pie forwards, all night and all day.
3.141592653589793238662862862089962803482534821170679821470679821482.
So there's your deep cut for the day. You're welcome. I was happy to offer this yeah. So this value to you, this value add. Value given for value or exchanged, man. Yeah. That was the song Pie by the band Hard and Firm. So, yeah, great. Is this legal education? Well, it's rap education, I think. We're trying to give Math Boy Fly over here some ideas for the future. Yeah. Grounds. Grounds. Oh, there are no grounds, my friend. It's just all past. It's all a thing. Is there a rackets raid incoming? That'd be cool. Asked and answered by the robot. Yeah. So after lunch, my friends, we got an hour. You want to play the rap song again? We did it yesterday. You want to do it again? You want to listen to the rap stylings of Mr. Brooks again? Should we further inquire from Mr. Brooks about the business? Because that is the question that's haunted my dreams of his rap stylings. I have no shame in telling you that what the business has been in my head rent free for like 3 days. It's a terrifying reality over here at Uncivil Law. I don't know what it will take to purge this from my mind, but it has been living in my mind rent free. I don't really like it very much. I'd like it to stop really soon. But yeah, yeah. Yeah. What's Brooks' best defense? Well, his best legal defense is probably trying to go after the mental state requirement, because it's obvious that, so like in every crime you have the actus reus and mens rea. So the act and the mental state. So since the act is obvious, the only thing to attack is the mental state, which, that's not really good there either, but it's all you got. CZR next says that was transcendental. You've not heard his raps? Oh, okay, fine. We can do this. Hold on, let me pull it up. We can enjoy it together. I'm looking for it. I'm looking for the link. Okay, I think this is it. All right, here we go. Yep. This will do fine.
D-Mark got that heat.
I just got a load worth about a half a ticket. 30 in the blicker when I'm out here chasing chicken. Was observant to the game when I used to play the benches. Now I'm Spike Da Vinci, got them looking at me different. I can't miss him, yeah. AR with a stenching, yeah. Venom when I kiss him, yeah. Kidnap you and misses, yeah. Work all in the kitchen, damn. Money by the ceiling fan. Shorty wanna take a chance, I'ma need a cash advance. Only fuck with real gritters, and I've been around gorillas ever since a little nigga fucking on my babysitter. Put some prices on the nigga, you know they gon' come and get you. You see how the models did him, now he look like Tyson hit him. I was in the slums, any weather, I was still trapping, sliding on the pussy early morning. Bitch, you still lacking, caught him in the mall, had to tuck it in my heel figure. You know I got steel with him, fully not that little pistol. Hurt they putting cameras on the lights, bitch, we still dealing. Give a fuck about the past, nigga, I'ma still kill you. No love for the suckers, listen, put them in the field, we bliss them. Shoot out all the ammunition, they move like some caterpillars. Post this on your social feed, Andy's that extend release. 2 cent boy, your talk is cheap, I won't stop till you deceased. Coming out your face, you bleed. Carbons, we gon' sweep the scene. Senses, we gon' find the heat. Take you out the movie screen. Shout out to my shooter team, they gon' handle teams for the revenue. Can't even eat off these dishes, they got residue. Remember when I used to play the hard back in middle school? Remember when them cases had me stuck in that cubicle? Playing like you stupid dog, you know what I do to you. Cool on the text so it keeps shooting when I shoot at you. Panoramic musical, beat you like I'm Rougarou. Call a Uber before you double back and hit the Uber too. Tapping with my grower, I need 20 when you shoot them through. Busting plays, bumming through the line, better watch my J's. Not a frame, shutty, these Cavalli, these ain't Cartier. Get the face, then I knock the shorty out of negligee. Blood hit me from the seal, told me get the cake. I don't wait for nothing, bitch, I'm running to the real estate. Stay away from suckers, I don't fuck with niggas anyway. Snitching niggas, hating niggas, stay the fuck up out the way. Got another low, how we playing with them digits. Weighing up them bowls, selling coke around the digi. Playing with them bloods, they gon' pop you like a skillet. Nigga, I'm a menace, and that's word to Mr. Wilson.
Yeah. So that's some of the rap stylings of yeah. But I'm gonna find let's see. Okay, yep. This is the song that's living in my head rent free for the moment. So we can enjoy this moment together.
What's the business? What's the business?
Phone jumping off the chain like what's the business? I'ma pull up with the yay like what's the business? Eating lunch with the blood like what's the business? AR double drum like what's the business? 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 Catch me sliding to the trap like what's the business? Grinding trying to make a stack like what's the business? I'ma pull up on you like what's the business? She gon' give it to the kid like what's the business? 30 shots in the clip like what's the business? You don't gotta choose it like what's the business? All my niggas on the job, what's the business? Tryna rob and you get dropped, what's the business? You a walking stain, what's the business? I'ma hit your chest brain, what's the business? We be running through a block like what's the business? 100 shots for a op like what's the business? Gang, gang. Phone jumping off the chain like what's the business? I'ma pull up with the yay like what's the business?
Eating lunch with the blood like what's the business? AR double drum like what's the business? 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 Bro say he need them pounds. What's the business? Hit my line when I'm in town like what's the business? Heard they claiming it's a drop like what's the business? I'ma bring them round the mouth like what's the business? Killing overflow like what's the business? Killing for these hoes like what's the business? Never leave without that pole like what's the business? Blowing Cali out the door, what's the business? Stupid link on the cane, what's the business? I'm a guy, Charlemagne, what's the business? Pouring money, that's my lane, what's the business? Thumbing through a whole thing like what's the business? Phone jumping off the chain like what's the business? I'ma pull up with the yay like what's the business? Eating lunch with the blood like what's the business? AR double drum like what's the business? 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 What's the business?
Yeah. So that's the song that's been living in my head rent free for a minute now. I'm hoping that's going to stop pretty soon because it's kind of irritating. I'm uncivil law. What's the business? Talking about U.S. Supreme Court like what's the business? Illinois versus Allen. What's the business? Kicking your ass out of courtroom. What's the business? What the business? What the business? What the business, yo? What the business? What the business? What the business, yo? Discussing law on the law tubes. What's the business? Explaining what motions in limine are. What the business? Offer of proof. What's the business? What the grounds? What hearsay? Leading. What the business? What the business? What the business? What the business, yo? How's my cover going? Is it going well? Are you feeling it? Are we feeling it? Law boy fly over here. Is this working for you guys? You think so? State of Wisconsin in the background. Love it. Great. I'm glad. I'm glad this is working for you. This is your day job. Oh yeah. No, yeah. Oh no, yeah, I can put on the hat. No, you're right. Uncivil law, talking law on YouTube. What's the business? Talking Supreme Court precedent. What's the business? Common law in this club. What's the business? Hanging out with the chat. What's the business? What the business? What the business? What the business, yo? What the business? What the business? What the business, yo? Hey, what the business? What the business? What the business? Talking Illinois versus Allen. What's the business? Miranda versus Arizona. What's the business? Brady versus Maryland. What's the business? What's the business? What's the business? What the business, yo? Dun, 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 dun. You need to be in a dirty kitchen. Supreme Court be tripping. What's the business? Chevron versus NRDC, what's the business? Wickard versus Filburn, what's the business? Supreme Court can't understand the law, what's the business? What the business, what the business, what the business, yo? Okay, I'm better. Probably not. Probably cracking more than I'm better, but you know, who makes the hat? It's custom made. Streamlabs, teach them about the hat. Guys, I think we've lost him. That's about moment. What's going on? Yeah, that's what's going on. You're having fun and we're having fun with you. Change nothing. Thank you very much. Have I ever thought of becoming a professor? Yes. I honestly don't know how I'd go about such a thing. I don't know how to become a professor. I mean, seriously, what do I do? Do I just write the dean of UT Austin and be like, hey, I have a YouTube channel where I discuss law. Have you considered hiring me as a professor? Is that how that works? I honestly don't know. So I don't know actually I don't know how to do that. But, you know, okay. This is just life in prison. There's no death penalty in Wisconsin. So yeah, he's facing 6 consecutive life terms plus time. So he will die in jail. He'll die in prison, which is fine. Probably need to write some law review articles first. Maybe. I don't know if that's the path forward or not, but okay. Can I add closed captioning? I don't know how to do that. YouTube does it automatically, and I don't know. I don't know how to add closed captioning. If it's not automatic, then I don't know what to do. What's the minimum he can get? 6 life sentences. Yeah, and it's statutory requirement. Did I address what the business is? I try to address a little bit what the business is. The business is the state of Wisconsin, a little book. A little bit, yeah. Streamlabs is a bot that provides notifications and stuff. Get a teaching certificate? Not for graduate school. You might need a teaching certificate for like K through 12, but I don't think you need a teaching certificate for college. I doubt that most law professors have a teaching certificate, but okay. As someone that works in higher ed that's surprisingly close to what you do, check the college job postings, which are usually listed in the HR section somewhere, or email the dean. Okay, maybe I'll do that. Yeah, you don't need one for college. You don't need a teaching certificate for college. Maybe the dean, if you are a student, or more to the point, how about that? If you are a professor at a law school somewhere, and you'd like to have me as a colleague, please feel free to reach out to business at Uncivil Law LLC. What the business is business at uncivillawllc.com. If you're a dean of a law school or professor of a law school or otherwise would be interested in having my legal acumen be added to your faculty, please feel free to contact me. I am available. Zachary gives $10 to say my rap stylings are the perfect backdrop to a lazy morning of painting 6mm wargaming miniatures. Thank you. Well, I'm glad I could provide that value. Oh yeah, I'm not offering to give up my YouTube channel. I'm not offering to give up my YouTube channel. I'd still have a YouTube channel and be a professor. I can do both. So I still do both. What the business is, at least in part, the YouTube channel. Yeah, I'm not giving that up easily. I am available for business. This is true. I am very available. Yeah. Community college, yeah, I could teach at a community college. That's easy enough. But I don't want to teach at a community college. I want to teach at a law school. And I'm not sure teaching at a community college necessarily helps me towards that goal. Right, because everything is opportunity cost, right? So could I teach at a community college? Yes. You know, I have a graduate education, I have a JD, I have 3 college degrees, I have 2 BS degrees and a JD. I could teach at a community college. Do I want to? Not really, not in particular. Does it help me towards the ultimate end of getting a job as a law school professor? I'm somewhat doubtful. So I'm not sure about that. Could I please explain homicide versus reckless endangerment? Yeah, well, strictly speaking, reckless endangerment doesn't require anyone to die, right? To recklessly endanger just means that people are put into danger. Homicide is someone died. Reckless endangerment is you put people in threat. So he's guilty of both. He killed people. That's homicide. He also hurt people. That's battery. He also threatened people he didn't hit. That's reckless endangerment, right? So even the people he didn't hit, there's a violation, right? He drove his car in a reckless fashion that endangered people. That's reckless endangerment. He hit people. That's battery. He didn't stop, incidentally, also. So that's driving away from the scene. He killed people. That's homicide. So yeah, I mean, there's many different things that are happening here. Jennifer Foley gives $5 to say just because. I appreciate everyone who's here. I will now answer your legal questions because we might as well get something of value out of this absolute nightmare of a trial. So if you have legal questions about things you've been hearing at the trial or otherwise, generally, I will try to answer your questions to the best of my ability. Because does community college have paralegal programs? Maybe. I'm not sure I'm particularly qualified to teach paralegal skills, though. That's a different skill set. I can teach you how to think like a lawyer. A paralegal is all about doing legal research, and that's a different skill set. Paralegals are better, arguably, at what they do than lawyers, which is one of the reasons lawyers hire them in the first place. Right? Paralegals do their job very, very well. Allow lawyers to focus on their job. So some lawyers are better at paralegal arts than others. I'm not sure if I can necessarily teach paralegal skills. That's not my training. Oh yeah, subject matter jurisdiction. Okay, fine. So yeah, so subject matter jurisdiction speaks to what subjects, what topics a court can hear. So not all courts are created equal. Different courts have different kinds of subject matter. And different, so for example, the most obvious distinction is between civil courts and criminal courts. So a criminal court can't hear a civil case. A civil court can't hear a criminal case, right? So if you somehow wound up with a criminal case in a civil court, you'd say subject matter jurisdiction. This court does not have jurisdiction to decide the subject. This is a civil court, not a criminal court. Why are we here? Right? So subject matter jurisdiction is about what subjects the court can hear. And for example, in my field of patent law, that's how the Court of Appeals for the Federal Circuit got decided or created, right? Because most federal issues get appealed to a regional circuit. So most of the time, if you're in Texas and appealing federally, you're appealing to the Fifth Circuit. Most of the time, if you're in Florida and appealing federally, you're in the 11th Circuit. Most of the time, if you're in Virginia and appealing federally, you're in the Fourth Circuit. Most of the time, if you're in California and appealing federally, you're in the Ninth Circuit, for example, right? But not if it's patent law. Patent law goes to the Court of Appeals for the Federal Circuit because that it's its subject matter jurisdiction. All patent cases go to that court. So if you have a case before a federal appeals court, and it involves patent cases. So if you had a trial and it involves a patent issue, and the person lost and they appealed to, say, for example, the 11th Circuit, you'd say, subject matter jurisdiction, you can't decide this issue because only the Federal Circuit can hear this, because only they have subject matter jurisdiction. So that's an example. That's what subject matter jurisdiction is. The power of the court to hear that particular matter, as opposed to personal jurisdiction, which is the power of the court over you. So just because they have subject matter jurisdiction doesn't mean they have power over you. So subject matter jurisdiction is the power of the court to hear this particular subject. Personal jurisdiction is the ability of the court to have it with respect to you. Why does the court have authority over you? In this case, that's pretty easy because the crime occurred in this jurisdiction. So the court has jurisdiction because the crime occurred there. So that would be the nature of the personal jurisdiction. The court can hear this case because it's a general matter. It's a felony court, and they're in the right courthouse. So that's subject matter jurisdiction. They're in the right place. Also, incidentally, for what it's worth, it's also interesting because subject matter jurisdiction is one of very, very few issues, and it might be the only issue, but I wouldn't swear to it. But subject matter jurisdiction is one of the very few issues that cannot be waived. So we discuss this a lot in law, like how if you don't use it, you lose it. Like if you don't object to something, you lose the objection. So that's one of the things, right? You don't preserve the objection for the record, then you can't complain about it later. So if you go to the Court of Appeals and you're like, the trial judge made the mistake, one of the things is like, did you object? Right? Did you preserve that objection? Right? So depending on the nature of the objection and depending on this particular rules, there's particular ways to preserve objections. So just because you objected doesn't necessarily preserve the objection, depending on specifics, which we don't need to get into. Right? So you need to preserve that objection. If you never object in the first place, right, that obviously doesn't preserve the objection. So if you're like, well, that question was leading, but you never objected to it, the Court of Appeals is going to be like, get lost, right? If you don't use it, you lose it, is a common refrain. But subject matter jurisdiction is not like that. It's one of the very few issues. It can be raised at any time, at any level, for the first time. It can be raised and has been raised for the first time, for example, at the U.S. Supreme Court level. Successfully, incidentally. And saying, hey, this court never had jurisdiction in the first place. The trial was invalid. The judgment from the Court of Appeals was invalid. This entire thing has been invalid. And it has happened before where the Supreme Court said, you're right. And it all just goes poof. Because if the court didn't have subject matter jurisdiction, nothing they did was valid, right? So that's like, well, that was 10 years wasted because we were in the wrong place. So yeah, it's an important issue. And until the case is final, it is non-waivable. So as long as the case is ongoing at any stage of proceedings, as long as there's proceedings going, you can always raise it for the first time. And he's raising it every time. Also, it's an invalid objection because we're in the right place, but in principle. Brittany asked, does a judge take contempt seriously in a custody order? That's such a broad question for both reasons. That's a broad question for every possible reason. First of all, does a judge? The first part of that is it depends on your judge. Different judges respond to things differently. They're human beings. There's literally judgment involved in everything. So the first thing is, who's your judge, right? Do they take it seriously? It depends. Who's your judge? Different judges respond to different things differently. As a general proposition, yes, judges take contempt seriously, but different judges have different levels of tolerance for a number of very pragmatic reasons, in addition to legal reasons. So like, even if you're legally in the right on a contempt order, like a judge might pragmatically be like, no, right? They might give someone a bye. They might give someone a pass. They might think that the contempt is the wrong remedy for, whatever number of practical reasons, especially, for example, if you're dealing with family law, if you're a family law judge, because the best interest of the child is, as always, a paramount, and depending on your day, a sole consideration. So maybe we're not going to issue it because would be a problem because it would be prejudicial to the child. So the first issue with your question is, who's the judge, right? Different judge take different things seriously. And the second issue is, what is the nature of the contempt? And also, what's the nature of the order? Not all contempt is necessarily created equal, right? We can have contempt we can have contempt because we disobeyed the order, but we did it in a very technical sense where we don't care. Like if the order is turn the child over at noon and you show up at 12:05, is that contempt? I guess technically. Is the judge likely to care? Probably not. You know, it's like, right? And like, now, sometimes they do care. Sometimes they do care. And sometimes you'll find a judge who will care about those 5 minutes. Right? Because, I mean, it is a technical violation, especially if it's not their first time. So is a judge going to care that you turned up with the child at 12:05 instead of 12? Well, it depends. Is this your first time? Have you already worn the judge's patience thin? You know, what is the nature of the violation? What's the nature of your reason for being late? I was doing it out of spite versus, you know, there was a traffic accident are two different reasons, right? So like, does a judge take it seriously? Depends. That's why the answer to basically every legal question is it depends. Because it depends on so many things. What is the order? What is the nature of the contempt? How serious is the contempt? How serious is the violation? How flagrant is it? How often is this person doing this thing? Is this habitual or is this a one-off? Also, what is the mood of the judge? You know, that day. So this is why it's very difficult to answer questions like that, because it's very difficult to make broad things because like there's a lot of factors that are in play. So but rule number one, just remember, guys, rule number one of litigation. It doesn't matter if it's criminal or it doesn't matter if it's civil. If you want one simple trick, here is the one simple trick. Don't piss off the judge. Okay? Rule number one of all litigation, criminal, civil alike, don't piss off the judge. The judge has a lot of power and a lot of discretion. The judge can forgive you, even if you're in violation of the rules. And the judge cannot do that, even if you're in a very technical violation of the rules. So, rule number one, and the judge gets a lot of discretion. The judge has a lot of power. You know how they say tell it to the judge? The judge has a lot of power. The judge has a lot of leeway. They can use this leeway to benefit you, and they can use this leeway to punish you. Right? They can use this leeway to accommodate you, and they can use this leeway to make your life a living hell. Also, incidentally, don't piss off the clerk. Don't piss off the judge. Don't piss off the clerk. Both these people can ruin your life. Both these people can ruin your life. So, don't piss off the judge. Don't piss off the clerk. And if you're like, well, that's not fair. That's not fair. The judge gets to be mean to me just because they're angry. Well, I don't know what to tell you. Whether it's fair or not, it's reality. Don't poke the bear. The fairness question can wait for another day. Yeah. Watermelon says 499. Judges let Brooke run aimlessly for 40 minutes. How long do you think his opening will be? Will the judge stop him? Oh, I think it's going to be a shit show. Yeah, and also take yes for an answer, which Brooks himself has failed to do. If things are going your way, shut the hell up. Yes. This is always a good point in just sales in general. This is just a good point in sales, whether you're selling a car or whether you're selling a judge. Once you've gotten a yes, take yes for an answer. Stop selling. Because you can always talk yourself out of the sale. So if you've gotten a yes, stop talking. That's a good tip. That's good stuff. Why is the court not yet at opening? The defense deferred their opening. The prosecutor had an opening at the opening of their case. The defense deferred their opening So the defense has the right, at least in this case, by law, and most judges will let you do it if you ask, you know, to defer. So you can choose as the defense to defer your opening towards your opening in chief. This is generally thought of as a bad idea, but you have the right, at least in the state explicitly. Taylor Flock says you may be interested to dive into Wisconsin bail laws. The case stirred up a case for bail reform. Our Constitution limits the judge's discretion on monetary conditions only to compel appearance. Fair, right? And so the power of judges, of course, is largely influenced by statute, right? And so the legislature can give the judge more power or less. But as a general proposition, right, the judge has less power over you. But of course, that can be limited in a lot of ways. Jason gives $5 to say, I believe he's guilty. I believe the judge has been extremely patient. I also believe the inherent bias between the judge and prosecutor showing. I disagree about that. I don't see any bias. I think the judge's rulings have been incredibly fair and patient and kind. I don't see any bias. Well, the prosecutor's biased, but then again, they're supposed to be. So the prosecutor's biased. Yeah, they're biased. They would very much prefer that Mr. Brooks be in prison forever. So if your proposition is the prosecution's biased, yeah, that's kind of what they're supposed to do. Your proposition is the judge is biased. I disagree. The judge's rulings have been perfectly fair and have been exceptionally deferential to the defendant. If there is any bias at all, it's actually the other way. In my judgment, the judge has been exceptionally deferential to the defendant. So if there's bias, which I don't even think it's really bias exactly, it's just the judge being overly cautious. So I don't think it's bias. But the rulings are more in favor of Brooks than might be strictly speaking required. I think we can definitely say that. The judge is being very deferential to the defendant, which, if you're going to be deferential to one side in a criminal case, all else being equal, if you're going to be deferential to one of them, you should be deferential to the defense, right? If you're going to pick a favorite, right? If you're going to pick a favorite at all, then, the defense is the way to go because they're the one that, is being in prison forever. So you don't have to, obviously, you can just cut it straight down the middle. But if you're going to err on the side of the defense. That's a good tip for a judge in a criminal case. If you're going to make a mistake, make the mistake in the defendant's favor. It's a good rule. It's a good rule to follow. Would it have been a case for a mistrial if the judge had given legal advice? No. I don't think it would have been mistrial. No, but the judge doesn't have to, nor does she want to. I don't think it's a mistrial. It's like you could make this motion, right? I don't think it's not a mistrial. No, it's not a mistrial. No. If the judge had said it, no, it would not be a mistrial. The judge can, the judge just doesn't have to, and they don't want to. It's just like, okay, do you have an emotion? I don't understand what you're asking. I know you don't, Mr. Brooks. That's why we told you it was a bad idea for you to represent yourself. She's thinking in her head. But do you have any emotions at this? Do you have anything you want to bring to this court's attention? Do you have any emotions at this time? Like what? Okay, well, I'll take those and no. Yeah. There's such a thing as a professor of practice at some institutions. That could be cool. If you want to, if you have connections at the University of Texas, if you have connections at the University of Texas at Austin in particular, are you a law student at the University of Texas in Austin? Are you a graduate of the University of Texas at Austin? Are you a professor at the University of Texas at Austin? Are you the dean at the University of Austin, Texas of Austin? If you have connections through your academic experience to the University of Texas at Austin, would like to extol me available. This will be my sizzle reel. Hi, Dean. I am Uncivil Law. I am a licensed lawyer in Virginia, and with the grace of the Bar of Texas, soon to be licensed in Texas. I've been licensed for 15 years. My experience is intellectual property, but my knowledge a lot is in constitutional law. So I'm available for teaching the fine young minds of the law school at the University of Austin, and I would like to be a professor at your school. I can teach constitutional law. I could teach intellectual property law. And in a pinch, I can teach other fields of law too, because I try to keep myself very well versed. So I could teach property. There you go. So that'd be fun. We can teach a whole generation of students about the rule against perpetuities as we watch me, tell them how stupid it is, and we'll just try to get through it all together so that they know it. So if you'd like me, I'm available. Can I do law classes online? Well, I'd want to do it in person. Could I teach patent law? I could teach patent law. I could teach intellectual property law in a general sense. I could teach any IP law. I could teach trademark. I could teach copyright. I could teach patent. I could teach a general IP course. Yeah, I could teach any of those stuff. I could teach constitutional law. I could teach property law. I could teach torts. That'd be fun. My IP professor was also my torts professor, so I could follow his or my patent law professor was my torts professor. He was a very interesting guy. A little bit in the model of Paper Chase. He was an intimidating guy. But I liked him very much. So yeah. I had some characters in my law school, which I suppose is very true. I will also teach probably using the hat. The hat probably will make a feature appearance in my law school. So yeah. Would I like my classroom like I like my place? Maybe. That'd be cool. Year-long course on international, sure or nothing. Civil procedure is my weakest subject. Yeah, civil procedure is my weakest subject of the ones, and I know that from my bar prep. It's the one I had the most problems in. And also I can't, well, more to the point, don't want to teach family law. So I'm out for that. Probably not an ideal pick for criminal law. I could probably do it in a pinch, but I don't have any criminal law experience, and I'm probably not ideal. Keep the hat or no deal, maybe. Paper Chase, good show. I was thinking about the movie actually, rather than the show, but either way. Over or under on Brooks actually completing a statement? Oh, under. I don't think he's going to make it. We could have the soundboard in the courtroom. We could have the soundboard in the classroom. Yeah, I think the soundboard in the classroom could, you got to find ways to break it up and ways to make things interesting. I think the soundboard in the classroom might actually go a long way to making things more interesting and more memorable. So yeah, the soundboard in the classroom is not actually the worst idea I've ever heard in my life. It is definitely a strong possibility. Is there a legal difference between murder and homicide? Sure. Murder is a legal finding. Homicide is a medical finding. So yeah, if someone dies as a result of someone else, that's a homicide. If someone kills someone else, that's a homicide, but it doesn't make it a murder. Murder is a finding of legal fault. This is one of the reasons why we have justifiable homicide, for example. Self-defense. Like, that's justifiable homicide, right? It's a homicide, but it's justifiable. That's why it's not murder. Justification is a basic principle in law, both criminal and civil, along with necessity. Right? I did it because I had to. I did it because I had a really good reason. Yeah. I did it, or excuse is another one. Excuse, justification, necessity. Right? I did it because I had to. I did it, but I had a really good reason. I did it, but it doesn't matter because of this other reason, which is different than justification. Like, there's actually something that prevents it from being operative. So, for example, the most obvious would be like the murder in the context of, or a killing rather in the context of a war, right? So, like, you killed someone, but like a criminal court, like a non-military criminal court, couldn't try you. I mean, like, for example, if you had an MP shoot somebody at a military base in the United States or something, right? So like that would be under a civilian court couldn't get to you. A military court might be able to, but not the civilian court because, excuse, I was performing my duties. Anyways, doesn't matter. I missed a $5 super chat question from Melissa. Let me see if I can find it out. Let's find it. I don't want to miss super chats. Melissa gives $5 to say, if Brooks testified, who does cross on him? How does that work? The state does. I mean, yeah, your question might be who does direct, and I don't know how that works. So your question is probably who does direct. I don't know how this court handles that. Some courts have the person just ask the questions and answer them. Some courts just have the defendant give it as a narrative, just talk. So it depends. I don't know how this court does it as a matter of its procedure. So I don't know. We might find out together. So some courts will have, just ask questions and then answer them, like, which is a little bit weird. Some courts will just be like, okay, just say what you want to say. The floor is yours. Basically, give us a narrative, which, is normally objected to. But, that's how sometimes it's handled. It's like if it's a person testifying on their own behalf. It's like a narrative, basically, by the way, is like basically like we're just going to let you talk and talk and talk forever about something. It's like, just tell us a story. We don't normally allow story time, right? The questions and answers are relatively short, right? Where did you go? I went to the park. What did you do when you went there? I met my friend. Why were you meeting your friend? Well, it's been a while since we met up and we wanted to go have lunch together. Did you go to lunch? Yes. Where did you go to lunch? We went to Taco Bell. What did you do once you got there? Right? So like you ask these questions, right? Rather than tell us about your day, right? So those are all valid questions. An invalid question normally is tell us about your day. Well, I woke up and I went to the park and I told my friends, like, objection there. Right? We don't normally allow that. But some courts, when it comes to people representing themselves, will be like, oh, fine, fuck it, just give us the narrative. Let's move on with our lives. So we'll see how that goes. He won't stop if he's allowed to give a narrative. The judge can control it. Like, just because we're like, give us a narrative doesn't mean it's unlimited, nor does it mean it has to be relevant. Like you can talk forever as long as what you're saying is moving things along and is relevant, right? So there's no limit to it except to your own. I mean, how long can you really give relevant facts? But like, as long as you're moving things along and it's relevant and stuff. And in the case of a pro se, you're going to give them a lot of latitude. But yeah, the judge does still have control over their courtroom. The judge can stop you at some point and be like, that's irrelevant. Move on. Whatever. So we'll see how it goes. Hypothetically, the Brooks could have an expert claim the SUV had a mechanical problem. Sure, absolutely, that's possible. You can always have a battle of experts. There could be an expert who said, it was a mechanical problem, and then it's a question of who's the jury believe. But I think we all know the answer to that question. Brooks should sue Ford for false advertising because he was driving a Ford Escape and he didn't escape. I respect that, Ron. That's a good one. I respect you. You are recognized by Uncivil Law. You, sir, get +1 point on civil law points. Yeah. If he chooses to ask himself questions instead of narratives, does that set it up for cross-examination? I don't understand your question. The state gets to cross-examine no matter what he does. There's no setting up for cross-examination. The state gets to cross-examine no matter what he does. So I don't understand the question. In California, what does a judge do when you go in for contempt? Does she ask both parties questions? How does that work? Is it a full courtroom or just the parties? It depends on the nature of the thing. It depends. It depends on the nature of the contempt. It depends on a whole bunch of stuff. Typically, though, you would have both parties present, but that's not necessarily always true, depending on the exact nature. Like it, yeah. Also, I don't know the exact procedures in California, but my expectation would be that typically, although not necessarily always, a good general rule is that always and never are to be avoided, because very little is always or never when it comes to law. Like if your question is, does this always happen or does this never happen? The answer is probably no. So we can save ourselves time. So if you ask questions like, in California, does this happen? I'm like, probably, but not necessarily always, because there's exceptions upon exceptions and exceptions, right? How would I start my opening if I were Brooks? I don't know. I object to that question, because by the very asking me the question, you're trying to get me into the mindset of Brooks and put myself inside his head, and I don't want to do that. It's a silly place. I refuse to answer your question, sir. Start your opening dressed as Batman. I wouldn't necessarily recommend that. I'm not sure that's a way to go. Why didn't the SUV airbag deploy? Different airbags and different cars are set differently in terms of how much force they require to go off. Because especially in older cars, like I forget what year his is, but like in older cars with like first generation airbags, um, they typically wouldn't deploy until a very, very severe accident because they created some risk themselves. Like as airbags have gotten more sophisticated, they tend to go off earlier. So if his car is older and like has first generation airbags, it's probably set not to go off until it has a very violent impact, because the airbag itself going off in a first generation airbag car is pretty violent and can cause some real harm and under the right circumstances. So if I had to guess, that would be my guess. In some cars, and it could be where the sensor is based in the car, that too. Could be where the sensor is based, that too. So yeah, that's a possibility. How would I defend myself in the opening? I don't know. I don't know how I defend myself here. I wouldn't try because it's all dumb. Why would I do opening statement after prosecution arrest? I probably wouldn't. The general zeitgeist seems to be that it's a generally bad idea. That you want to get your story out right away and you want to do your opening as soon as the prosecution does. So why would you? I don't know that you would. I don't know there's any circumstance. I mean, I've never done a criminal case, so you're asking the wrong guy. To some level, but the general consensus is you don't want to do this. Is there some circumstance in which it's justified? I'm sure, because again, it's that always and never thing. So should you always do your opening immediately after prosecution? I'm sure there's some circumstance in which it makes sense to defer, but the general consensus is it's a bad idea. Excuse me. I thought Brooks chose to defer his opening. He did. He's going to give his opening at the start of his case. So he'll give his opening as soon as the court comes back, which will be fun and exciting for us all. What's going on? You have some questions if the state proved intent? Well, I will agree with you that the mental state is the most easily attackable. I think the state made its prima facie case on the mental state elements, but I think that it's attackable by the defense. Of course, Mr. Brooks is going to come absolutely nowhere close to being able to do that competently. So, like, the mental state elements are the most attackable. It's the only thing that's really attackable. I mean, the actus reus elements are, yeah. So does he have the intent for intentional murder? That's attackable. Excuse me 1 second. I have a phone call I've got to answer. I'll be right back. I'm back. I had to take a call. My car's in the shop. Some minor repairs, and so I just had to deal with that real fast. So I had to mute the mic. Do I hunt? I tried hunting once and I didn't really like it. Especially when I found out I could just buy the deer and it was like not that expensive. It was surprisingly cheap to just be able to buy an entire deer. And I'm like, just buy the deer, man. I mean, by the time you're like talking about all the costs and expenses of everything, I'm like, you know what? Especially also because you have to process the deer if you hunt it. Like, man, it's just cheaper just to buy it. Just buy the deer in the first place. I tried hunting once. I didn't like it. I thought that was illegal. I meant from a butcher. I mean, I didn't mean from like a person from just a person shooting. I don't know what the law on shooting on buying deer from like someone who goes and hunts it. I meant from a butcher who sells it like from wherever they get their meats from. It's just cheaper. I don't know. Yeah. Okay. Never mind. I don't know the law. I'm buying it from a hunter who goes out and does it. I don't know the law on that issue. It never came up. Bought deer mate isn't wild deer mate. It's raised. Okay. Noted. Look how much I care. Do you see my amount of caring? Can you tell the caring levels? Okay. Yeah. All right. Were the repairs on my car expensive? Yeah. Fortunately, my insurance company paid for them all, but they were surprisingly expensive. Yeah. Do I shoot for sport? Yes. I haven't been out for a while, but I shoot pistol. And I haven't been out for a while, but it's fun. Does the prosecution have to prove intent? Yes, they do. They have provided their prima facie case of intent. Yeah. They have provided their prima facie case. Yes, they have to prove it. They have to prove every element of the crime. They have to prove every element of every single crime beyond a reasonable doubt. Of course, they have to prove intent. It's an element of the crime. So do they have to prove it? Yes. Have they provided their prima facie case? Yes. Is it attackable? Yes. Will Mr. Brooks be able to attack it? Not a chance in this world. Will a competent attorney be able to attack it? Also not a chance in this world, but you can try. But yeah. Why did I move to Texas? I want something different. I was tired of living in Northern Virginia. Better weather here. Oh my goodness, UT, hire this amazing man. Kurt is intelligent, interesting, extremely knowledgeable, and such a down-to-earth good man. I live in San Antonio. I have connections, Kurt. Kurt, go get that position. If you have connections, feel free to talk to them. I figure people knowing I exist is a good place to start. Have I ever been to the UK? As a matter of fact, yes, I have. I've been to London. I have a really good story about that too. I was a freshman in college. This is a good story. I was a freshman in college, and my high school girlfriend, she was a senior. She was in like honors French, and they were going to France. And by way of France, there was a stopover in London for a couple days to experience London, and then on to France. So since we were dating at the time, I went along for the ride. And so I was in London. I was a freshman in college, and the group of people I was with, was out and about on the streets of London, and they stopped somewhere in order to eat, in order to get some food. And somehow, like it was a busy restaurant. It was a busy restaurant or something. And apparently somehow like everyone decided that collectively basically decided that they didn't want to wait in line, and so they all left. And somehow I missed it. Like I was in the bathroom or whatever, right? So somehow I missed them leaving. And so now I'm sitting in this restaurant in the middle of London by myself. Now, fortunately, what I had going for me is I had a business card of the hotel we were staying at. Because it's one of those things that my dad said, you know, if you're ever traveling, get the business card of the hotel you're staying at, because you never know when it will be helpful. It was extremely helpful because otherwise, like, I don't know where to go, right? Like, but fortunately, I had the business card of the hotel I was staying at. At that point in my life, though, I had never used a taxi before. And this is, of course, this would have been in 1999, I think. Or was it 2000? It was one of them. Anyways, so this is well before the days of Uber and anything else. And so, anyways, so I had never used a taxi before. And so like, I didn't know how to use one. Right? There were black cabs everywhere, but I didn't know how to use one. So I, walked down the street and I found myself a street map somewhere. I found myself a street map somewhere of London and found the street of the place my hotel was and found where I was. Right. I'm like, well, I'll just walk back. It was, 2 miles or something. It was a reasonable distance. It's like, I'll just walk back. It was like 2-3 miles, whatever it was. It was a reasonable distance. I was like, I'll just walk back. So I'm walking back, following the street map and walking back to the hotel. And I had not gotten lunch, right? Because they had stopped for lunch and I had missed them leaving, and I left the cafe, of course, as soon as I realized that, trying to find them, and I couldn't find them. So I had never eaten. So on my way towards the hotel, I passed through Piccadilly Circus, and I decided I was hungry. So I walked up one of the side streets of Piccadilly Circus. I went into this complete hole in the wall place, and I ordered a ham and cheese sandwich and a Coke. And so they gave it to me in a brown bag. And then I walked back into the middle of Piccadilly Circus because there's, a little park there in the middle, right? Where you can like sit like in the middle of it as cars are going around. I'm just sitting there in the middle. I open my brown bag and it's a can of Coca-Cola, and it's literally just ham and cheese and nothing else. And I think I got some mustard as a mustard packet. I'm like, there's no lettuce, there's no tomato. It's like normally when I order a ham and cheese sandwich, I expect there to be some accoutrements. There were no accoutrements. It was bread and ham and cheese. And I think I had a packet of mayonnaise or a packet of mustard or something, and my Coca-Cola. And so I sat in Piccadilly Circus and I ate my ham and cheese sandwich and I drank my Coke and I watched the cars go by. And it's one of my fondest memories in my life of this happening. And just because it's so incredibly memorable, just that moment of sitting there in Piccadilly Circus watching the cars go by, eating my ham and cheese sandwich with my Coca-Cola, trying to feel marginally better about myself, and eventually, of course, make it back to the hotel, and thus ends the story. But it's a good story. So yeah, they knew I was a tourist. Well, maybe. And it's like, yeah. So yeah, that's what that was my story. That was one of my stories of being in London. It was an interesting place. Interesting story. Technically, they gave me exactly what I asked for. Yeah. I was expecting a little bit more, but it worked. So it was a fond memory. I got literally what I asked for. Welcome to England. I guess I did. Yeah. I didn't inspect my sandwich before taking it back to the place to eat it, so I didn't notice, or I would have made a point of it. But yeah. So if you ask for ham and cheese in UK, that's what you get. Apparently that is what you get. They call them Monte Cristos. No, Monte Cristos are usually baked. Monte Cristos are usually like a panini. They're usually hot. This was not. This was just ham and cheese and bread. and nothing else. I got Londoned. I might have gotten a little Londoned. So at least I was in an English speaking country. Yeah, I did have that going for me. Exactly, Phil. Simple moment on a beautiful day in a beautiful place. Exactly right. So it's a fond memory I have. Wasn't my only time getting lost on that trip or behind the group. So I'll also tell you another part of that story, which is interesting too, because I got yelled at a little bit by the chaperones on the trip. Not that they could do anything because I was already a college graduate, so like they had no power over me really. Also, I'm an adult, so whatever. But I wanted to go to Greenwich because I wanted to go see the atomic clock. I might be a geek. The group wanted to go see like a Broadway show or something. They wanted to go see the theater in London. They wanted to go get tickets to some play or something. I wanted to go to Greenwich and watch the clock. The chaperones are like, you can't go by yourself. You have to find someone to go with me. No one went with me. I did not get to see the clock. My life is disappointing. I still have not yet seen the clock. My life is sad. But yeah, that's part of the adventure. They thought maybe I had escaped from the group to go off by myself to go to the clock. I did not. They yelled at me a little bit, but of course there's nothing they can do because I'm already in college and it's a high school trip. So like, but fine. Yeah. It's a good story. Yeah, he didn't. Did I see Darrell Brooks glaring at the judge yesterday, completely mad dogging her? The looks on her face looked at like he actually wanted to hurt her. I've taken a look at their faces. It's really interesting. All right. Let me take 5 minutes so I can maybe get some food of some kind, and I'll be right back. I don't know if I can play music and also keep the mic muted at the same time. So you just might have to deal with some songs of silence. So actually no, I think there is a way for me to do this. Hold on. Give you something to listen to while I'm getting a little food and taking a little break between sessions.
John, I have a question.
Go ahead.
The files that I'm attempting to locate are pertains directly to the witnesses that I will be calling. I'm not sure what witnesses are here today.
Well, let's do this. I'd like you to at least do your opening statement, bring the jury and do that. We'll give you an opportunity to look again. I can have the state write down who's here. I believe it's based on what you told them. And then if there's still something you need at that point, but I'd like to at least bring the jury out and start with your opening statement, okay?
Well, just so I'm clear, I didn't give a specific order in who I will be calling by specific order. I gave a generalization of
Sure, I'll
who
have the
would be-
state, sorry.
who would be called on what day.
Why don't I have the state write down who's here presently, and then you can make that determination, but at least let's go with the opening statement, okay?
That's what I was trying to get at. It would help to know who's actually here today.
Yeah.
Before you make your opening statement?
Well, so I know if they're not here, then essentially I can't call them.
Let's address that after. I'll have the state write down who they know to be here now or who's coming this afternoon, because there might have been people here this morning. I believe they're still here, but I'll let them write that down for you so you can better prepare. But at this point, I would like to bring the jury out for your opening statement. I presume you're going to give one.
I am.
Okay. Then I'll have the jury brought out, okay?
Subject matter jurisdiction?
No.
My prior written decision stands. I will not be addressing that further. Your objection is noted, and I will be continuing with the trial.
Is it verified proof for the record?
Sir, I don't believe I need to do that, or that the state needs to do that as well. I believe your statement about that is a misstatement of the law, and I do not intend to pursue that further.
Can you show me lawful law that says that?
I gave you a written
Lawful
decision.
law?
I have done that.
Can you show me lawful law that verifies that
Sir,
for the record?
I gave you a written decision. You
That
can,
I accepted for value in return for
and
value.
that's how I'm going to answer that.
It
So
was
let's
not verified proof. We still aren't.
Sir, there is no requirement in the law that the state or the court establish that. So your
Actually, there is.
objection's noted.
Actually, there is, Your Honor.
Actually, there's not.
Subject matter jurisdiction has
Sir,
to be
please.
proven for the record. Has
It
to
does
be
not.
proven. Has to be proven. You know that just as well as
Mr. Brooks,
you know that.
please
No,
do
it
not
doesn't.
make statements
Subject matter
that
jurisdiction is a question of
mischaracterize
the law.
You know it
Not a
has to be
fact.
proven
or that
for the
impugn the
record.
integrity of this
You know
court.
it
It's a
has to
question
be
of law,
proven
not a
for the
fact. It
record.
does not have to be proven for the record because it's not a question of fact. It's a question of law.
The statements that Mr. Brooks is making
It can be
regarding
raised at
subject
any
matter
time de
jurisdiction.
novo.
They are not evidence.
She's right.
You are to disregard them.
They're not presented as evidence.
No.
Just has yet to be proven for the record.
The jury will disregard the incorrect statements of the law that Mr. Brooks is stating.
Where's lawful law that is incorrect?
Mr. Brooks, please. I am going to read one instruction. Thank you, everyone. Please be seated. The defendant will now make an opening statement. The purpose of an opening statement is to give the defendant an opportunity to tell you what he expects the evidence will show so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. With that, go ahead, sir.
This is going to be infuriating.
Obviously, I don't have any rehearsed or well prepared speech, so I'm just going to speak from the heart.
Okay.
I would just like to first say that I want to bring to remembrance something I think everyone in this room has been taught pretty much as far back as we can remember.
Oh,
is that
shit. Here we go
there's
again.
always two sides to every story.
Okay. Not bad. Okay.
And for so long now, roughly a year, there's only truly been one side told of this story.
Okay.
And I've sat back and watched from countless narratives that's been put out there, the way this incident has been portrayed at times, And
You know what? So far, so good.
finally,
Not a bad idea.
everyone getting a chance to get the full story.
It's not in complete destruction gibberish.
You
Hey,
won't hear me try to
it might.
argue facts.
Okay, that's going to be a bit of a problem.
The fact is, this incident was tragic.
Uh-huh.
Very tragic.
Uh-huh.
That's not lost on me.
Good.
Facts are that there's still a lot of people healing, a lot of families healing on both sides. And when I'm confident that the evidence will show.
Hey.
Sorry, I'm getting a little emotional.
What the evidence will show. That's, hey, I've seen lawyers do worse.
That the evidence will show is that this incident was not planned. This incident was not intentional.
Hey, he's attacking the mens rea.
It's never even thought about.
Hey, pretty good. It's doing fine.
It's easy to I'm sorry.
Not intentional. Yeah. He's attacking the mens rea. Intentionality is an element of the crime. To say it's not intentional, he's attacking mens rea. He's doing great. I'm not saying he's right. I'm just saying he's making an argument that actually kind of makes sense. Which, is pretty high praise at this point, to be honest.
It's easy to look at the magnitude of something like this and form opinions.
Uh-huh. Okay.
I think it's easy to disregard a lot of factors.
Okay. All right. Okay. I'm liking this. Tell me more, Mr. Brooks.
And I think in reference to what I stated earlier, it's easy to forget the other side of the coin.
Uh-huh.
There's been a lot of suffering involved in this incident. A lot.
Yeah.
Obviously, with the families.
He might be play acting and stuff like that, but he might be play acting, he might be conning people, but he's doing a good job. I'm going to give credit for what it's worth, man. It's a lot better than what I expected. It's coherent, it's workable, it actually alludes to a legal theory that's arguable.
Even the alleged defendant's family as well.
My expectations were pretty low.
Suffering. A lot of misunderstanding. And I just want you to keep in mind everything that will be presented in its totality. Keep in mind the power that you have.
Mm-hmm. 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 Hey, I have no problem with you calling BS. It's just a lot better than I expected. My expectations were set so
I
low.
believe that should escape your knowledge.
Did he say escape?
This has been a long process for everybody. And what I believe is when it's time for you to make your decision, all of you, I believe that, and I pray that it's the right decision. That all the factors are weighed. There's been a lot of words thrown out there about the alleged. A lot of speculation, a lot of ridicule. Words like demon. Words like monster.
Mustard? You know, some of it might be genuine. I mean, you know, maybe he does have some compassion somewhere in his body. I'm still going to send him to jail forever. But if he has any sense of remorse at all, you know, hey, maybe there's some redemption to be had somewhere. Plenty of time to find Jesus behind bars.
I've had my reasons for that. But I feel now is the time to, it's important that you see me for who I am. No mask. For who I am. I think this is the moment for that. I pray that your eyes and ears.
I can save her, surfing bird. I can fix her. I can save her. I can fix her. I know I got it in me.
You understand that you alone decide this case, this matter. The power is in your hands. All of you.
Mm-hmm.
To determine for yourselves what truth is. Thank you.
Aw, that wasn't actually too bad.
Thank you, sir.
And do we have their writing materials available? All right, thank you. Mr. Brooks, you ready to call your first, would be your second witness, actually.
You want a break? I could use 5 minutes, actually, if you want to
Need
take
a
5
minute?
minutes. If they take 5 minutes, I mean, yeah, he's probably. I mean, all the sympathy in the world wouldn't affect my influence as a juror at this fact, right? Because like, he might be genuine. I just don't care at this point because I have all the information I need, right? As a finder of fact, right? That he did the thing, he did it knowingly, intentionally. Like my believing him or not as to sympathy just doesn't really matter because it doesn't go to any
Take
element
a
of the crime.
short break. I'll rise for the jury, please.
All right. I actually got to go run real fast and get my car. They just dropped it off. So let me just go do that real fast. I'll leave the camera on in case something happens, but I'll be away for about 5 minutes. I'll be right back. Talk amongst yourselves.
The materials that you were looking for, let us know if there's something you need in that regard. And Attorney Apper, if you could perhaps just confer with him over which witnesses are here. I'll step off the bench while you do that, and if someone can just let me know, I'll come back out in like between 5 and 10 minutes unless I'm told to come back out sooner.
Yes, Your Honor.
Thank you. right, thank you. Please be seated. Mr. Brooks, have you found what you were looking for?
I'm just gonna go with, I'm just gonna work off the list of people who's here,
Okay,
if that's fine.
all right. You know who you're gonna call first? We'll have that person ready.
Yeah.
Okay. You want to let us know so that the state can assist with that? Otherwise, you can just call when we are in front of the jury. So have the jury brought out, please.
Some of them are downstairs and some of them are out here. So it's fine. It just will take a few minutes if they're over in the main courthouse.
Okay. Why don't you tell the state the first witness to make sure they're right outside the courtroom, sir?
Most likely Bertram.
Okay.
Most likely.
Do you want to give us two names and we'll have two people out there? I just want to make it go smoothly, sir. That's all.
Since I'm working off this list, I wasn't expecting that to be first.
Who do you want to call first? And we'll see if they're here.
Well, sorry.
That's okay.
Apparently, this list is who's here, I'm guessing.
That's my
Yes.
understanding as well. Not yet.
The trial judge does have limited rights to determine the order and presentation of trial,
Is there
notwithstanding,
someone you
of course,
expected
the
to be on
party's
the list
wishes.
that is not?
And the judge is given every opportunity for the person to declare who he wants to be here. And so the judge can insist that they call one of these
Do you want to
names.
make a record of that? Do you want me to address it in any way?
No, not right now.
No, you don't want a record? Oh,
All right, well, then I'm going to instruct the jury to come out and then you can call your first witness.
whoa. Uh-huh. And now he's putting on a face again. I don't care whether his emotions are real or not. It just doesn't go to any fact and evidence, right? When Amber Heard was testifying, I still had doubts about facts, right? I still had some doubts. I don't have any doubts anymore. So his emotional state is now irrelevant to me. I don't care. I have all the information I need in order to dispose of this matter. His emotional state, his credibility is no longer an issue from my mind. I don't care whether he's genuine or not. I don't care about his credibility. I care about the facts, and the facts are he did the thing. He ran over the people. I'm good. You know, his credibility is not the issue at this point. My believing every word that comes out of his mouth has precious little probability of changing my assessment of the facts at this point. I do not foresee that possibility. I have reached my beyond a reasonable doubt, and I'm having a difficult time foreseeing me believing every single word that comes out of his mouth and it changing that
Thank you,
assessment.
everyone. Please be seated.
So, yeah.
All right, you may call your first witness. Actually, your second witness.
Who do you want?
I'd like to call the plaintiff, state of Wisconsin.
They're not here. No.
Object.
The objection is noted. It is sustained. Call your next witness, please.
Reason for the sustain?
Not relevant.
And you haven't named a person to go along with it.
The subpoena was accepted, Your Honor.
I'll take the issue up outside the presence of the jury if necessary. Call your next witness, please.
Well, I would like to make an oral tennis motion to dismiss for failure to appear by the plaintiff and for failure to state a claim from which relief can be granted.
That's
I
a
will
civil.
take that up outside
That's a
the
civil
presence of the
motion.
jury.
Failure to
Next
state a claim.
witness, please.
It's like a 12B6 motion.
So is the state not present?
Mr. Brooks, I'm not going to address that any further. while the jury's present. I'll take that up outside their presence. Call your next witness.
Yeah, I don't really care if his tears are weird, real. I don't care if he's crying for it. I don't care if he has regret. It doesn't change my assessment. You should go to jail for life. It doesn't change my assessment.
The defense calls Nicholas Kirby.
All right. Nicholas Kirby. Is that a
Well, he
witness
actually
in the
said a
hallway?
name.
Do we know?
I don't believe in the hallway, but we will have him brought over, Your Honor.
All right, thank you. It'll be just a moment or two. I'll wait for that witness to come into the courtroom.
Anything to delay, right? Well, Nicholas Kirby, no problem. He's in the court. He's in a different courtroom. No problem. We can forward him over. It'll take 5 minutes. You know, he's not a suspect, so we don't need to like go through any sort of like coughing him or anything. We just need to drive over there and put him in the car, drive him over, right? It'll take 5 minutes, no problem. No, we don't need any special security or anything. I don't know who Nicholas Kirby is. I have no idea. I have no idea who he is or what he could possibly offer us that would be relevant anyway. We're all going to find out together. It's fun and exciting hour here on Uncivil Law. Is the special effects guy for his rap videos?
Sir,
Okay.
would you please make your way to the witness?
No, there's
stand?
Mr.
It is,
Kirby.
One riser to my right. When you get there, please remain standing. Raise your right hand, and my clerk Teresa, who's across from you, will swear you in.
Lol.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you, sir. Please have a seat. The first thing I will ask you to do is to state your first and last names for the record, and then to spell each. Go ahead.
First name Nicholas, last name Kirby, Nicholas Kirby.
Great. Thank you. Go ahead, sir. Your witness.
Good afternoon, Mr. Kirby. How are you today?
I'm here.
What do you do for a living?
Mostly temp work.
Do you recall the events of November 21st of 2021?
All too well.
And what were you doing that day?
What time of the day?
Around 3 o'clock-ish.
3 o'clock-ish. Around 3 o'clock-ish, I was walking with Corey around Waukesha. Earlier, well, yeah.
And made reference to walking with Corey. Who is Corey?
Corey is a friend of Miss Patterson's.
And would it be fair to say that it's also a friend of yours?
Mutual friend, yes.
In reference to Corey?
Yes.
And what were you doing?
Walking around Waukesha, she was waiting for Miss Patterson to get done meeting with Mr. Brooks. You?
At 3 o'clock?
Around 3 o'clock-ish. Around that time, I had advised her not to go meet with Mr. Brooks.
You made reference to Mr. Brooks. Who's that?
That would be you.
And why would you say it would be you? That's you.
Because that's your name.
And you were privy to that information at the time?
I was privy to the information about you about a week prior to this incident.
About a week prior. And during your walking around, what were you doing with Corey?
Walking, like literally walking. We went from one store to walking around downtown after Erica told us she was going to be going to meet with Mr. Brooks. That would be you. I had advised her not to do it because it was a bad idea, and I was in fear for her safety.
This is going great, guys. This is everything a defense lawyer wants. Right out the gate, man. I didn't want to meet with you. I was in fear for her safety if they met with you. It's just going
You may
great over
reference
here,
to going
defense
from one
land.
store to another. What stores are you referencing?
Dollar General and Speedway.
Did you go anywhere else?
No.
Did you ever go to a park?
No.
Dollar General's a store.
You
It's
made
everywhere.
reference to knowing about a Brooks a week prior.
My volume's
to
loud compared to the court. I already at the court jacked up.
I didn't know everything about him. Ms. Patterson had showed me his
Yeah.
rap sheet, if you will. And
Another problem with audio, court audio levels. I fucking hate it.
I'm going to stop the witness unless you want him to go there, not to discuss what may or may not be
I'll drop my volume
conduct of
down.
Mr. Brooks prior to November 21.
I'll drop my volume down to 75%, see if it matters. Because I can't hear myself relative to the court audio. Inside StreamYard, it fucking sucks.
You made reference to a picture you were shown.
Just a photograph with a rap sheet behind it.
And at some point, did you and your mutual friend Corey meet up with Miss Patterson?
Yes.
Do you recall where that was?
Corey and I were in the Dollar General area of Waukesha.
Please feel free to tweet at StreamYard telling them to fix their audio management. Please tweet at StreamYard telling them that creators who use StreamYard can't hear their own audio or the audio of their guests, and it doesn't sound the same to them as it does to the people who are listening, and their audio management tools need work. Do that. That would be really helpful. If you want to do something helpful, tweet at StreamYard telling them to fix their audio management.
Red Apartments.
Yes.
Do you know what those apartments are called?
I do not know the name. I'm guessing they're called White Rock Apartments.
It's loud enough. You're just too loud.
And do you know if there's a
I
park
can't,
in that?
it's just like, I fuck StreamYards is what I'm saying there. It's just like, I can't fucking deal with this bullshit.
Did you ever go to Frame Park?
No. We were in that area near the park where the elementary school is and the apartments are.
About what time did you and your mutual friend Corey meet up with Miss Patterson?
Miss Patterson called me and said that she was.
About what time was the question? About what time?
I'm getting to that.
I'll direct the witness answer those questions specifically. What time?
Honestly, around what time the parade started. I would have to say like dusk. I honestly don't wear a watch, so sorry, I don't remember the time. But if I had to put it at a time, I'd probably say about 4:35-ish.
Let's back up a little bit. Around what time did you and your mutual friend Corey first hook up that day?
I had worked that whole day, so we didn't meet up until I was done working, which was probably about 2:30, 3 o'clock.
And at some point, you received a phone call from Miss Patterson?
Yes.
You yourself?
Yes.
And then at that point, what did you do?
When she told me that she was in trouble and she needed help, I went to her aid, which means I took off from where I was near Dollar General and ran to where she told me to go.
And when you got there, what did you see?
When I got there, well, halfway towards White Rock Elementary, I stopped a police officer at a barricade and I let him know that a woman was being assaulted in a vehicle.
And do you recall giving a description of who may have been assaulting your friend?
No,
Why not?
because at that point in time, the description didn't matter. I had the identity of the vehicle. So I told them you need to be looking for a red SUV with a woman screaming out of it.
And how did you come into the knowledge of the description of the vehicle?
Because I saw the vehicle.
At what point did you see the vehicle?
When Corey and I were walking up White Rock Avenue on the apartment building side of White Rock, which would have been my right if you were walking towards the train tracks that crossed White Rock. On my left was White Rock Elementary. I walked past the red vehicle, didn't realize that she was in that vehicle. Then Corey and I crossed the street to White Rock Elementary and started walking down the sidewalk. And I heard her scream, Miss Patterson scream. I don't remember exactly what she said, but she screamed and I knew it was her. So I walked back across the street and escorted her across the street over to White Rock Elementary.
It's going great. Our first witness is testifying to having a woman.
Just giving you full description.
Going great, guys.
Let's back up a
A+.
little bit because that doesn't make sense. You stated that you had a description of the vehicle. Would that be fair to say?
Yes.
The question was, how did you learn of the description of the vehicle at that point?
Miss Patterson told me over the phone that she was in a red SUV. There aren't many red SUVs with young women screaming for help in Waukesha.
Yeah, that would work. I mean, that's a sufficient description. Hi, I'm in a red SUV, and then there's a woman screaming from a red SUV. 2 + 2 is probably the same thing.
So
yeah,
I'm
that works.
assuming-
That works as an identification. Yeah,
because
I'll do
you
it.
made reference to stopping law enforcement before arriving to the scene. Would that be fair to say?
Yes.
So I'm assuming somewhere in the time of you stopping the law enforcement officer to report what you were being told, and then actually walking past the vehicle as you said you did, and then hearing this and all this, did you give a full report to law enforcement?
At the time when someone was in help and needed help immediately, absolutely not. I said there's a woman being attacked in a red SUV. You need to call for backup now.
There you go.
Then you just ran.
And then I
away.
ran towards the person that needed help.
It's going great, guys. Did you give a full description? No. Time was of the essence.
Did you at any time give a more detailed report that evening?
No, not that evening.
Did you speak with any more law enforcement that evening?
Yes.
Do you recall whom that was?
I do not recall the officer's name that showed up in the SUV coming down White Rock, in the police squad SUV. I don't even know the name of the officers that turned into Frame Park and went to the boat launch instead of where Miss Patterson, myself, and Corey were. But yes, I did speak to an officer.
How did you come into the knowledge of where officers turned and went?
Because me, Erica, and Corey were arguing with Mr. Brooks on the side of the road of White Rock, right in front of White Rock Elementary. And the officer that I had stopped at the barricade when we were coming to Miss Patterson's aid had radioed for backup, and obviously given them description of the vehicle that I had described to them, the red SUV. That backup came, but they went to Frame Park. They did not go to where we were on White Rock.
Any idea why they went to Frame Park if you specifically told them a description of a vehicle and where it was located?
I did not tell them where the vehicle was located because at first incident, Mr. Brooks had taken off in his SUV.
Okay. I didn't know where he was probably the better way to phrase that, but yeah, how would he know exactly? He might know, but like I didn't know because I didn't know where the car was. He might know, but he doesn't. This is his own witness. He's called this as his own witness. It's going just that well, guys.
In the police report, and is it fair to say that the officer that took your report was writing down what you told them?
Do you mean the officer that I alerted about the trouble in the SUV?
Well, let me back up. On the next day, the 22nd of November of 2021, did you speak with a detective at that time?
Yes, I did.
And during that interview, were they writing down what you were saying?
I believe so, yes, but I believe it may also have been recorded on tape. I'm not sure.
Fair, he doesn't know for sure. Fair. I mean, strictly speaking, he doesn't know what the officer was writing down, right? And the officer was writing. Was it responsible to what he's saying? I mean, strictly speaking, he doesn't know. Maybe the officer was putting together his shopping list for the evening. Who knows, right?
The detective that your friend Miss Patterson was being assaulted somewhere near the area of White Rock School.
Overruled. He may answer. I'll just caution Mr. Brooks about leading questions since it's his witness, but this particular question you can answer.
Yes, I mentioned that I had received a phone call from Miss Patterson and that she was being assaulted while in a vehicle.
Why do you object to that? The answer's so great.
White Rock School?
I identified the street, which is named White Rock, the apartment buildings, and the school as well as Frame Park.
So you did identify Frame Park?
I identified the entire geographical area.
He's doing fine as a witness. Just answer the questions, man. Just answer truthfully. The truth shall set you free, right? He's doing fine. He's just answering the questions truthfully, man. That's all you have to do as a witness. Just answer the questions, man. Be truthful and honest. You're there. Not that hard.
And at some point you said you heard your friend Miss Patterson screaming?
Yes.
And do you recall what she was screaming? I said, do.
No, it's excited utterance.
Ask for him the question. He's asking, did he hear? So you may answer. It's a yes or no.
I do not. Yes, she screamed. Do I remember what she was trying to say? No, I'm guessing it would be help. I'm in trouble. I would assume that that's what a person would scream when they're in trouble, is for help.
Reasonable. Also, it's not technically hearsay because it would qualify as an excited utterance, but whatever. When you're being kidnapped, that's kind of an excited utterance. So,
do we still have the exhibit with the footage from the White Rock School available?
The security footage?
The security footage, I'm sorry.
We do. Would the state be willing to pull that up?
wanted to identify which exhibit he would like us to publish.
There's 3 and 4. Door 1 and door 2 is what I have.
I'm sorry, you said do.
Exhibits 3 and 4 have been received. One is of the White Rock door 1, the other is White Rock door 2. I believe those are the videos you're referring to.
Let's try door 2.
Ooh, Money Hall. What's behind door number 2, kids? Well, my friends, it's a goat. Yes, my friends, you've won a goat.
Initially, make sure it's the one Mr. Brooks wants. I appreciate the state with their assistance. Can you see that on your monitor, Mr. Brooks? Is this the one you're looking at?
Yeah, I can see it.
I believe there's 2 clips from this, but go ahead.
Oh shit. Here we go
Can
again.
This one is roughly 7 minutes, so I would need a little bit of it played, if possible.
Which segment do you want?
And, receive, so go ahead. It'll be published, so everyone can see.
Well, before it's published, can you show it to the witness?
That's fine. We'll just play for the witness then.
I'm sorry, I should have said that before.
It's playing, so we'll let it go. Let us know if there's a point where you want it stopped.
Okay.
I'm not sure if this is the video you're looking for, though.
I think it might be door 1.
No.
It's exhibit 3.
No, maybe not. Let's watch. I could be wrong.
I was kind of thinking that too.
Take a look. Of course, none of our statements right now are any kind of evidence. We're just trying to get to the right spot.
Can you
Pause right now at 105.
105. Can you back it up a few seconds? Not 2 or 3, but maybe 5 seconds, 6 seconds, maybe.
59 seconds. It is on the witness stand, by the way, just so you're aware.
Okay.
Just watching it.
Can you play from here? I don't think it's playing.
It's playing.
Oh, okay. Pause right there. From what you can see in this video, do you see anyone get in or out of the vehicle that you see on your screen?
Miss Patterson has just exited the vehicle.
Just for the record, the video was played. It's exhibit 4 from 56 seconds to 1:21. Go ahead.
I didn't hear the answer.
Miss Patterson was the one that exited the red SUV.
You saw someone exit.
Yes.
Can you wind it back?
To what? Again?
You want it back to 56 seconds?
No, to 105, where it was paused the first time.
Okay. Thank you for attempting to do that, Ms. Gussie. It is paused at 1:05. Do you want to play from?
Yes, I'm sorry.
And the jury still hasn't seen any of this, by the way, because it's not been published. So the witness can see it, but the jury isn't seeing whatever he's looking at. Because that's what he wanted. They offered to publish, and he said, no, I just want it for the witness. Okay.
Paused again at 1:21.
Oh, okay.
Did you see anyone from, in the video that you're being shown now, from about the 1 minute and 5 second mark to where it's paused right now at 1 minute and 21 seconds? Did you observe anyone get in or out of the vehicle?
I'm going to take back what I said earlier. Apparently, according to this video, she did not exit your vehicle. She was behind the White Rock sign. That's why I did not see her.
Did you see anyone get into the vehicle?
Later on within the incident, yes.
On the video that you are able to view right now, from the 1 minute and 5 second mark to the 1 minute and 21 second mark, did you observe anyone get into the vehicle?
No.
Can you publish for the jury?
You want to replay it again?
Yes.
Go ahead. We'll start at the, close to the minute mark as possible.
Again, is that where the defendant would like it started?
Around the 105, around that area.
105, exhibit 4.
I know we have to wait for the jury, right?
Yeah, we have to
And then
wait.
you want it to the minute 21 mark again?
Yes,
All right,
if I may.
Go ahead.
You may. This is illuminating footage, guys. This is breaking open the whole case, man. Yep.
And
It's breaking open the whole case.
at that time, were you already en route to where you believe your friend was being assaulted at?
Objection calls for speculation. This defendant has not even put this witness at this location at this time. He's just having him testify about what he's seeing in video.
I understand the objection. It's sustained. Please establish some foundation for this witness being present at that location.
Were you-
more information about the incident?
Were you present at this time?
We were on White Rock Avenue, but we were not in the general location of the school as of yet, as of that point in time.
So to your recollection, you didn't see anything that you're seeing right now or on this video. You did not see the day of the incident?
No, I definitely saw Miss Patterson in a red SUV that day.
Did you see?
At this specific time, no. Because I was down the road on White Rock talking to an officer who was manning the intersection of Hartwell and White Rock and reporting at that time.
There's not enough money in this world,
Can
RP
we
cubed.
play a little bit more?
It's not worth my time or energy to try to do a rebuttal on becoming a state national.
Relevance. If he wants to
That's
direct the video to a certain time that.
also, incidentally, for what it's worth, you are a citizen of the state in which you reside under the 14th Amendment. So if your argument is, I'm a citizen of Texas, for example, yes, you are. Congratulations.
And ask general questions.
There's only been one video that's been shown.
I'm going to give Mr. Brooks some leeway on this. The video is to be played from this moment, and then Mr. Brooks tell us when you want it to stop.
Okay, what I'm attempting to do for the record, Your Honor, is
Just play the video and you can ask your question.
all right.
Go ahead.
Can you pause it right there?
Video's paused at 1:38.
By what you are viewing in this video right now, had you and your mutual friend Corey linked up with Miss Patterson at that point?
At this point in time in the video, given from what I've just seen, that was when Erica was on the phone trying to get a hold of me. We were already on White Rock at that point in time. We were not near the school at that point in time, though.
So that was when you would, to your recollection, that's when you would say the phone call to you was made?
One of the phone calls, yes, she made multiple phone calls to me. I think probably about 6. I had been having issues with my phone that day, so it had been turned on and off multiple times. The final time that it was turned on was when I picked up her phone call and she said, I need help. I'm in trouble. Come help me. I'm being assaulted.
You just
That's
made
when I left.
you just made reference to that point in the vehicle being I'm sorry. Oh, I'm so drained. That point in the video
You're
was
drained.
when you made reference to that point in the video being when you received the phone call.
You know, maybe you could get assistance to counsel. Maybe that would help with the drainness.
Multiple from her.
That would
That's
help with
fair.
it being
A phone call.
drained because it would be someone else's job and they could take turns and, you know, they could have
Would
multiple
it be
different
fair to
attorneys
say,
and
though,
different witnesses
would it be
and
fair to say
focusing on
that
different things. So you didn't have
this
to
is
do
in
everything
reference
yourself.
to
Maybe
you
that's an
saying
idea.
that you were having issues with your phone that day? Would it be fair to say that you're not sure how many phone calls you had received that day or who they were from?
I only received 51 phone calls on my phone that day. That I actually do know.
One baby to another says I'm lucky to met you.
All around the town.
I don't give a
Obviously didn't wanna
damn
get
what
off
you
the phone
think
because
if
no one
it
called me
isn't
6 times
about
in a row unless
me.
they need some help.
It is now my duty to completely drain you.
Go ahead.
Can you pause right there very quick?
Paused at 1 minute, 47 seconds.
Do you see in this video your friend Miss Patterson walking back in the direction that she had just come from?
I see her on the phone talking to someone, which I assume would be me, telling me where
Mr.
she.
Kirby, I need you to answer the specific question that's being asked at the moment, okay?
All right.
Thank you.
Yes, I see her on White Rock on the phone, walking back in the direction she was originally.
Again, Your Honor, I
Coming
can object
from.
to this line of questioning unless the defendant can put this witness there. I don't know what the relevance of this testimony is.
Well, the exhibit has been received, it's been published previously.
Absolutely.
So I'm gonna give Mr. Brooks some leeway here, overruled. I would like you to get to where you need to go, though.
That was the next question. At this point in the video, had you yet come into a range where you and your mutual friend Corey, had you yet come into a range where you can see Miss Patterson at that point?
Corey was the one that spotted her first.
Could you yourself see her at that point?
I heard her scream. That's what caught my attention.
And you made reference to that scream being heard from inside the vehicle. Would that be fair to say?
Yes, because that's where she was when she called me. And I was still on the phone with her while going down White Rock Avenue. Even while I was talking to the officer, I said, I'm on the phone with her right now. I'm trying to figure out where she is. Can you please call for backup? So we continued down White Rock to look for Miss Patterson.
Would it be fair to say that in the phone call you received, she told you where she was at, and that's the area that you were generally responding to with your mutual friend Corey?
Miss Patterson doesn't know Waukesha. I knew the area she was talking about because I live in that area.
Would it be fair to say that you just testified to when you had the interaction with law enforcement that you stated you're on the phone with her right now trying to figure out where she was? So would it be fair to say at that point you didn't know where she was?
I knew that she was on White Rock. I didn't know exactly where or how far down on White Rock she was at that point in time. At that specific time, I did not know. It wasn't until I seen a red SUV parked in front of the apartment buildings on White Rock that I figured that might be the one that she was in. It was Corey who spotted her across from the road.
We're paused at the 1 minute and 47 second mark of the video. it's a little hard to see.
Uh-oh. I closed the video by accident. I swear. I didn't mean to close it. Or did I? Was my subconscious trying to save me from myself? Was I acting involuntarily and my mouse just went over to the place to hit the button? Honestly, not sure. Maybe I wanted it to happen. Maybe I wanted it to happen really deep. Maybe my subconscious is trying to save myself. Yeah, it could be a lot of these things. Let's ignore all that and just go back to the let's go back to the trial. You can do it. You can do it. You're a good on civil law. You're a good on civil law, and you're a strong on civil law, and you're mentally resilient. You can do this. I believe in you. Okay, got it. Sorry for the slight delay. It's having some problems with the window resolution.
Pause there. At this point, had you come into a range where you can see Miss Patterson at that point?
No.
The record video's paused at 2:13.
I'm sorry.
It's all right.
213.
Keep going.
And you made reference to your friend Corey spotting her first.
Yeah.
Is that correct?
Corey had said that she thought she had seen her across the street. And we looked and we crossed the street once and then we crossed the street back over. Then we crossed again for the final time. That wasn't until later when the incident with Mr. Brooks took place.
And at this point, walking with your friend Corey, had she alerted you to spotting Miss Patterson at that point?
She said she's over here. She must be out of his car now or something. She said something along the lines of that. So we went across the street and there was Miss Patterson hobbling down the street with a boot on her leg.
You made reference to your friend Corey saying she must be out of his car now. Do you know, as you were walking with your friend Corey, do you know if she observed Miss Patterson being in a vehicle at that point?
She was with me when the phone call came. So I assume that when someone tells me that they're in a vehicle, then they are in a vehicle. That does not mean that they would be in a vehicle by the time I got there. I was on foot and I wasn't walking, I was running.
Nice, good answer. Good job.
Can you play it from 2:13? Hard to see that in that corner.
Hold on, let it play.
Okay. Pause right there. Is that 409?
Yes.
Would it be fair to say we see some individuals walking right here? Are you able to see that in the video?
Yes, I can see it.
At that time, had you come close enough to the scene where you can observe any individuals in that area?
I don't remember the people that were in that area. I was only focused on the one, and that was the one in danger.
Could you
So no,
could you at that point observe Miss Patterson?
from my point on the street, from where I was
At that time, yeah, where's paused at now?
during a parade, no.
Can we clear the circle? Thank you. We observed at some point Miss Patterson crossing over to the opposite side of the road.
Yes.
Did you see that?
Yes.
Any
I was
eye-
on the phone with her at that point.
Could you observe from coming down White Rock? Can you observe that from where you were at that time?
I was at the intersection of White Rock and Hartwell when she said that she was by some red apartment buildings.
Could you see her from that position?
No, not from that far down.
Can we play it from 409?
Go ahead.
Pause right there.
Pausing at 4:18.
418, I'm sorry.
Go ahead.
You see the two individuals here?
Yep.
Do you know who those individuals are?
That's me and Miss Corey.
So at 409 to 418, you were able to come into view of Miss Patterson at that point?
No. I wasn't. I was on my phone trying to call her back to find out where she was.
Can we clear this circle? Thank you. So at this point right here where the video is paused, 418, you weren't able to observe Miss Patterson on White Rock Avenue at that point?
Ask the answer.
Huh?
Overruled, the witness may answer.
I was not looking ahead of me. As you can tell by the video, I was looking at my phone trying to call Miss Patterson back because she was not answering her phone. That scared me. So I told Corey to keep an eye out, look for her as I tried to keep calling her. When I looked up and we got past the White Rock Elementary School sign, that was when I seen her.
Would it be fair to say that judging from the video, the White Rock, let me back up. Are you referring to the sign right here that says White Rock Campus?
I'm referring to where the end of the school building itself meets the driveway or the road that's there. There's a turnoff road.
I apologize. Can we take that X from next to the White Rock Campus sign?
What?
So can you point to exactly what you're referring to?
Where that intersection is, where I just drew that little X, that intersection cuts across from the other side of White Rock to the other side and leads to a road, but also there's the frame park area there, and I believe there's a boat launch there somewhere. I don't know.
And at that point, you were able to observe Miss Patterson.
I observed her walking when Corey had told me that she had seen her. And so we grabbed her and started to leave to turn around. At that point in time, an officer was coming to Frame Park because of the report that I had given.
So you observed Miss Patterson walking and not inside of a vehicle?
At that point in time, no.
No, as in
she was not in a vehicle at that point in time when we finally came upon her.
So when, if at any time did you observe Miss Patterson inside of a vehicle?
When she was going into his vehicle to get her things, or whatever it was that she was trying to pull out of his car, her phone or something or whatever.
Can we play the video from 418?
Go ahead.
Oh shit. Here we go.
Oh,
again.
I'm sorry. Can we clear the X?
Continuing to
Sorry
play
about
from
that.
4:18. It's at 4:21, but go ahead.
pause right here. Is it fair to say it stopped at 4 minutes and 38 seconds? Is it fair to say from the video that two people right there are crossing the road?
Yes.
And do you know the identity of those two people?
That's me and Miss Corey.
Would it be fair to say that at that time you observed Ms. Patterson?
That was when I first noticed the red Jeep or red SUV, whatever you want to call it, across the street. We had zigzagged up White Rock.
I haven't gotten my Jaeger drink yet.
Going from one side to another looking
I'll go to the
for
store
Erica.
today and get it.
When we ended up
Now that
on
I'm my
this
car
side,
back.
the red SUV was parked in front of the apartment buildings. There was a tree here, and Miss Erica came from the passenger side of the vehicle around the back. That's when I heard her yell something. That's when I went over.
You made reference to Ms. Patterson coming from around the vehicle.
Coming from the passenger side. So I had assumed that she had just gotten out of the vehicle.
Do you know that for sure?
If I didn't see her earlier when I was on White Rock or a vehicle earlier on White Rock, how could I know?
Did you see her in the vehicle at that time?
I seen her come from around the vehicle. I am not actually sure if she was in the vehicle at that point in time.
Thank
I
you.
was just going by what she said over the phone.
Okay.
So my
understood.
assumption is that she was in a vehicle.
All right, next question.
So see, the judge just asked a question. Judges can ask questions too, right? And they usually use it for that purpose, like as a bridge.
Do we have a better view
Especially in this
of
case, like so
this- of
trying to
this
get
point
clarification. So
in
judges can ask
particular?
questions.
I don't know.
Maybe on Exhibit 3 might be a better view of
Trying to translate the
This-
insanity into something that might make
If you want
sense.
a specific spot to direct the state to, then I will have them do that, but
can we view Exhibit 3?
do you have a specific spot to direct the state to on Exhibit 3?
I'm not sure. It's been
Oh shit.
I don't know how
Here
long
we go
since
again.
viewed that exhibit. I don't know how long it is.
Bruh. Bruh.
I'm just reviewing my notes. If there's a specific spot that you recall, I might be able to direct the state to that. But you'll have to give me a little more information.
Okay. I think that's why I was stating about the length of the video. I'm pretty sure I would know the exact spot. I don't know how long that video is. It's towards the end of it. I know that for sure.
Rita, I will never stop with Elevator Muzak. The Elevator Muzak will live forever.
Can you ask your next question? You need to be able to tell the state with more specificity which part of which exhibit and at what point.
Well, I know the exhibit. The exhibit would be 3.
StreamYards has apparently failed.
The spot, judging on the length of the exhibit, would be towards the end of the exhibit.
And you're sure it's Exhibit 3?
That would be White Rock Door 1, correct?
That's my understanding. Right, so we're done with this exhibit?
Yes.
All right, turn that off. Just
Yes.
I had to restart. I had to restart the window. Chat was
like
frozen.
Yeah, about 4:14, a little over 4 minutes.
Steve says, "Kurt, lose the drama and the
so,
music. We watched this for your legal
I would say
interpretation.
around
Something
about
entertainment value, legal interpretation, not your entertainment value." Steve,
30-ish mark. If that helps.
well, we're gonna just show it to you in the state. If it helps you, then you can ask this witness a question about it. Otherwise, we're gonna move on.
I would say take it back to about 3:15.
This is the footage, though, you're looking
Yes,
for?
this is the footage. Yes.
Is that where you want to start?
Actually, let's go 3 minutes exactly. This is definitely the video.
All right, this has previously been received. Why don't we watch it from this point forward and then ask your questions?
But before it's played,
Don't hit that yet. Sorry. Turn
waiting
off.
for the jury.
Go ahead, tell me what you want to do. That was a mistake on our part. It's just
You
in
can
front
show
of
it.
you and the witness at the moment.
Yeah, that's fine right now.
Well, I don't want to have to play it twice for the jury. So if you're
Oh.
going to question him, let's show it. It's already been admitted.
So should it just publish
Why
now
don't
or
we
just
publish it from this point, play it, and you can ask the witness questions regarding it, okay?
okay?
All right, so it's at 3 minutes.
the one word soundbite Nick gave me, I honestly don't remember what was the one word. What was
I
the
have about a
one
minute and 14
word
seconds to get from this
soundbite
one.
Nick gave me? I honestly don't remember the reference.
Yes, we'll publish
Oh.
now. Jury, if you can let me know when it's on the monitors in the jury box.
No,
That may take a little longer.
is that a soundbite? How about no?
Do you right now it's paused at 3 minutes. Does looking at this video right now bring any recollection of that?
Everyone say
day
goodbye to
back
Colin. Bye.
Yeah.
Colin doesn't want the music either. Colin.
And using the touchscreen, can you identify if you see yourself in this video? Can you identify where you are? Right here. And can you identify who the other person is that's shown on the exhibit?
That's Miss Corey.
You can play from right
Let's
there.
clear that first and then
Oh,
play.
I'm sorry. Well, before we play, could you see from right there where you are? Can you see Miss Patterson, where her position is at that point?
No.
Can we play it from right there?
Go ahead.
Can we pause?
I'm gonna have fun on this channel. I'm gonna have
It's fair
fun.
to say
I'm
that
gonna
we
entertain
can
myself.
see you and Miss Corey
Legal
running
education
towards
and
the
entertainment.
area of the vehicle that just
And my
stopped.
personality.
Is that fair to say?
If all you want is just pure
And
law,
where was Miss Patterson
if
at
all
the
you
time,
want,
if you recall?
if all you want is just pure
At that
law
point in time, she
with no
had
entertainment,
met up
just
with
watch
Corey.
continuing legal
Corey
educations.
had walked ahead of me.
You can sign up for
And
you can sign up
her
for
and
them
I
yourself. There's plenty of
were looking
companies
for
out
her.
there that
I
sell
didn't see her
CLE. You
right
can get
away.
yourself an
Corey
annual
did.
subscription for like $99.
And she
And just
said
watch continuing
she
legal
just told me
educations. You'll
she's
get
in the
all the
red
law
car.
with none
So
of the
that's what we were
entertainment
looking
value.
for.
At that time, was Miss Patterson inside of the vehicle?
I do
That's
not
what you
recall.
want. It's readily available.
But what I do recall is the owner of the vehicle getting out of the vehicle, and that became my primary concern.
So fast a little bit. We observed the two, you and Miss Corey running towards the area of the vehicle. Why such the urgency?
Miss Patterson is a mutual friend of ours. She said she was in trouble. I don't play around when people are in trouble.
Can we play it from, it's paused at 3 minutes and 8 seconds. Can we play a little bit of it from there?
Go ahead.
Pause right there. Can you see Miss Patterson? It's paused at 3 minutes and 11 seconds. Do you see Miss Patterson in this video? Where's
Yes.
paused at right now?
Yes.
Is she inside the vehicle?
No, she is not.
Had you seen her before that?
Corey had spotted her, not me before that. She did.
But it is fair to say that you're also in the area at
I
that
am
time, correct?
not in this general frame, no. I'm
Not
actually outside the frame.
not the video, but you are present on the scene. Would that
Oh,
be fair to
yes.
say?
Yes.
And what happened at this point, if you recall?
At this point, there was a physical altercation between Mr. Brooks and Miss Corey and Miss Erica. I was more worried about Miss Patterson being hurt, so I went for her to get her out of the way. I stepped between them as best I could, and I told Mr. Brooks he needs to leave. He needs to get out of here. Does not belong out here.
Do you recall if there was a knife involved at that time?
No, that is a miscommunication. And I will clarify that. The Monday,
Hold on, there's not a question yet.
Okay.
He'll ask the questions. I appreciate that, but just answer the questions that are asked at this point. Go ahead.
Did you at any point during this altercation, did you observe Miss Patterson get back into the vehicle at that point?
I observed her reaching into the vehicle for something. I don't know if she was grabbing a purse or something or whatnot. She was grabbing something of her personal property out of the vehicle.
Did you observe
while
her?
this was going on?
Did you observe her get into the vehicle?
No.
Can we play it from 3 minutes and 11 seconds, please?
Go ahead.
What claw mango? That sounds promising. Oh,
Pause it
there's
right
a little
there.
fight going on there on the street.
Did you see yourself come into the frame in this vehicle at that
Yes.
point? Would that be you there?
Yes.
It would be fair to say that you had some type of jacket on, or a black jacket.
At one point,
that
yes.
evening? What happened to your jacket at that point?
That jacket hit the ground as soon as Mr. Brooks
Good night,
started
state of
going for the two
Wisconsin.
women.
Enjoy your rest. You've deserved it at this point.
So you threw the jacket off,
Mm-hmm.
Is that a yes?
Yes, ma'am.
Thank you.
and what was your reason for throwing the jacket off?
Well, if the court don't hate me for it, I'm just going to say it's a good thing that there were two women in my way at that point in time.
And what do you mean by that?
That means when my jacket comes off, trouble's going to happen. Especially if you're trying to assault a woman in front of me.
Okay.
So that gesture
I'm
was
feeling
an
it.
aggressive gesture.
Oh, that was a completely focused gesture.
Well, you did make reference to.
He wants to kill you.
Let me back up. Would it be fair to say that you just made reference to trouble following you throwing off your jacket?
No, not trouble following me.
Well, maybe that's the wrong way to put it, but
I'm
there would
confused
be
by your
trouble.
question.
Excuse me?
Can you rephrase your question?
Oh, I will. I'm sorry about that. You made reference to there being trouble when your jacket comes off. Is that fair to say?
Yes.
Would it be fair to say that that would be, or that could be, perceived as an aggressive gesture?
You mean as an
Calls for speculation. How it's perceived calls for speculation.
Sustained as to the form of the question.
If you recall, who gave the report that there was a knife involved?
Thank you, Polly Prissy Pants.
That was not put into a report. That was a miscommunication between me and an officer. I had been knifed earlier that week and had 12 stitches in one hand.
Okay. The guy gets around. He'd been knifed earlier that week and had 12 stitches. I'm beginning to believe him when he says when his jacket comes off, there's trouble.
No, there was never any knife. I didn't have a knife. Miss Patterson, Miss Corey didn't have a knife. You didn't have a knife.
This guy's been in a street fight once or twice.
The report that was taken.
He was in a night fight and lived to tell the tale. Wow. Okay.
Well, I'm the one. You mean you're talking about when I was on White Rock going to Miss Patterson?
No. The day of November 2020, the day of November 22nd, 2021. You made reference already to being interviewed by a detective, correct?
Yes.
And had you, after that, seen that report from that day?
No.
Are you almost done? Please stop talking. I'll give you $10 for your prison commissary if you stop talking right now.
And you stated that the reporting of the knife was a miscommunication.
Yes.
Referred to it as.
Yes.
Did you at any time tell law enforcement that there was a knife involved in the altercation?
No.
Do you know if your friend Corey told law enforcement that there was a knife involved in the altercation?
No, she did not.
Do you know if your friend Miss Patterson told any law enforcement that there was a knife involved in the altercation?
She did not as well. No.
Maybe, Kathleen. Maybe. That, of course, in no way excuses Brooks. But
And how
yeah,
long
maybe.
before the incident on November 21 of 2021 had you known Miss Patterson up until that point?
Probably maybe a week and a half, 2 weeks.
I want to back up to the phone call that you received from Miss Patterson.
Who's this guy in the tracksuit behind
Okay.
the defendant?
When
Is
she
anyone in
did she
particular? Does anyone
give
know?
you a name of whoever may have been assaulting her?
I'm thinking he might be a
She
relative
didn't
or something.
have
That's
to.
why I ask.
She was meeting one person that day, and I knew exactly who he was because she had showed me his picture and rap sheet prior. Her child's father, the father of their 15-year-old daughter, is who she was meeting up with that day. And I
That's
told her
what people
multiple
ask me.
times, it's not a good idea. I have a bad feeling about this.
Do you recall stating, well, actually, you testified to that here today. Do you recall stating that you walked past the red SUV that was parked?
Yes.
Would it be fair to say from the two exhibit videos that we watched today that
Thank you
in
very
fact did
much,
not
Stephen,
walk past any SUV?
for tipping
I
$10.
most
Appreciate it. Thank you very, very
definitely walked
much.
past an SUV that was red on White Rock Avenue. Whether or not it was your specific SUV, it was still a red SUV. Up until this point, knowing Miss Patterson, I didn't know anything about the father of her child. I didn't know anything about his background except for what she showed me over the phone. Anything about his vehicle description, why would she need to tell me that?
Is it fair to say that the video doesn't show you walking past any red SUV?
If the
Is
video,
that fair to say?
if the video proves that, then yes.
In the report that you, well, in the report that was taken from you by detective, do you yourself recall stating that the alleged defendant tried to punch and push you?
The alleged defendant being you, yes. Attempted to.
Would it be fair to say from the video that it doesn't show you being pushed, or
No, it does not. It shows me pulling two women away from the situation.
any reason why you would state to detectives that the alleged defendant attempted to punch and push you?
Probably because there were three different people's fists flying, and I was just trying to get the people that I cared about out of the way of danger. So if my statement to the detective is off a little bit after watching a bunch of people get run over, I can understand why.
So you were at the parade that day?
I was not at the parade that day. I was in the area
So
trying
how
to get back to my house.
so how can you watch people being run over if you weren't at the parade that day?
I wasn't attending the parade. I was in the area that the parade route was in. My street is the parade route.
Did you see anyone injured that day
When
during the parade?
Yes, after I walked back through that area,
You saw someone get injured?
I saw a red SUV take off like a bat out of hell down Main Street and
you
go
see-
through a crowd of people.
The question was, did you see this take place?
Yes.
With my own freaking eyes. Yes. How many times do I have to say yes for you to understand it?
Nice.
YES spells yes.
Nice.
I'm sorry, Your Honor, I don't know how to.
Are you moving to strike the last response?
Yeah.
The jury will disregard the last response. I'm just going to remind both of you, please answer the questions that are asked. Follow-up needs to take place. Either Mr. Brooks or the state will ask.
Is it fair to, well, in reference to
Mr. Brooks, I'd like to applaud your decision in calling this witness
that we just viewed?
as the first witness to your defense.
talking
I
about
think
the
the
ones
calling
that
of this
elementary
witness continues to
Yeah,
manifest the
one that we
judgment
just
and reason that we've come to expect from you. And I'd
Is
just
it
like to
fair
applaud you
say
in your
from
choices.
that vehicle
This is truly
got me.
Video.
the best thing that you've done so far this
That
trial.
Video. Is it fair to say from that video that, in fact, there are not three people throwing punches? That'd be fair to say?
There are three people throwing hands in that video: Erica, Corey, and Mr. Brooks. Not myself. If you watch the video, you will see 3 pairs of hands go up towards one another. Whether one is stepping in to pull someone away from another or not, hands are being brought up.
Yeah. Yeah, that's exactly right, man. Everything is funny because if not, we'd be crying all the time. Yeah, that's about right. Yeah.
Do you recall where you went after that altercation?
You mean where me and the 2 girls went? Where me and Miss Patterson and Miss Corey went?
Where you and
we
your
started,
2 friends went? Yes.
We started walking back. We turned to walk back the direction we had came. So taking White Rock to Main Street and then cutting through the neighborhood there to get over to where the women's shelter was. That was where we were going at that point in time. However, things took a drastic turn when the red SUV that I have described multiple times went down the opposite direction of White Rock Avenue across the railroad tracks. And
You think the state
intersection
has
of
any
Perkins
cross-examination
and
at
White
all?
Rock, and then turned back around and came back
I'm not
down.
sure you
That is
do.
what you saw in the
I'm not sure
video
you
here
ask
when
anything
the
on cross if you're the
red
state.
vehicle pulled up on the
You're like, we have
school
no
side of White
questions.
Rock.
Just try to get this farce over with. The witness
After
is
the
good for you as it is.
altercation
What do you need to
between Ms.
clarify?
Patterson, Mr. Brooks, Miss Corey, and myself.
My
the
my
three of us,
instinct is no cross-examination.
Miss Patterson, Miss Corey, we started to leave. I told Mr. Brooks, you need to get out of here. The police have been called. You need to leave. You need to leave now. You do not belong here. I did not expect.
Can you strike everything that's not pertaining to the question that was asked?
Actually, I'm just describing the entire event in its entirety.
I understand. I'll strike the response as being non-responsive to the question. The jury is to disregard it. Re-ask your question again.
Okay. Do you recall where you and your 2 female friends went after the altercation?
We started to head back in the direction of the women's shelter where they lived, where they were staying at the time.
Do you recall at any point during your travels to the women's shelter, as you referred to it, do you recall at any time coming into contact with another law enforcement officer?
Within that point in time, no. Except for the one that pulled out of Frame Park.
Do you recall at any time being stopped by a law enforcement officer on your way back to the women's shelter?
We were stopped partway down White Rock, and that was when I had told the officer, because he wouldn't get out of his SUV, I had let him know that they need to be on the lookout for a red SUV that took off back down White Rock towards Perkins Avenue, or street or road, whatever it is. The officer had asked me if there was someone with a knife, and that was when I held up my left hand, and I said, no. I said, I have 12 stitches from a knife injury on this hand, but this is what you need to be looking for, is this red SUV. And I'm guessing that's where the miscommunication of the knife came in, and I don't know where that officer went after that.
And would it be fair to say that that was the second law enforcement officer that you had spoke with that day at that time?
Yes. You are referring to November 21st?
Correct.
Okay.
During that interaction with the second law enforcement officer, do you yourself recall stating that a black guy just assaulted my friend?
No.
Any reason why the officer would report that?
Objection calls for speculation.
Rounds.
Sustained. Calls for speculation.
Did you yourself sustain any injuries during the altercation?
I ripped open 3 stitches on my hand, but that was more so from pulling Miss Corey away from Mr. Brooks so we could get out of there.
Okay. Guy's a badass.
Did you report to any law enforcement?
Well,
Well,
he is a
I guess that
aggressive
would refer to
streak.
the second
Better.
law enforcement officer that you spoke with. Did you report that to that officer?
No. Because at the time I didn't notice it. I didn't notice my hand was ripped open again until I got home.
So it would be fair to say that you don't know how those stitches opened up. Would that be fair to say?
No, I'm pretty sure I know how they opened. My stitches got caught on the zipper on Corey's backpack. That's how the stitches were ripped out of my hand when I was trying to pull her away from Mr. Brooks and intervene between her, Mr. Brooks, and Miss Patterson.
Knowing a little bit about stitches, would it be fair to say that a wound that was stitched being reopened would cause a little bit of pain? Would that be fair to say?
Objection. Relevance.
Rounds.
Sustained. Relevance.
Did you notice any blood from the stitches being reopened?
Didn't feel anything until I actually looked at it when I got home. 12 stitches coming across my thumb in kind of like a fish hook type pattern. It was the 2 over here that ripped open and the 1 up here. Or actually, I take that back, the 1 up here.
So just for the record, he's holding his left hand. He had his thumb out, extended almost like an L, but with the other fingers almost like a C. And he was pointing to his left thumb near, I would say, the middle of the thumb, and then the curve of the thumb where on the inside where it goes up toward the index finger. Sorry, I have to make a record of all.
No,
that.
that's just fine.
Go ahead.
So was it 2 stitches that opened or 3?
Objection. Relevance.
Grounds.
Overruled. He may answer, but then move on.
It was 3.
And do you recall what time you made it home that evening?
Absolutely not.
Was it immediately after the altercation or sometime after? Or
No, I took the girls back to the shelter, and then I started running back towards Main Street to try and see if I could avoid the parade traffic. And that's when I saw the red SUV go down Main Street.
and do you recall speaking with your women friends after you had made it home that evening?
Yes.
Did at any time you indicate to them that you,
Hold on, let him finish the question. He was asking what he indicated
strike
to
the
them.
question? I thought that's what I said.
You can ask your question. That's what I thought you were saying too.
Did you yourself at any time indicate to your female friends that you had sustained injury during the altercation?
No.
Objection of relevance.
Overruled, his answer may stand.
In the time that you had known Miss Patterson up until that day of November 21st of 2021, had you yourself ever heard Miss Patterson refer to the alleged defendant by a different name?
Objection of relevance.
Grounds.
Overruled, the witness may answer if he knows.
No. You mean like an alias or something?
A different name.
Well, okay, that could, a nickname, an alias. I mean, let's be specific here.
Did Ms. Patterson ever refer to him with another name? If you recall.
Not that I can personally recall, no, ma'am.
All right, thank you.
Do you recall if, to your knowledge, was your friend Miss Corey, as you referred to her, do you recall her stating that she was injured during the altercation?
She did tell me that she I believe she like hurt her finger or her fingernail or something like that, but I don't think it was relevant to the incident that had happened.
What do you mean by you don't think it was relevant to the incident that happened?
Objection of relevance.
Sustained is to the form of the question.
No further questions?
Hey.
Before I decide whether to do cross at this time, how long do you believe it will be?
0 minutes because I have no cross.
All right, thank you.
There you go.
Step down, and we're gonna
Wave
take a break.
cross. All right, guys. I also have to take a brief break because I have to fish.
Give me a second. I'll rise for the jury. Let me excuse the jury for a second.
I don't know if he's crying, if he's laughing, if he's what he's doing. He's a interesting character. I'm sure he's going to have an interesting time with interesting friends in an interesting prison.
All right, thank you. You may be seated. You may step down, sir. And I presume he may be released from his subpoena, Mr. Brooks? You're done questioning him?
Yeah,
All right, you are released from your subpoena, sir. All right, let's take about a 15-minute break.
All right, guys,
Anything we
I
need
have to
address
go.
Prior to that, or can we do it when we come back?
No, thank you.
All right, Mr. Brooks, work with the state, please, for the next witness. We have them available.
All right, guys, I got to run an errand real fast. So it'll probably be about 5 minutes. I'll be right back, and then we can talk some more. Okay, so we got to take a brief break, but I'll leave you on with some music so you don't have too bad a time without me. Hello, everyone. How's it going? Well, in today's problems in Kurt World, I have lost my car key in the car. I didn't have it on my key ring. Because I gave it to the people who were repairing my car. So when they dropped off the car, they dropped off the key. And rather than put it right back on my key ring like a sane person, I had it in my hand. And I fumbled it around and it is now inside my car somewhere. I pulled up the front seats all the way to the front, pushed them all the way to the back. Tried reaching under the seats. Tried looking everywhere. I haven't found it yet. So my frustration is high. You can't hear me. I understand. Streamer, it's fucking bullshit. Okay. I have lost my car key in the car. I was having my car repaired, and the people who were repairing it were kind enough to drop it off at my apartment complex. I told them to leave the key with the manager. So the key was just sitting it by itself. I went to pick up the key from the manager of the building. And when I was driving it to my place, I dropped the key. It is now in my car, and I can't find it. It's a battery powered key. So the car is unlocked. And the car can be started because the key is now in the car. So I do have a spare key. That's not the problem. I have spare keys. That's not the problem. The problem is as long as the key's in the car, the car can start because the key is in the car. So I need to find it. I have copies of the key. So Audio levels are a disaster. Thank you, Matova. That just really brightens my mood to say that the audio levels are disaster. That's just really freaking. Yeah, so I pulled the seat all the way up. I pushed the seat all the way back. I removed the mats. I've looked everywhere. And that's somewhere lost in the car. The car is at my house. The car is at my house. The key to the car is in the car. It is lost in the car. The car is unlocked. No, it's me. I had the key in my hand. I had the key in my hand. I fumbled the key. I fumbled the key. It was in my hand. I fumbled the key. It is not in the glove box. It is somewhere under the seats or somewhere, and I can't quite find it. It is in the car. Sure it's not under the car? Pretty sure. Yes. What kind of car would it matter? Could it have fallen backwards from his backseat? Yeah. So I can't find it. The tile wouldn't help because the tile would be on the key ring and the car key is not on the key ring. I'll figure it out. I'll figure it out. I'll go get a clothes hanger and fish under there and see if I can figure it out. I'll figure it out. I have to have the seats removed. I'm not sure it's going to be that necessary. Magnet on a stick? Maybe. Yeah, I'll figure it out. It's a, it's an electronic key, so it's kind of bulky too. It's not a flat key. It's a little bulky, so it shouldn't be that hard to figure out where it is. It's an electronic key. So we'll figure it out. Yeah, reset the key and give me new keys. I guess you could do that too. No, I haven't locked the car. The car won't lock as long as the key is in the car. So the car's unlocked. It won't lock as long as the key's in the car. It's smart enough to know if the key's in the car. Which also tells me the key's in the car is also how I know, because I press the lock button. It's like, it beeps at me. It says, okay, the key's still in the car. So I know it's in the car. I'll figure it out. Just minor annoying thing that adds to my day. Even with the valet key, I don't know about a valet key. I'll find it, yeah. I just gotta go fishing again. Doors, I'll check the doors. I'll check the doors when I get back. It could be in the, it could be in there. It could be in the door pocket. That's possible. I did find some things in my car actually along the way. I found a pair of headphones. So far already, I found a pair of headphones in my car that I didn't know I had, and I found I found a battery charger that you can, like, a portable battery for like charging things for like a phone or something. I found that in my car. It's probably been in my car. Those things have probably been in my car for several years. So hey, I found 2 objects already that I didn't know were in my car. So, I found a pair of earphones and I found a battery. Wedged in the seat? Yeah, maybe. St. Anthony will help me if I ask. I'll ask anyone that helps. Under the clutch? That would be kind of hard. That would be kind of hard. It would be kind of hard to be under the clutch. Probably not under the clutch. When I find it, put a lanyard on it. Just put it on my key ring. No, the key's in the car. Do you still sell the club? Probably. In the visor, it is not in the visor. An RFID tracking device? Yeah. Look under the floor mat, maybe. RFID tag detector. Yeah. Maybe there's an app for that. I'm gonna go hunt for the car again. I'm gonna go hunt for the key for again. Indoor pocket driver's side, it might be. It might be there. Yeah, let me go look. I'll be back.
We are back on the record. It's 3:58. Appearances are as they were before. Jury is coming into the courtroom.
Subject matter jurisdiction.
Your request, as I understand it, is noted. The objection is noted. It's overruled. We'll continue with the questioning of a witness. You may call your next witness as soon as all the jurors get in the jury box. All right, thank you. Please be seated. Go ahead, sir. You may call your next witness.
Defense calls Heather R. Reamer.
Thank you. Good afternoon, ma'am. If you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand. It is up a riser. Be mindful of that. And then my clerk, Teresa.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, ma'am. Please have a seat. The first thing I will ask you to do is to state your first and last names for the record and then spell each.
Heather Reamer, Heather Riemer.
Thank you. Go ahead, sir, your witness.
Good afternoon, Ms. Reamer. How are you feeling today?
I'm okay.
I want to direct your attention to the evening of November 21st of 2021. Do you recall what you were doing that evening?
I was at the Waukesha Christmas parade.
And do you recall who you were with at the parade?
I was with my husband and 3 friends and one of their children.
About what time, if you recall, did you and your family arrive?
Right before it started, we were running late, and then by the time we got to where we were seated, it was right before it started. I don't recall exact time.
Do you recall where you and your family were positioned along the parade route that evening?
At the time, I don't remember, but I later found out that it was the Historical Society.
What do you recall weather-wise that evening? Was it a pretty chilly evening?
Yes.
If you recall?
Yes.
Pretty windy?
Yes.
So I'm assuming at some point you observed a bit of commotion. Would that be fair to say?
Yes.
And do you recall what that commotion was?
Everyone running around was the biggest commotion.
At that point, did the area you were positioned in get pretty loud, chaotic?
Yeah, screaming gets loud.
Do you remember what you and your family were doing directly prior to the parade that evening?
I don't recall.
At the point you observed this commotion, what did you do from that point?
started running.
I'm assuming with you and your family all took the same course of action.
We all ran, yes.
And where did you run to?
Away from the parade route. I'm not familiar with streets. I'm thinking it's East Avenue. We ran down that road.
Would that be a side street connected to the main parade route? Or,
Yes, it was a perpendicular road.
do you recall if that side street was barricaded in any way?
I don't recall.
Do you recall if there were any law enforcement officers stationed at that side street?
I don't recall.
Did you, at any time during the commotion when you and your family were at the parade, do you recall seeing anything that drew your attention in any way?
Yes,
And do you recall what that was that you saw?
a red Ford SUV driving through faster than all the other cars in the parade.
And what did you observe this vehicle doing at the time that it caught your attention?
It was honking. Well, I heard honking. I'm not positive if it was the red SUV or another car alerting.
Did you notice any other vehicles around the vehicle you saw, following the vehicle you saw?
Following, no. It passed a float that had a vehicle in the parade. So it was by another vehicle, yes.
And it was passing the other vehicle you're referring
Yes.
to, correct? And you stated a reference to honking. In your opinion, strictly your opinion, why would a vehicle honk its horn?
To alert somebody.
No dice. No dice. My key fob remains missing.
I'm assuming at some point the vehicle passed the position where you were. Would that be fair to say?
Yes.
At any time during the vehicle's passing you, did you see who was driving the vehicle?
No.
Did you notice if they were intense to the vehicle as far as windows?
Yeah, can you speak up a bit?
Oh, I don't recall.
Thank you.
Yes, I'm sure this shop gave it to me back because I had to
Do
move
you
the
recall
car.
if you were able to see into
I had the key
vehicle?
in my hand.
I don't
Yes, I
recall.
had the key in my hand.
Do you
I had the key
recall
fob in
if
my hand. I opened the
you got a
door.
chance
I got in the
to
car. I started the car. I
catch the
drove
license
it.
plate number of the
I
vehicle?
fumbled the car. I
No, I
fumbled the
didn't.
key fob. It's in the car because the doors won't lock. The doors won't lock because the key
And
fob is in the car.
from your
The car can tell
recollection,
if the key fob is in
when
the
the
car.
vehicle
So when you
passed
press the
you,
button on the
were
door,
the windows up or down?
when you're outside the door, if you press the button on the door, right, there's a little button on the lock. There's a little button there
I
to
don't
lock
recall.
to lock the door. Right, but it won't lock if the key fob is in the car. Instead of going
And
beep or
did
beep
you at
beep
some
to
time
lock or unlock, it goes beep
report
beep 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 beep
what you
beep.
saw to law enforcement?
Tell you the
that
key
evening?
fob is still in the car. So the key fob is in
That
the car
evening, I did not know.
Did you at
because the
any
car
time
knows the car.
report what you had
The
saw
car
that
knows where
evening
the
to
key
law
fob is. Well, it knows it's in the
Yes.
car.
And do you recall what agency that law enforcement officer was from?
I don't recall. I'm going to assume Waukesha.
If I restart the car, I'll turn off, he'll reset. No, it won't. No, the car's smart enough to know if the key fob is, the car will start. The car will start.
During the course of reporting,
But the car knows if the key fob is in the car. It's smart enough to know the key fob's in the car.
A recorded interview, or were they writing down what you were telling them?
I was on the phone, so I don't know what they were doing.
Do you recall if that was in the days following the
Who am I talking to? I'm
incident, or
talking to the
a little
chat.
longer after that?
It was after the incident. I don't know how long after.
Side chatter about key fob is annoying. Well, Barbara, please leave my channel and unsubscribe. Thank you.
Upon arriving at the parade that evening with your family,
In fact, I'll help you out.
did you notice any of the side streets barricaded in any way? Any of them?
Yes.
Do you recall if there were law enforcement officers at those barricaded side streets?
I don't recall.
Bye, Barbara.
Do you recall about how long the parade had been ongoing before you saw this vehicle?
I don't recall.
And from that point, did you and your family immediately leave the parade and head home? Or?
We don't allow personal attacks.
We
Goodbye.
left, we didn't head home.
Argued enough. Goodbye.
Did you or any of your family members suffer any injuries during this incident?
No.
There's no law in place to protect people from victims like this? Not really. No, the Sixth Amendment gives everyone, the Sixth Amendment gives every person the right to confront the witnesses that accuse them. It gives the right to compel witnesses to appear. It's a guarantee in the Constitution.
Related to this incident?
Yes.
Yeah, I've looked. I have a cell phone. I have a flashlight on my cell phone.
Did you keep up with
Floorboard
those
wedged
reports,
inside
or
the seat.
was it
I've looked.
that evening?
I'm going to keep looking. Obviously.
Just a
Seat
couple
rail,
days
yeah.
within whatever was right immediately. I'm not a person to watch the news.
And after that initial phone conversation with law enforcement, did any more law enforcement officers follow up with you about the report?
No.
Did you yourself follow up with law enforcement after that
No.
initial report?
We can stop talking about the key now.
Did you yourself observe the vehicle that passed you during the parade? Did you yourself witness anyone injured by the vehicle?
I don't believe so.
That's all I have right now.
Thank you. Any cross?
Yes, briefly. Thank you, Your Honor. Good afternoon, Ms. Reamer. Thank you for being here today.
Yes.
I'd like you to take a look at the man seated to my right, table to your left. Mr. Brooks. You ever seen that man
Objection, I don't
before?
consent to being called that name.
Noted, overruled.
Yes.
Tell us about when you've seen Mr. Brooks before.
Objection, leading.
It's cross-exam, so it's proper. They may lead. You may answer.
As we were driving to the parade, we were coming to a stoplight and we saw the red SUV coming down the wrong way on the road, and I slowed down.
Can prosecution defense called
because
same
the car
witness?
in front of
Yes.
me started to back up.
They
to let
can.
him through.
This took place outside of a gas station, is that correct?
Yes.
Your Honor, I'd ask that we display for everybody exhibit number 7. It's previously been received and published.
Go ahead.
Objection to relevancy.
Exhibit 7 has previously been received. Overruled.
Is it relevant to this particular witness?
Yes, it is. Yes, go ahead and publish.
That's
Madam
not
Clerk.
how relevancy works. It's relevant. It's relevant.
Mr. Reamer, can you see the map depicted on the screen in front of you? We're looking at the intersection of North Street and Barstow Street. Does that look correct to you?
Yes.
And is this the gas station that we're talking about?
Correct.
And you were parked on North Street facing southwestbound at the time, is that right?
Objection, speculation.
Overruled. The witness may answer.
Is that the way of traffic? I don't know.
Well, let's
So-
assume, based on these arrows here,
Yep.
Objection, speculation.
Yep.
They're on the map. Overruled. Her answer was yes, and you may ask the next question.
Madam Clerk, can we please clear the annotations? And you saw the red SUV that we've been talking about come the wrong way on North Street, is that right?
Is there minimum time to post messages? I think
And
it's 10
what happened
seconds or
after that?
15 seconds, something like that.
Should I draw?
Sure, yep, that's a touchscreen, go for it.
So I stopped roughly back here, as the car that was here started to reverse this way.
Okay, can we please, let's get a screen grab of this, please, Your Honor, and mark it as Exhibit 7.
It'll be C as in cat. Or Charlie.
C, Charlie, please.
It will be so marked. And just for the record, the green line was placed by Attorney Wichow from, as you're looking at the exhibit, left to right to demonstrate travel of a vehicle in his question. And then the witness put the yellow mark on the screen, and it will be received as 7C as in Charlie.
I'm going to try moving the car. Like,
To relevancy.
I'll try moving the car and like maybe I'll try like going up to 30 miles an hour and
You saw
like
Darrell
slamming on the
Brooks
brakes or
driving that
something and
SUV
see if
in front of that gas station, is that
see if
correct?
that dislodges the
Objection,
key.
I
At that
don't
time, I
consent
didn't
to being
know.
called that name, and it's speculative.
Overruled, you may answer.
At that time, I didn't know his name, but yes.
That's probably the next
Now, you
step is
see
I'll
him
probably
sitting
just
here today?
Yes.
That's the guy.
probably drive it.
Objection.
Yeah, just take it up to take it over to a space.
The
There's a
record
space near me where I can do that. There's a
Identification
space near
as
me where I can do that safely.
defendant as the driver of the red SUV she saw is depicted in this exhibit.
Thank you. May we please
So take it
display
up
for
to like 60
everybody
miles an
exhibit
hour, just
number
slam on the
15,
brakes.
Which has also previously been received and published.
Go ahead.
Can we zoom in, please, on the intersection of Main Street and
I've run my hands between the
Northeast
seat and
Avenue?
center console.
Objection,
Yes.
relevancy.
I presume the question will provide the relevance.
How much are fobs?
Go
They're fairly
ahead.
expensive, but that's not the problem.
Thank
The
you.
problem is that it's in the car, and as
You
long
were
as it's
sitting
in the
front
car,
of
the car can be
Historical
started.
Society, you
And that's not
testified?
great.
Yes.
And do you recognize this map in front of you?
Objection, speculative.
Overruled, the witness may answer.
No, I don't.
Okay. Would the Historical Society be near this intersection that I'm circling, East and Main?
Yes.
Okay, we can please remove that annotation, Madam Clerk. When you saw the red SUV drive by, you testified you could not see the driver, correct?
Correct.
Because it was going so fast?
Yes.
Did you ever see that SUV come to a stop at any point on Main Street?
No.
In fact, did
As
you
long as
see
it's
it
in the car, you can run
accelerate
battery down.
as it traveled towards
No,
you?
it won't have any impact on the battery.
Speculative.
It says, overruled, the witness may answer.
Sound
Yes.
like you was going to say some stuff.
And then I remembered you had called the witness, not the state. So cross-examination is appropriate. Fair enough, though. Next question.
Did we get an answer on that?
I said yes.
Okay, thank you. That's all I have.
Redirect, sir.
Yes.
Do you want any of the exhibits up?
It's.
I forgot what the one.
I know where the
was.
shop put the key. They put the key in
7
the
was
hands of the manager of the building I
near
live
the
at.
gas station. This is 15.
That's not where it's
I'm gonna
now.
Turn it off until you tell me you need something.
I'm not
the,
explaining the problem adequately, I guess. So I'm just going to stop talking about it.
Put that up and we'll publish it for the jury as well.
And when shown this exhibit on cross, you stated you were approximately around. As a matter of fact, that wouldn't be fair. Can you erase that that mark, please?
It's
were
clear.
Were you show again where your vehicle was positioned?
It's just a rough estimate, but
Okay.
probably right out here.
And where we?
That's when I initially slowed down.
Okay. And you stated there was another car that did a backing up motion. Can you show again where that vehicle was positioned?
If they were at the light going this way, backing up.
If you recall, or do you recall, if there were any vehicles in this space right here?
There was none.
Rough estimate, about how far would you estimate the distance is between your vehicle and the vehicle that was at the light? Rough estimate.
I never came to a complete stop back there. It's when I started to slow down.
So you were still kind of rolling forward a little bit?
Yes. Because they backed up and then moved forward. And so then I moved forward.
So you didn't come to a stop until you noticed that vehicle backing up?
No, I didn't come to a complete stop until we were back up at the light. I started to slow down at that point.
So where did you end up? I'm sorry, can you erase the white circle?
I can erase all of it or none of it?
The white circle.
Only, I think it's just all or nothing.
Oh, all. I'm sorry. So let's start this again. Where did you finally come to a complete stop at, if you recall? And at that time, well, back up a little bit before I get to that. You observed an SUV, you say, at some point before you came to a complete stop?
Yes.
And what did you see that vehicle do?
This way.
What did you see it do after you noticed that it was coming in that direction?
Turn in here.
Would that be into the gas station?
Yes.
And what did you see the vehicle do at that point?
Roll down their window and yell something at the car in front of me.
Did it stop?
Yes.
Was it? I'm assuming you might know what I mean by this. Was it like a brake stop or was it a park stop? If you recall.
If you're not in the vehicle, how do you know that they put it in park?
Good point.
Well, brake stop would be brake lights, but okay.
You could be neutral, not in park.
Grant that, strike the last statement made by the defendant, but you may ask your next question.
And how long were you at the light?
Just a very short time. It turned green pretty quickly.
And in that short time, you were able to see who was driving the vehicle, the SUV, as you say, that went into the gas station.
Yes.
Is that the same SUV you saw at the parade that evening?
Yes.
The same vehicle that you said you don't recall if it was tinted or not?
Yes.
So at the point of seeing this vehicle at the gas station, at that point, did you notice any tints?
I don't recall.
Did you notice if there was anyone else in the vehicle at that time?
I only saw one person.
Could you see into the back of the vehicle?
I don't recall.
Can you see the passenger seat of the vehicle?
Yes.
Was anybody in the passenger seat?
No.
But you don't know for sure about the back seat.
No, I couldn't see it.
Can we take down this exhibit 7?
Go ahead.
Can you pull up exhibit 15? Can we pull that back up?
The state would please pull that up. We'll publish that for everyone.
And
hold on, let's make sure the jury has it.
Oh, I'm sorry.
Okay, thank you. No problem. Go ahead.
And you stated that you were in front of the Historical Society.
Correct.
And if I recall, you can correct me if I'm wrong, that would be somewhere around this area here.
Yes.
So
Can
was
we,
that a yes?
Yes.
Okay, thank
Can
you.
we erase that white? So the side streets, I'm sorry, I didn't mean to tap the screen. Can you erase that? I'm sorry. The side streets would be Buckley Street and Northeast Avenue. Would that be fair to say by looking at the map?
Yes, that's what the map says.
Excuse me.
And you said you don't recall if those side streets were barricaded.
I wasn't at the intersection. The
You were-
Historical Society is at that intersection, but I was in front of the Historical Society.
So would it be fair to say you were close to the side street?
I was close, but not at it, so I don't know if there was barricades there. I wasn't close enough to see to be by barricades.
So you stated you ran away from the commotion. So it would be fair to say at some point you moved from your position in front of the Historical Society, correct?
Correct.
And do you recall what side street you went down to when you were running?
We ran up to the building of the Historical Society on the side of East Avenue.
We can, what, just really quick. So that would be this side street here.
Yes.
We could take down exhibit, is it 15? And you stated that you knew the identification of the driver of this SUV based on what you observed at the gas station, correct?
Can you repeat that?
You stated that you, let me back up. You were able to identify the driver of this SUV based on what you observed at the gas station, correct?
The gas station, I saw the driver, yes.
Do you recall what the driver was wearing when you observed him at the gas station?
At the gas station, no.
Do you yourself recall in your telephone conversation with law enforcement stating that the driver was wearing a red-orange shirt?
That was not from the gas station.
So where would that description come from, if not the gas station?
I saw video footage of you in somebody's backyard.
So what did you observe the driver of the vehicle wearing at the gas station?
I don't recall.
So it'd be fair to say that in your phone conversation with law enforcement, you gave a description based on what you had seen from footage. I guess that would be the right word to use.
The shirt color, but your description was from the face was from the gas station.
And do you recall in that phone interview stating that you weren't positive on the shirt color?
Yes.
Do you recall in that phone interview stating that since seeing the news,
Emmanuel, don't ask logical questions.
that you
Just
may be
breaks your
getting the
brain.
clothing description incorrect?
I remember saying that I've seen the news. I don't remember saying that that is why I'm getting it. It wasn't the same as when you were driving.
So would it be fair to say that your description came from watching footage at some point and from news reports at some point?
Not news reports.
But you did see this incident reported on the news.
Yes.
Did you see where the vehicle went when it passed your position?
Objection, can we just clarify whether that's at the gas station or the parade?
Fair enough. Sustained.
Sorry for that, I'll clarify.
Thank you.
Do you recall seeing where the vehicle went when it passed your position at the parade that evening?
Continued down the parade route.
And you already stated that during the parade, seeing the vehicle and not seeing the driver, how are you sure that that driver of the vehicle you saw at the gas station was the same vehicle at the parade?
I know that they were both red SUVs, Ford SUVs.
Were you yourself sure that they were the same vehicle?
They were the same model, same color, same make.
So what is the make and model, if you recall, of the vehicle that you saw at the gas station?
Ford Escape.
And how did you come to that determination based on your observation at the gas station?
Because I know a decent amount of cars.
It works.
you mean by decent?
I mean, I don't know all makes, but I know this one for sure because I had a friend that had the same exact make and model,
They'll do it.
just different color.
So are you yourself able to just look at a vehicle and tell the make and model?
Sometimes.
So it'd be fair to say some, not all.
Correct.
So that brings me back to the driver. You stated you didn't see the driver of the vehicle you saw at the parade. How do you know there was the same driver?
Objection. The state's the evidence. She never justified that she knows it's the same driver.
Sustained.
I'm asking how did you,
Rephrase your question, please.
do you know if it was the same driver?
No.
No further questions?
I thank you. You may step down. And you are excused from your subpoena. It is 4:34, so we will end for the day. And I will read my instructions to the jury once again. Do not begin your deliberations and discussion of the case until all the evidence is presented, and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging, or social networking sites to send or receive any information about this case or your experience as a juror. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capabilities to send any information about this case. For example, do not communicate by telephone, blog post, email message, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is
I've heard the
improper
evidence.
for them
I'm good.
to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial.
For sure, I'll
throughout the
do a
trial.
video on
If
Hosnima's
any juror has
defamation
any
lawsuit.
reason to believe that another
I
juror
told
has
you guys,
violated
I thought
these
there were some
rules,
strong
you should
possibilities of
report that
defamation. It
to
doesn't
me.
surprise me
If
at all.
jurors do not comply with these rules, it could
I'll
result
definitely be
in a
covering
new
that.
trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, we'll see you all tomorrow morning. We'll begin at 8:30. All rise for the jury.
All right, that's going to wrap it up for us today. Well, we didn't get quite the fireworks show that I thought we would today. So I don't know whether or not I'll be streaming this tomorrow. You can leave me comments about whether or not you want me to stream this more, but I don't know whether or not I will or not. But, you know, we didn't get quite the little shit show that I thought we would. We got 2 witnesses down. He says he's got, what, 12 of them? So we'll probably be wrapping up here on this trial around Wednesday or Thursday. We'll be wrapping this up before next week. So I think within a week we'll be wrapping this up for sure. Closing arguments, give it to the jury. The jury's going to take about 5 seconds, convict them on everything, and then we'll have sentencing in like a month or 2 or whatever it is by law. So yeah, he's going to lose it before too long. Yeah, we'll see. So we'll see. So I'm going to continue my quest to search for my car fob. But yeah, I'll just acknowledge the super chats that I marked and hope that I got them all. Chris said for 999, what's not going to get him any sympathies and trying to make himself a victim of his own choices and actions? A killer trying to highlight himself in the same light as victims won't change mine. Yeah, I mean, whatever sympathy I have is not enough to change my analysis of the facts. All right. I don't have any doubt as to the facts anymore. So as to the elements of the crime, I don't have any reasonable doubt. Ewan Stealthfoot said, is there some reason behind delaying as much as possible? No. Just being a jackass. Also, thanks for what you're doing, Kurt. You're a godsend of legal explanation. Thank you. Zachary Jarvey gives $10 to say this guy is pissed at DB, not just because DB is a piece of shit, but also because he hired an attorney to prep. Remember, he makes a living as temp worker. I don't know if he hired an attorney or not. He's just answering the questions honestly, and it's really no more complicated than that. Just answer the questions honestly and, you know, let the truth be your guide, man. It's fine. Michael Flanagan gave $5. I haven't watched the full case, but isn't he effectively introducing more evidence for domestic abuse charge? He's not helping himself in a lot of ways. Unindicted co-counsel gave $10. Say, I'm somewhat hoping that this gets appealed extensively. So provide us something akin to Meads versus Meads, a clinical on how to take down so sit BS. And no, probably not this case. I wouldn't, not me. If it's court appeals, it's just judgment affirmed and called a day. Stave Wisconsin gave $5 to say, gotta get some rest for work tonight. I'll catch the rest later. Thank you, Stave Wisconsin. Polly Prissy Plant says, I'm here for the music and dancing. The lost incidental. Excellent. Kathleen says, maybe if Nicholas got to Brooks, the parade incident would not have happened. Avery Johnson gave $5 to say his proximity doesn't specifically need to be inside. Drive and stop the car. The key is near where the car was parked, but outside. That's not how my car works, but thank you for the super chat. VT Warrington Man said $5. Isn't Cross going beyond the scope of direct? I don't know. And Kathleen says, if he testifies, doesn't he have to state his name? Probably. So all those good things are happening. So, yeah. Fob, oh fob, where art thou be? Yeah, so I'm going to continue my quest for the fob and stuff like that. So, yeah. Please stream in more soundboard? Maybe. We'll see. So I'm going to sign off for now as I continue my quest to find the key and stuff. And yeah. And then I will tend to other things. If you've enjoyed this stream, please remember defamation. Why? What was said? Dude, man. Really? Okay. If you've liked this stream, please remember to like it. Please remember to subscribe, do all the YouTube things. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.